to see if we have a resolution. If not, your client needs to turn himself in.
Well, Judge, I mean, we're here right now. Can we, I mean, we all know what we're talking about. Is there any way we can just have maybe a bond reduction hearing right now, or I don't know how you want to handle this?
Well, you know, were there other violations, Ms. Pineda? Was he otherwise compliant with probation? I don't see a very, very long case summary.
Yes, Your Honor, I don't see any other issues reported by the probation officer summary.
But he allegedly violated, you know, 3 months into probation, right?
That is correct.
That's not good.
He has reported, Your Honor, he did complete his step counseling class. The only thing right now that he's lacking would be the community service hours and obviously the outstanding restitution balance that he has.
Has he paid anything on the restitution?
Yes, he has. He's paid. So he paid a ton of the money up front. I don't know if you remember that, Judge.
I don't, but I see here in the case summary that at least the last payment, and if I scroll back up, I'll probably see some. Oh, is that correct? He's paid $143,000.
That's correct, Judge.
And his last payment was on May 1st, 2023. That was $1,600.
I think he's court ordered to pay, Your Honor, a significant amount on a monthly basis, if I recall correctly.
Right. It says client is to pay $1,550 a month towards restitution, but I mean, that's no small thing. I know it's what he agreed to, but it is no small thing to remain compliant in that respect. He's pending community service. We've got a new case. Mr. Sutton, what do you think about that, KPS?
Your Honor, I mean, I don't have an issue with that being withdrawn, given his appearance here today.
Okay. Yeah, I'm actually good with that as well. All the cases are on track. You're hearing what the rec is, Mr. Ortiz, to adjudicate him on the new case, I mean, on both case to straight, and then place him on straight. I'm gonna leave the MTR open as is to carry along with the trial track on the one not really new, but other one really new case, and see where you all end up.
Thank you so much, Judge. Appreciate you.
Mr. Ortiz, make sure that your client is aware of how to check in for court, because he will still need to be compliant with his reporting to probation and for his hearings here, okay?
I'll talk to him right now, Judge.
Thank you very much. Mr. Sutton, anything else?
No, Your Honor, may I please be excused?
You may, as may Mr. Dennis. Mr. Ortiz, I don't know if you have anything else.
I just have another case, Judge. So I'll stand by.
Okay, thank you. Who's next?
Staying with Mr. Ortiz on page 11, Judge.
Mhm.
His client is logging in. In cause number 2014-0D01785, State of Texas versus Anthony Smith. Announcement of counsel, please.
Okay. David Vandenberg on behalf of the state.
And Ruben Ortiz by Mr. Smith.
Okay, Mr. Smith and Ms. Lerma, I couldn't hear you if you were talking.
Monica Lerma, dog probation.
There you are. Okay, and Mr. Smith is also appearing remotely here. Let me go ahead and get an update on Mr. Smith as I'm scrolling through this case summary.
So, Your Honor, I'm here for CSO Ramos. She had a family emergency, so she can't be here today. As per last hearing on April the 27th, the issues were that Mr. Smith had missed a couple of the SOTP meetings, one in February, one in March. Since then, I don't show any absences. However, he had a significant balance. He paid some of that off, but I got some new information. It may not be on the case summary because I just got it yesterday, that he has a $140 balance, and that is due to the June sessions that he attended. The balance was for previous balances, but now he has that. And I was notified also that he had been dropped from treatment for that reason.
I think that was Miss Lerma. Okay, sorry. All right, so now we have him dropped from treatment. Or is it Mr. Smith? Sorry about that. I think it was Mr. Smith. Okay. Okay, but he was attending, but he has an outstanding balance and that is the basis for him being dropped. And then on the financial end, sorry, Ms. Lerma, I think I muted you because I thought it was you with that background noise. The financial, I guess, probation was going to do a financial assessment, but that is incomplete. Is that right? Or have we completed that?
It's not complete, Your Honor, to my knowledge. My supervisor was looking over that, as a matter of fact, yesterday. So I don't think we have all of the information quite yet. I know that Mr. Smith was recently offered a position at a call center, so he may be starting that soon. That's pretty much it. I made him get a UA before court. He did that yesterday and that was clean. Just, you know, the lack of assignments that he's not doing in treatment, Your Honor. I think he went 2 months with one assignment, no assignments in June. But he
So
spent April and May on one assignment.
Mr. Emily, help me understand. So he's attending treatment, but he's not doing the work? I'm not understanding because I hear he's attending, so that's a good thing. And the only problem is the financial angle. But now you're telling me he's not doing the, I guess, the homework or whatever it is that they're supposed to do there.
You know, sometimes, because depending on the class size, it takes them a while to get to him because each person presents an assignment. But it looks to me, based on the progress reports, that he's been working on one particular assignment in April and May and nothing else. So nothing else has been presented or completed.
Is that, does that happen? I mean, is it something that it happens when you're in that type of treatment and working on assignments? Is it maybe something unique to the assignment that, you know, what I want to know, is it something that it's difficult and treatment is working with him on completing the assignment, or is he blowing it off?
What I see here is that he's not completing the assignments. That's what I'm reading from the notes.
So Judge, I don't think that's quite accurate, Judge. I think that the issue, Judge, if you recall, and I'm just gonna, I don't mean to jump in, Judge, but the last time I was in this hearing, the issues, I don't know if you recall, was him not having any money. He was having issues with him being indigent, Judge. He was having issues getting a job. That's the issues, really, Judge. Not that he doesn't want it. You know, if the classes were for free, Judge, there'd be no issues. You know, but unfortunately, you know, some of these clients that have these type of cases, it's really hard for them to find work. You know, it's really hard for them to be employed.
I totally get that angle. What I don't know is why he's not completing his assignments for 2 months.
I don't know if that's the case, Judge.
Mr. Smith keeps raising his hand, Mr. Ortiz.
That's fine. He can explain. Yeah, Judge, I have all the faith in the world. He knows how to.
Thank you,
explain
Mr.
himself.
Smith. If you'll unmute, but please, you have some background noise there.
Yes, Judge, I do apologize for that. Yes, ma'am. So I have been doing my assignments. The only issue is I've had an issue with the assignment that I'm on, and Ms. Regalado's been helping me through it. And then it's hard for me to, like you were mentioning, when we're in the treatments themselves, so many people have assignments. I know from the last time that we were there, we started off with, I believe, 3 or 4 different people presenting from the last class from last week on Tuesday that didn't get to present. And then there were still people left over this week that didn't get a chance to present as well. But I have been doing my assignments, so I'm not sure why it's showing that I'm not doing them.
So I'm going to ask a couple of things here, Ms. Lerma. Is anything there that he is saying not your experience with how treatment happens? I mean, that doesn't make sense. That would be knocked for not turning in something when I guess he's not being called on or asked to submit it. I don't know why those wouldn't be submitted anyways.
And what he said about some assignments are difficult and it takes some 1 or 2 sessions to kind of get through them. there are several people in the groups, so she goes around, everybody who has an assignment to present, they present, giving everybody the opportunity, but sometimes time runs out, and she puts them at the top of the list for the following week.
And what can we do in terms of the financial? I don't know if this is a situation, I know it, and I'm not asking for probation to do this, but in other, especially when we did this review of these older cases, that probation was able to assist with either, I don't want him kicked out of treatment if he's participating in treatment and the issue is solely financial. So I want to make sure I know that the issue is solely financial, that he is getting kicked out, not for lack of participation.
I believe that is the only reason at this point, Your Honor, but can I also add that he went to go see the Spider-Man movie. And he didn't have permission to do that. That is, they need to ask for permission to do that because it's geared toward children. It is an animated movie. And the probation officer did not know. He did not mention it to her. We found out after the fact.
Are there any other issues? Any other violations?
No, I don't have any now.
So what can we do in terms of the financial issue?
We are working to see if he qualifies, Your Honor. Like I said, my supervisors, they're waiting on more information, and as soon as they get it, we will get we'll find out how much subsidy he will receive.
Okay, how soon is that going to be done? I don't want him out of treatment. That's my problem.
Yes, ma'am. Well, I just got the report yesterday, so I'm gonna talk to my supervisor today and see where we're at and what else we need.
Mr. Smith, you have the responsibility to make sure when probation is extending a request to, assess your financial need, that you help them expedite that as soon as possible. So if you're the holdup, then you're the problem and you're the reason you're kicked out. I'm not insensitive to financial, that's for sure. And I'm going to order that he remain in treatment and review that. But I also want to see, make sure that Mr. Smith understands when you're talking about going to an animated movie at a movie theater, that he is reminded of the conditions of the things that you can't do, Mr. Smith, or for which you have to ask permission. So I don't know what other things, he does regularly, interests he has. Maybe you all can have a conversation with him to see where things that might seem to him permissible, probation may not. So we want to make sure he's informed.
Yes, ma'am.
In terms of his progress, I'm okay with it. I'm okay with what he's doing, but I don't want him if he's blowing off, turning in assignments. I want to know that for sure. He's attending, so I'm tending not to think that. We'll just check his status in 60 days. When does he term?
He terms on January 28th of 2025.
Yeah, we still have time. Okay, so we'll come back in 60 days. Certainly, Ms. Lerma, you can let Ms. Ramos know that we don't have to wait if we have an issue. But as long as he's still attending, get your assignments turned in. I mean, there's really not a whole lot more other than the financial that I'm displeased with. I just don't want to hear any other issues, Mr. Smith. I just want you to know what you have to do and do it. And, they've made a recommendation here that if you have issues with employment, they have a referral for you to Borderplex Jobs Program to obtain employment. How many hours do you work a week?
Right now, I'm paid bi-weekly. I work part-time at a gas station. I make about 181 in a bi-weekly check.
Yeah, if you're only working part-time, I mean, you got time.
Yes, ma'am.
If you're only part-time, you haven't, they've gotten on you about community service. You haven't done that. I think, you're saying you're going to do some more. You got time. I don't know, what's going on here. Get to work.
Yes, ma'am.
All right, Mr. Ortiz, I'm gonna do one more review in 60 days and see if we can, these last hurdles, we can overcome them with a little more attention. And hopefully I don't have to come back anymore on this.
That'd be great, Judge. We can resolve this matter.
Thank you for your time.
Thank you,
Thank you,
Judge.
Ms.
Abby.
Lerma. You may, as may Mr. Smith.
And Judge, and Probation Department, Ms. Lerma, if there's any issues or anything, if I could help out prior to the 60 days, please reach out to me. And I'll be more than happy to reach out to my client and get this thing moving quicker than and sooner than us having to show up to court and having the judge kind of interfere when she can be doing other things.
Great, great.
Thank
We'll-
you.
we'll do that.
Thanks,
Thank
Mr.
you.
Ortiz. Thanks, Mr.
You're welcome, Judge.
Take care, guys.
A lot of
Have
work
a
that I
good
know you
Thank
do.
you.
All right.
Bye-bye.
Thank you, Judge.
Judge, I think he meant intervene, not interfere. Come on.
I didn't
Ruben.
even hear the word. I just appreciated the little, hey, let me help you out.
It was intervention, not interference. Oh, my God.
Ándale pues. Who's next? Thanks.
English is my second language, Mr. Mena.
On page 4, Judge,
Uh-huh.
in cause number 2021-0D03031 and 2020-0D05479 and 2023-0D00383, State of Texas versus Ernest Gomez. Announcement of council, please.
David Vandenberg on behalf of the state.
Greg Anderson on behalf of Mr. Gomez, ready to proceed, Your Honor.
Where's Mr. Gomez? Is he here?
Judge, that's my fault. I think my office told him to log in on Monday, which I believe he did. But that he didn't have to do it today. We are reaching out to him right now and asking him to log in, but I think we misrepresented to him that he did not have to log in today.
And he did check in, Mr. Marufo?
Correct, Judge, he did.
Okay. So we've got 2 probation cases and a new case. What are we doing on the new case?
For a rec,
Mhm.
the new case. Let me look that up. I have the status conference. Is that what you're referring to? On
Yes, 383.
yeah, that's for TDC.
Judge, if you were, my recollection on the case, I think we had this conversation maybe a month ago, was that when you issued a capias, we came to you on a bond on his probation revocations. You basically made the decision to give him jail therapy for the probation revocations. And he basically, in essence, sat in jail over the holidays and I think turned himself in to do jail time as condition of probation. And
Right.
I thought in that case, we took care of the probations. And then we were just going to wait till the new case came in. And so here we are, the new case is here. Mr. Vandenberg, I think probably this is the case we should talk about, maybe look to running the new case concurrent with the probations. That's at least my hope and recommendation. I don't think he's going to be willing to plead to flat out pin time when he's currently on probation.
Do we have any motions still active on the probation cases?
Your Honor, if I may,
Yes.
the motion was actually just filed on 6/21/23.
Judge, I think the conversation we had with the former prosecutor at the time was that we kind of took care of the motion to revoke at that bond hearing and doing the jail therapy. I think that was a conversation we had, although obviously.
That's what it looks like to me from the case summary. So let me go back and look at that motion.
Your Honor,
Mande.
apologize to interrupt. I am trying to double check, but what Mr. Anderson is referring to back in December, the time,
Mhm.
and that's, I'm sorry, I'm waiting for Odyssey to load up, but I believe those were his ACOP days that were ordered for his 2 different DWI probation cases.
Mhm.
And my notes from the last 2 court hearings have been one on 4/11/23 That hearing, ADA Vance was present and we were pending the assault charge, but
Mhm.
we're waiting on Mr. Anderson to provide a non-prosecution statement. We're waiting on that. And then fast forward to the last hearing on May 23rd of 23. That one, Ms. Elizalde, Lady Elizalde was on, and she stated that the MTR was pending to be filed since there was still an active assault case.
And that does refresh my memory on it. I did submit an affidavit of non-prosecution to the DA's office on several occasions, actually. It was submitted at the time of the bond hearing. The complainant actually was insistent in coming in to see me. I didn't even reach out to her before the bond hearing. She came in, I did an affidavit non-pros, I sent it to the DA's office. We discussed that, I think, at the hearing for the bond. At the last hearing, I emailed again the affidavit of non-prosecution to the assistant DA. I don't know if she's received it or not, but I have sent it on several occasions, and I'll be more than happy to send another copy to you, Mr. Danberg.
That would be good.
I think the complainant stated that she actually put in the affidavit when she met with me that she felt like she exaggerated the claims. I told her she needed to be very careful about what she stated because it could result in problems for her. But she felt as though she got extremely emotional about it, probably exaggerated things to the police. And I'm pretty certain she put that in the affidavit and signed it. I'm pretty certain that's what she would state. At the last hearing, the assistant DA said, well, there's a video of it. Basically, with the video, it does not show what happened as they were walking down the stairs. But in essence, what the allegations are that is they were walking down the stairs while the complainant was basically chastising the defendant to get out of her house because they were having a spat. He turned with the goods that he had in his hands, maybe made contact with her with his elbow, or maybe didn't. But in any event, she got very emotional about it, and she thought that she exaggerated the claims when she talked to the police officer at the scene. That's her story.
Okay, I did go back up on the case summary, Carla, and I think that does conform. He did receive the 30 days, but if I'm reviewing it anew, since my memory is not great and not necessarily taking everybody at their word, I'm comfortable with that. In other words, I'm comfortable. The recommendation from probation is to modify him to BIP. That's what's on the case summary. And if I'm not mistaken, we already modified him, right? Because we had the new assault case. I'm looking at his compliance otherwise. On the monitor, I only saw a report of one window. I'm sorry, yeah, about a month's worth, right? So let me go back. We're talking about May 7th to June 7th. He had 3 skip tests, which for me, Mr. Gomez, are violations. I don't want you skipping, missing, testing positive, doing any of that stuff when you're on the monitor, because you're on for 2. You're on for 2 DWI thirds. Jasmine, are you able? You're not driving, right? Mr. Gomez?
No, ma'am.
The recommendation here is, yeah, he'd be modified to participate in BIP. He's already modified, right, Carla? I thought I saw a modification in Odyssey on
Modification, Your Honor, was
no offensive contact. I see
correct.
that one. I thought I saw BIP.
I don't think we discussed the judge, but certainly some family violence counseling would probably be in order.
Okay. The most recent mod says no offensive. Okay. For my purposes, there's nothing else on the MTR other than the new offense. So I'm going to go ahead and for the probation case, modify him to participate in BIP class. Mr. Gomez, your attorney will go over with you. It's a long-term family violence class. So it goes over many weeks. It costs a little bit of money. So once you're enrolled, and he'll have for 30 days to register. Don't get kicked out because they kick you out and you have to start from scratch. I don't know what's going to happen on the AFV, but I think this case is tracking the assault family violence case, the 2023 case. You heard the rec, it's for TDC. So you all can go from there. So let's go ahead and for me, I'm going to have that motion dismissed, modified to BIP, to continue on probation, to include that new no offensive contact, and then he's to remain compliant with the monitor for sure.
Judge, I think there's 2 BIPs. Are you okay if, and I may be wrong about that. I think there's a shorter and a longer BIP. Are you okay at least starting with the shorter BIP, if there is such a thing?
If it's called BIP, I'm not seeing any distinction on this recommendation. If it's a shorter BIP, the longer BIP, medium BIP, he just needs to take BIP.
All right. I'll
Okay,
discuss that with him. Marilyn.
all right.
And Mr. Vandenberg, I'll send another copy of the affidavit on false.
Good, thank you. I don't see it in our record.
How many prior family violence convictions does he have, Mr. Vandenberg?
Let's see. He has no prior convictions for assault family violence. He does have the DWIs.
Well, he has to have a prior because it's an assault family violence with a prior.
It's an ag assault with a deadly weapon he has.
Any other arrests for family violence?
No, Your Honor. Arrests. Let's see about that. I'd have to go through the rap sheet. This
I'll look it up. So we'll go ahead and I need a dismissal on the motion. A dismissal on the motion, and yes, if you'll get me an order recalling the KPS, Jasmine, please. All righty.
Thank you,
Anything
Judge.
else? You got it. Thank you very much.
Well, Ms. Gomez, I'll give you a call.
Who's next?
Yes, sir. Thank you. Thank you.
Bottom of page 10, Judge,
Mhm.
in cause number,
You can log off.
in cause number 2021-0D0-0743 and 2020-0D0-6119, State of Texas versus Kayla Mendiola. Announcement of council, please.
David Vandenberg on behalf of the state.
Good afternoon. Good morning, Judge Jesus Soleos on behalf of Ms. Mendiola.
What are we doing on Miss Mendiola? She's in custody.
I spoke to her, Judge, and the jail did go and talk to her with regards to her mental issues.
Mhm.
I don't know if they reported back to you in any way, shape, or form, but in talking to her, Judge, basically she wants out. She's promised me that she will attend outpatient services with EHN. I got every reason to believe that that'll be the case. During her time, there were no dirty UAs and she was in full compliant. Once she got notice of the new case, she kind of freaked, and that kind of threw her off balance and into this issues. So I'm asking this court to go ahead and let her out and give her like one last opportunity to prove herself. And I think we'll be okay. And that's basically where we are.
Mhm. So if I remember, Miss Mendiola will go okay, right? When she's got meds, treatment, and then the problem is, like out of the blue, she just takes off on us, and she
Yeah, she
starts
reported to me-
using, and you know.
Yes. She reported to me that once she got notice about her being possibly picked up again and rearrested, she just has problems with coping skills. She freaked out and yeah, she disappeared. You're right. But prior to her, if you look at her record, she's pretty much in compliance. Probably pretty sure Mrs. Pineda can attest to that.
How many times has she gone off track while she's on probation? I remember one for sure, but I don't want to assume it's been a bunch.
I do not know, Judge, to be honest.
Let me ask Carla. Carla, How many times have we lost track of Miss Mendiola? How many let me go back. How many motions have we had on?
She is muted, Judge. I can't hear you, Carla.
Oh, yeah, I wasn't looking. Thanks.
Sorry. I apologize. I'm trying to I want to confirm. I don't want to speak thinking of a different case.
Mhm.
I want to say that she had stopped reporting for a while, like 2 years ago. And then the MTR was dismissed. And then we let her out to report, and then she picks up these new offenses, and then again, she stopped reporting when.
The recommendation is to Kumi that probation department recommends that Ms. Mendiola's term be extended, the number of months she has absconded, and be modified to the MHI caseload. I mean, was she not already?
No, Your Honor. Because when she would be released and she would be referred to attend an appointments,
Mhm.
she wouldn't, she stopped going. So she was released from there. And at
And
one
is she-
point, she didn't qualify for the MHI. But according to this last update, if you see on the summary, there's a little confidential area there.
Yeah. I see.
And I mean, just reading that, it seems like she is going to qualify for Tercomi, which will allow her to qualify for the mental health caseload through probation.
What amount of time are we talking about extending her? She's on for 8 years.
We still have her through 2029.
I don't need to extend her. Mr. Vandenberg, do you have any input here?
No, I agree with Ms. Pineda, but the state would request a safe P program for her.
Does Safe P address mental health, Carla? I mean, I know there's, I think fentanyl method, something that she's using, but I think the crux of her issue is the mental health angle.
What she would go under, Your Honor, would be the safety with special needs. And it would just be not necessarily to address mental health, but, to have her under special needs for medication if it's needed. But safety is mostly substance abuse counseling.
But they will address her mental health needs. If
They'll
she's,
also keep her to date with medication, but no mental health treatment.
I'm afraid that will just kind of freak her out again, Judge. And then she'll be surrounded by, I hate to classify them as such, but tougher criminals are more involved into drugs and other issues. And I think we're just exposing her to probably more pitfalls.
my concern is how easily we can lose her, even when she has treatment. You know what I mean? Even when we're looking at, and I guess we weren't looking at the mental health before, right, Carla? Is that right?
That's correct.
Okay. All right.
Your Honor, and I apologize, but I don't think I was referring to the correct client. I don't think I see another MTR filed.
Yeah, I just see one, too. Well, Jasmine's giving me all the scoop in the chat here. She's telling me about Safe P. Safe P has a special needs program, that they have therapy sessions, but if we weren't there before, right? If we weren't there before, then I'll go with that recommendation. I hear you, Mr. Vandenberg. I was at Safe P, but we've never addressed the mental health angle while she's been on probation. So let's modify her to the MHI caseload. We already have her for a good chunk of time. So what other recommendations were there? I mean, is modifying to MHI caseload sufficient to address that? Just means green light to address any mental health concerns and any treatment that comes from that?
Yes, Your Honor, that would just be for her to be participating and ensuring that she participates.
Part of the issues, Mr. Olivas, I think, and I gotta remember, I don't know if her home, if she's stable, like if she has a place to live, all of those things I think are outstanding. Was she with parents, Carla? Do you remember? Or Mr. Olivas, go ahead.
From what I gather, Judge, she does have family support from her mom and whatnot, but then her mental health issues prop up. And the family is not really educated enough or prepared enough to be able to cope with her issues. So they really are at a loss when she
starts to go off track. Okay, so before we do that, I want to get either I guess it's through probation to, we need to have a plan. We need to know where she's gonna live. I want to know what her appointments are gonna be. I want to make sure they know what meds, what counseling, all of those things. I want to know. The primary thing I'm concerned about is she gonna have a place where she's stable?
Yeah, as long as she's taking her meds, she's doing good and she's more than welcome from to the homeless, from what I understand.
I want probation to confirm that, please. I want probation to reach out to, if she was staying with parents before, reach out to the family. Want to make sure we have her somewhere where it is understood she's going to be going through a regimen of treatment to address the mental health needs now, but that she's somewhere stable. I'm not, if she doesn't, you know, we're talking about something like opportunity center or something like that. I don't know. Okay.
Your Honor, may I throw something?
Mm-hmm.
And I don't know if Mr. Olivas
Gonna get mad at you?
talked about this in the past, but I know I have some kind of notation where I believe one of the last hearings, we were trying to see what about SafeP or BHRTC. Mr. Olivas, did you get to talk to Ms. Mendiola if she's willing to participate in any? I mean, I'm just throwing it out there. Maybe a safer plan. She does have that substance abuse, which was, you know, noted through the counselor that saw her at the jail.
But I thought BHRTC didn't attend to the mental health angle.
They won't, Your Honor. It's mostly treatment. I guess my angle of what I was trying to say is BHRTC, since she's still in custody, she's obviously to stay clean, to help her. She's on medication right now. Once she gets released from BHRTC, she participates in outpatient. But at the same time, once she's done with outpatient, she can be modified to the mental health caseload.
Well, to answer your question and talking to her, because she's been on her meds, she feels that she's at the point when she could handle it and get back on track. And unfortunately, I know there's some concerns with regards to how long she'll be able to do that. But sorry, to answer your question, she feels that she can go back and handle it.
Okay. And if I may, Your Honor, Mr. Olivas, if you can, I don't know if you can email me or I can email you so that you can get with her assigned probation officer. I know there's no contact since she had stopped reporting. I don't see that there's any contact, and Your Honor is asking for a plan of an address and stuff, and it doesn't seem like probation has any of that information or who to contact her family regarding this.
What is your email address, Carla?
I'll put it on let me put it on the chat, okay?
Okay.
Let's go ahead and have her screen for BHRTC as well. Just to know and not have to wait.
Okay.
We're gonna come back in 30 days.
Yes, ma'am. May I be excused, Your Honor?
You may. Thank
Thank
you
you,
for
guys.
your
Have a good-
efforts. Thank you, Carla. Thank you,
Bye-bye.
Jasmine. Who's next? Oh, okay. Who's next? What's Mr. Mena waiting on? He's been here for a minute.
I don't have him.
Judge, good morning.
Morning.
Judge, I have Carlos Gallegos who's here present. But I believe that case is up on appeal, and I think Felix
Right, I
Valenzuela is
had a
handling that for
question.
him.
Yeah, and I see Mr. Valenzuela here, and now I see Mr. Gallegos. What were we set for? I'm sorry, admittedly, I think it was like 6:30 last night when I saw this on the docket, and I don't know, I had a whole much more steam in the tank or whatever you want to call it to question why he was on the docket.
It's just a status, Judge.
Okay, well, it's on appeal. So we took care of the bond. I think when we were in trial, that's kind of cloudy too, but I mean, it's on appeal, right? So.
Right.
Yes, Your Honor.
So can I be excused?
Absolutely, Mr. Mena.
Okay, it's always good talking to you, Felix. Mr.
Good to see
Gallegos,
Thank you, Mr.
Judge,
Mena.
good seeing you all. Bye-bye.
Good to see you.
Carla, I'll tell you, I haven't seen, was there some kind of summary or something that the probation wanted to bring to our attention? Let me go back.
Sorry, Judge, I was muted. No, Your Honor. okay, so according to the summary, Mr. Gallegos is still doing his 8 cop days that were ordered.
Mhm.
So he continues to do as is, although it's on appeal?
Well, I
No.
didn't get any, and I'm speaking just from memory, and so I shouldn't do that. I should go and see if there was, I didn't see anything staying the proceedings here. And so I just recall seeing the notice of appeal, Mr. Valenzuela.
Yes, Your Honor. If I may,
Yes.
because it's on appeal, the conviction is technically not final. And because it's not
Mhm.
final, we don't believe that he should have to serve ACOP or any of the conditions until it is final.
Okay, well, I mean, he's been turning himself in through, it says here, June 12th. Was probation inquiring about that before? Because other than having this status, is that why we have the status today? I'm not understanding.
Right, so my client was just in abundance of caution, still trying to report just so he doesn't run afoul of anything. But I told him that because it's not finalized,
Mhm.
the conditions of the conviction are not applicable to him until it's finalized.
The minute I saw the notice of appeal, I assumed everything was abated, stopped. The fact that I'm looking right here and the bond, I know that was one thing that we just, had to take care of. But I didn't know that Mr. Gallegos was continuing to do anything on probation. So yeah, you don't have to do anymore. And now you have 39 days of your ACOP completed out of 60. So
Thank you, Judge.
let me see, let me go back to Odyssey because I was going off.
I don't know that that's true for these things, that the appeal abates the order of the court. I'm going to look that up and I'll get back to that if that's not true.
Okay, Mr. Vandenberg, I'm gonna go ahead and set this. Let me see. Sorry, Odyssey is just not friendly. But here it goes. For a status hearing in 6 months.
Perfect, thank you, Judge.
All right.
Judge, if I may, this is Ed Guerreras for the probation department.
Mhm.
If we're speaking on Mr. Gallegos, I guess he's not going to be reporting anymore since he's doing his appeal and so forth.
I'm comfortable with that. If the state wants to file something and tell me why he should be, then we can hear that and talk about it then. For my purposes, no.
Okay.
Thank you.
We did have conditions, right? We did have conditions on his bond, right? So he still has to be compliant with his bond conditions. Okay.
That's correct, Judge.
All righty.
Thank you. May we be
Alrighty.
excused, Your Honor?
You may. Thank you, Mr. Eras.
Yeah. Yes.
Mr. Gallegos, you can log off now.
Take care.
Thank you.
Who's next?
Bottom of page 11, Judge.
Mhm.
In cause number 2021-0D02680, State of Texas versus Leroy Ayala. Announcement of council, please.
David Vandenberg on behalf of the state.
Mr. Aronson, if you're announcing, I need you to unmute.
I'm still muted, sir.
Is he frozen?
No,
Oh.
he's moving.
Can't hear you, Mr. Aronson. There you go.
He muted again.
Turned it off and on.
You're muted again, Mr. Aronson.
Sorry about that. Was I not muted when I got on the phone a second ago?
I haven't heard you until these words that you're
Oh,
just saying.
Good, okay.
All right, so Mr. Aronson is here on behalf of Mr. Ayala. I believe there's a Leroy's iPhone. Is that Mr. Ayala? We are scheduled for that's your client, Mr. Aronson?
Yes, it is, Your Honor. We have
Okay.
already submitted a waiver.
We're also set for a review hearing today. Has the state looked at this case?
Yes, Your Honor. 2680. I have looked at this case.
Is there a recommendation?
Yes, the rec is 5 TDC, Your Honor.
Okay, so Mr. Aronson, so your client is aware on these DWI cases, it's standard for me to review the bond on the DWI for conditions. It does not appear in Jasmine, if you can confirm this for me, it does not appear that he has any type of PR components on his bond. Is that right?
don't know, Judge. I'm not sure. We can ask him if you'd like. I know that several weeks ago or several months ago when he hired me several weeks ago, I don't believe that he was, but
So this is what I saw yesterday, and I'm asking our clerk, Ms. Welch, to look at this. When it was indicted, the grand jury put a $10,000 bond there. However, it looks to me like he was picked up in some other county and a $1,500 bond was at his bond. That's what I was looking at late yesterday.
Judge, I don't know. I don't know about that. I'm looking at my notes. I don't have anything about that, but that may be true.
Please correct me, Ms. Welch, if I'm wrong, but I think I saw that he is on a straight cash surety bond of $1,500. And I believe.
Sorry, Judge, I'm looking at the capias. It says the amount of bail fixed by the court in this case is 10,000 cash or surety plus 10,000 personal recognizance conditions as follows. Personal PR fee, $10 per month. Defendant may not operate any motor vehicle unless his driver's license is in effect. The device shall be installed on appropriate motor vehicles before the 14th
Jasmine,
day.
can you send that to me, please? So are you telling me his bond is 20,000 split 10 and 10?
Yes, Judge.
Okay. Can you tell me also what, let me go back. Let me go back. So on March 16th, right? March 16th, there is a bond order that says out of county.
Is that under his jailings, Judge, or is it on the case on Odyssey?
It's just on the events.
If you like, I can send you the document, but I'm not quite familiar with their paperwork. But let me go ahead and send it to you, Judge.
Well, I'm looking at this, the March 16, 2023 out of county bond, and it says Ayala Leroy, $1,500 on case number 2021-0D02680.
Yes, I see that too.
Give me a second. Let me go to what this sent me.
It looks like it was a misdemeanor.
Oh, that's another case. It's not, but it says our case, right?
Yeah, it does.
Were you picked up in another county? Was he picked up in another county, Mr. Aronson?
Mr. Ayala, were you picked up somewhere else? You're muted. We can't hear you. You have to unmute your phone or computer, please.
Is that, can you hear me now?
Yes.
Okay, yes, I live in Odessa, Texas, sir, and yes, I was picked up here in Odessa.
And what was your
Texas.
bond?
I believe I paid, I'm not mistaken, Your Honor, I paid, I think 15. It was 10,000, something like that.
You paid
But it was-
1,500?
Yes, 1,500 or 1,000, yeah, something like that. Yes, ma'am.
Okay. I just wanted to confirm because I was confused as to what the bond amount was and whether there were conditions. I see the conditions that I don't think we usually have the conditions on the capias. But so he is currently, do we have a PR report on Mr. Ayala? Somebody get me PR so I can get a PR report on Mr. Ayala.
Yes, ma'am.
Does he have a monitor? Does he have an alcohol monitor?
Mr. Ayala, are you using any alcohol detection device? We can't hear you again. You're muted, I think.
Okay, I'm sorry, it's because it's saying that hostess is muting me. No, sir, I was never aware of this. Like I said, when that happened, I never received anything, any courts, anything. So I'm not in no, I have no ignition lock of any sorts.
All right, so it's a good thing we're having a review hearing today because there are, right, Jasmine, but it's not straight surety. I see it here on the order on the KPS that it's 10,000 cash or surety plus 10,000 PR bond condition as follows. The conditions are that you may not operate a motor vehicle unless you have an alcohol monitor attached to that vehicle. These are the conditions that are on the KPS, and it's to be installed within 14 days after he is released on bond. So this was unusual, Mr. Aronson, for me to see this kind of piecemealed like this. Initially, when we have a review hearing, which is standard for me on the DWI thirds, there's the PR bond order, right? And it's usually coming from the jail magistrate, and it's pretty clear. And those conditions differ from the conditions that I have on my DWI third defendants. So we'll do a review, I'll review a monitor report, things of that nature. It sounds to me like he may not even be on PR's radar. So we are going to do this. As I'm seeing the bond, it's going to remain the same. In other words, what you paid Mr. Ayala, that's all good to go. It's a $20,000 split bond, 10,000 cash surety, 20,000 PR, 10,000 PR. My conditions are as follows. You may not operate, do you have a valid driver's license, Mr. Ayala?
Yes, ma'am, I do.
You have valid insurance?
Yes, ma'am, I do.
I show this to be, is this our, I have 3 prior DWI, so this is our 4th. He has a third already out of the 41st.
Let me confirm.
I don't know, Your Honor, I haven't, I just got hired like about 2.5 weeks ago, so I haven't had a chance to go through all this thoroughly.
He has 1, 2, 3. This would be the 4th, Your Honor.
Right. Okay. So I don't, Mr. Aronson, Mr. Ayala, I don't want you to think I'm picking on you, period. I do not allow my DWI third to operate a motor vehicle, period. And that is going to be the order because you do not have a monitor. That is where I start. I don't know if you have a need to drive. If you do, then you need to communicate that with your attorney and we will review that. And Mr. Aronson, as long as he has a valid driver's license and explains to me why he needs to be driving, I'm going to consider that, but he cannot drive. Like right now, Mr. Ayala, you may not operate a motor vehicle, irrespective of whether you have a valid driver's license or not, because we have no monitor. I'm not saying it's your fault that, you know, I don't know what got given to you or not in terms of what the conditions were, but
Yes,
I'm
ma'am.
going to assume it wasn't your fault. However, I am not going to have you operate in a motor vehicle when you're on your alleged 4th DWI and not have a monitor. So what that tells you all is get on getting that portable monitor. It's not a monitor on your vehicle. It's a portable monitoring unit. PR is very well aware of the unit that I use. It has GPS capability and camera capability. As soon as you get that, Mr. Ayala, and I'm gonna tell you what the other conditions are, Mr. Aronson, feel free to come back to the court and say, Judge, he's got the monitor and we want to ask the court's permission. He's got valid driver's license, valid insurance that PR is going to verify, and we'll address his ability to drive. Okay?
Judge, yeah, Judge, I have a question when you're done.
Yes, sir. No, go
Okay,
ahead.
so I want to make sure I understand the court's instructions. So does the court want him to get ignition interlock?
No, it's a portable monitoring unit. It's not something on the vehicle. It's something that he's going to keep on his person, and he will have windows to test.
Is he going to be able to do that without a court order or some direction from the probation department?
Not probation. It's going to be PR, and I'm going to have a bond order that tells them that that's what he's supposed to do.
Will I be receiving a copy of that, Your Honor?
It will be filed as part of the case. Once it gets filed, obviously it's there, but you can inquire with Ms. Hernandez to send it to you.
Okay, and Judge, was it my understanding that the court said that once he has a valid license, insurance, and an ignition interlock, the court may consider him driving?
It's not an ignition interlock. It's a portable monitoring unit. And once he does that, because here on the original order, they said he has to do it within 14 days. What I'm telling you is I'm not going to allow him to drive until I see that he's got a monitor and valid insurance and driver's license. As soon as he does that, if Mr. Ayala turns around in the next 2 days and gets that portable monitoring unit immediately, Mr. Aronson, contact the court and I will readdress the condition that does not allow him to drive. I know this is coming out of, probably left field. It's standard for this court, but it's, not everybody knows.
We understand, Judge.
Mr. Ayala, he lives outside of El Paso County?
Yes, ma'am. I'm in Odessa, Texas.
Okay. So I will not have a restriction that he remain in El Paso County, but I will require that he maintain current contact information with PR. He is to report to the PR bond office once a month. I believe they have remote capabilities. I don't have an issue with him reporting by phone, or they have something new, Mr. Aronson. I'm not going to pretend to know exactly what it is. It's some kind of app. I don't know that it's available to everybody, but if it's a remote report, that's fine by me if he's living somewhere else. He's going to have a curfew from 10 p.m. to 6 a.m. unless he is working or going to school. He may not drink alcohol, use illegal drugs. He's subject to testing. Let me see what else. What am I missing? May not operate a motor vehicle. Again, like I said, we can come back to that, but the urgency is on the monitor. Clearly, with this type of allegation, that is the court's concern, is that we don't have him operating any type of motor vehicle while he's intoxicated. He's going to do this 4 times a day, Ms. Welch. Mr. Ayala, I would encourage you to get on that. There have been times post-COVID where these providers aren't always, sometimes they have, supply issues on these. I don't know if it would be the situation over where you are in Odessa, but the sooner you get that done, the sooner I will consider allowing you to drive.
Yes, ma'am. I just have a. May I ask a question, please?
Yes, sir.
Can I get it here in Odessa, or does it have to be off of El Paso?
I would refer you to the PR bond office to see. I don't see why you wouldn't be able to get it in Odessa. Okay. Because these companies operate not just in El Paso. So I think there's Smart Start, Lifesaver. In fact, there's one provider they don't use anymore. But Mr. Aronson, if you can contact PR Bond, maybe assist your client to find out what providers he may be able to find when they're in his area, and they could certainly, a lot of times PR and the provider companies, they talk to each other. So once you get it, they can confirm with the company that you've received it, and that's what can be reported to the court. Okay.
You know, one more question. So,
sure.
One more
go ahead.
question.
Mm-hmm.
Yeah, Judge, I just want to know, so he's not going to be able to get a monitor until he gets a copy of the PR order. Is that accurate?
Right. And as soon as we finish talking, I'm sure the clerk is going to send it to me. I'll sign it. It'll get filed electronically. Okay.
That was my next question. Okay, thank you, Your Honor.
Mr. Aronson, if you want it, email, put your email in the chat, and Mr. Hernandez can look at that and send it to you, or Ms. Welch.
Yes, or I can contact your clerk. What is your clerk's name?
Miss Welch, Jasmine Welch.
Justin Welch?
Jasmine.
Jasmine. Okay, I'll send her an email as soon as we're done, so she'll have mine and she can get me a copy of that. Mr. Vandenberg, will I be dealing with you or Ms. Elizalde on recommendations?
With me.
With you, okay. I'll shoot you an email later. Thank you very much. Your Honor, will that be for us?
That's it. If you have any questions, please feel free to contact the court.
Thank you very much.
Take care.
Thank you.
Judge, something came up for me. It's Daniel, Your Honor.
Yes, sir.
I gotta run, but I'm withdrawing my motion anyway. I'm set for a motion to withdraw.
Okay.
But we worked it out.
Okay. So 2022-0D05791, State of Texas versus Nolan Montellano. Mr. Avelar is here on behalf of Mr. Montellano, has indicated he is withdrawing his motion to withdraw.
Correct.
All right. So we'll go to our next setting.
Thanks so much. Yes, ma'am.
Thank you, Mr. Avelar. I saw Ms. Warwick here as well, and I want to get to her case because I know that it was something about this afternoon and she had some scheduling issues. I feel like today is going really slow.
Good morning, Judge. I'm not the one with the scheduling issues. It's the state, but I'm here and ready to go.
He is correct.
Let's call it, please.
In cause number 2022-0D01706, the State of Texas versus Richard Alexander Dominguez. Announcement on council, please.
David Vandenberg on behalf of the state.
Your Honor, Melissa Wark on behalf of Mr. Dominguez. He is not present on Zoom, Judge.
We were originally scheduled today, I think, and honestly, my head is kind of mush right now. So we were scheduled this afternoon. I think there was some type of request to reset something.
Yes, right.
I saw another email from Ms. Warwick saying, well, I thought one was reset, the other was not. And so I just kind of said, come in the morning and tell me what's going on.
The state is requesting that the outcry hearing should stay the same this afternoon, but it's really the Daubert hearing with the state's witness. The state's witness is unavailable this afternoon, cannot make it. So we requested a reset of that for next week. It can work next Monday on the 3rd from 11 a.m. on, and on Thursday from 10 till 2, I believe, according to Ms. Warwick's schedule.
Okay, so next week does not work for the court, so we got to look at the following week.
Okay.
Your Honor, the following week I have a vacation certificate on file, the 10th through the 15th.
Well, we're set for a final hearing plea deadline on July 18th. We can do it on the 17th. We can do it on the 20th.
I don't know if Mr. Vandenberg has spoken with his witness to know if she's available on those dates.
It probably is, as I understand it.
So
I'm sorry,
why
I
don't-
didn't catch that.
Why don't you all confer on the reset for that week and let the court know what dates your witness is available, and I will look at the court's calendar and find out if we're available. Because I said the 20th, and now I'm trying to make sure we don't have any trials set that day. We don't. So the 20th is really good.
Okay.
I say really good. We have a trial on the 13th and 14th, so maybe that Monday's not going to be great. So let's try and do the 20th.
Okay.
I will confer with Mr. Vandenberg, Your Honor, and I just want to confirm we can still go forward with our hearing this afternoon.
Correct. And that might have been my mistake. When I saw something being continued, I put it all in one basket. That's fine. You guys are still set for 1:30.
Perfect. Thank you, Judge. We'll see the court then. Thank you.
Thank you for your time. Who's next?
Bottom of page 15, Judge, in cause number 2023-0D02635, State of Texas versus Antonio Roberto Machorro. Announcement of council, please.
Laura King for the state. Good morning, Your Honor.
Morning.
Good morning, Your Honor. Mario Ortiz Aroldi on behalf of Mr. Machuro.
Okay, and I believe, is that your client there also appearing remotely? Excuse me. We're set for an arraignment and review hearing.
That's correct.
Okay, 1 second. Messages. Okay. So in terms of the review, let me just check the bond order very quickly. He's on 110,000 split DWI. Yeah, okay. So for my purposes, again, it's going to be Mr. Saroldi, the conditions on the bond. Let me ask, does he have any prior DWIs?
He has no priors, Judge.
No, Your Honor.
No criminal history.
Okay. So does he have a valid driver's license?
It may be suspended right now, Judge. He is not driving. I know that for a fact.
All right. For now, that is going to be a change in his bond conditions. So JMAG uses this kind of standard form. I do not. He's going to be subject to testing, reporting to PR once a month, may not use any illegal drug or alcohol. He may not operate a motor vehicle, and he is to acquire. Does he already have a monitor, Mr. Saroldi?
Yes, Judge.
And so that's the portable monitor, I would imagine. So that's the order. So that's not an issue as long as it's a portable monitor. Maintain current contact information, no new offenses. Is he in school going to, does he work?
He does both, Judge. He's enrolled at UTEP and he's also employed.
Okay, so I'm not going to impose a curfew. No illegal drug or alcohol, subject to testing. Those are are there any other conditions, Ms. King, that you're thinking of?
No, Your Honor, we are still waiting for DPS to send us the toxicology results.
Any reason to leave El Paso County, Mr. Sarodi?
Judge, he does have family he's originally from Denton, Texas. His parents reside in Denton, Texas, so for the purposes of travel to visit family, I mean, that would be a reason why he would be traveling, Judge.
I'm not going to restrict him to El Paso County, but he must maintain current contact and all that information with PR bond, okay?
Yes, Judge.
Mr. Machoro, I'm sure your attorney has explained to you how to report not only to PR, but to the court for your hearings. We do pretty much everything by Zoom unless your attorney requests differently or someone else requests differently, we do them in person. Please do not go afoul of the PR bond conditions, okay? Mr. Sarodi, we'll get the new order out and then we'll just go to the next setting. Ms. King, did you have anything further?
No, Your Honor.
Thank you for your time. You all are excused.
Thank you, Judge.
Who's next?
Oh,
Middle of page 10, Judge.
Monday?
I'm sorry to interrupt, Your Honor. I had one set, I don't know if it's still on your docket. It was an arraignment, but they asked me to check in, but not my client on Mr. Yanez. It's the other one I had set this morning. I don't know if I actually need to check in with you. It's not a DWI.
Probably not with me, but let's take you off the list. Who is it?
The gentleman's name is Eric Yanez.
Oh,
Page 17, Judge, but I show Kristen Romero as well.
I subbed out court appointed counsel, Judge.
okay. Let me see. Did we get that? All right, Mr. Vandenberg, are you there?
I am here. I think this is a BPU case though, Your Honor. And this is Yanez, 2023 DO.
Oh, yeah. Did we have, I mean, if it's set for arraignment, did we get your waiver in, Mr. Sarodi? Yes?
Yes, Judge.
Are we expecting anyone from BPU or do you have any instruction, Mr. Vandenberg? Because if it's an arraignment, I just assume go to the next setting.
As far as I know, it's BPU and I'll confirm that.
Okay. You're good to go, Mr. Ortiz. Thank you very much.
Judge. Take care.
Who's next?
Middle of page 10, Judge. In cause number 2019-0D0-6836, Victor Manuel Greco, State of Texas versus Victor Manuel Greco. Announcement of counsel, please.
Hello? Can you hear? Yeah, I lost contact. Could you repeat the case number, please?
In cause number 2019-0D0-6836, State of Texas versus Victor Manuel Greco. Announcement of counsel, please.
David Vandenberg on behalf of the state.
Rick Huffman on behalf of Mr. Grego.
And Mr. Grego is appearing remotely as well. Let me see, we're set for a probation status hearing today. Carla, oh no, is Mr. Edos?
Yes, Judge. Good morning, Edgar Edos, with the probation department.
Do you have an update on Mr. Griego? Why is this name familiar?
Yes, Judge. So initially there was a motion to adjudicate guilt filed on Mr. Griego that was never really resolved. The very first one was filed back on October 18 of 2021. And it was amended to include a few things during the course of last year. Mr. Griego was picked up on two different instances, one on April the 14th and the other one on August the 17th for alien smuggling, crossing over people illegally. He was detained, I guess, on the federal level there, and he pled out to 3 years of federal probation back in November 22nd, I believe. As part of his sentence, he had to do so much time in jail, and he was released from custody back on May the 18th. Last month, I just spoke to Mr. Griego last week. I had given him an appointment to go ahead and report to our office. However, when he showed up to our office, the counselor, I guess there was some miscommunication there. And she ended up taking him and doing an assessment for the alcohol and drug counseling. So I never got a chance to talk to him as I ended up going over there with her. She did accept them into the program itself. Now, I spoke to Mr. Griego 2 days ago, and I sent him the link for the other court setting. The motion adjudicate is still pending. The very latest one that was filed was back on April 21st of 2022. And that one only included the very first arrest. When I spoke to Mr. Griego last week, I did tell him to go in for a drug test, and he did go and he tested negative. 2 days ago, when I finally got a chance to talk to Mr. Griego, I asked him, I said, since you got out of, bless you, since you got out of court on May the 18th, why is it that, you didn't bother to check in with, myself or this department? Mr. Griego did tell me that, his mom passed away on the 25th. And in essence, he's been in mourning ever since then. But he is reporting, 2 days ago, he did report, and I believe I gave him an appointment for July. And I did instruct them to go ahead and show up for this hearing. So we still have that motion pending based on one of the new charges that he had picked up. And I believe on that motion itself, it also indicates, I guess, failure to pay fees, yes. Failure to pay fees, and then whatever was listed on the initial first two motions that were filed.
All right. This is the one I kind of stumbled on and looking for, I think, something else. Your last report had indicated he was due to be released. And when I saw that release date, it was actually like 3 or 4 days after. And I said, oh, well, let's find out. Okay, Mr. Huffman, what do you have? You're muted. Today's mute day.
Hi, Judge, I have not had contact with Mr. Griego, and I think I've got a bad phone number for him. We're obviously hoping, Judge, that the court keeps him on deferred and lets him finish off the probation.
The recommendation is to transfer him to the TAP caseload. He qualifies for TAP SOP treatment. For my purposes, unless I'm hearing something differently, Mr. Eras, the case for which we, kind of put the MTR into motion has been handled, right?
Yes, Judge. That is correct. In essence, it's been handled because he is not only on regular probation here with the state, he is on probation on the federal level.
Mr. Griego, what I'm going to do at this point is we were keeping track of your case. I am going to do what probation is recommending, which is to basically kind of start you from scratch, but I don't need to extend him because he's on for 8 years. He's on for 8 years, right? He doesn't term with us until like 2028, something like that.
Yes, Judge. He does have plenty of time left. And as far as the TAP program, when I spoke to him the other day, he did mention that he's doing alcohol and drug counseling through federal probation. So I was thinking, we'll just give him credit for that. I mean, I'll just go ahead and I'll keep in contact with that counselor over on their end to make sure he's attending and all that, if that would be fine with the court.
That is, basically, Mr. Griego, I feel like we're starting from a new place and you're in a different place now. Whatever difficulties you think you're having, I just implore you to work with probation to see how they can help you. I know it doesn't feel like it's help, like it's punishment, right? But I don't, life circumstances change and the court is willing to work with you. It's a long time. So Mr. Eras, as long as, you have him, whoever he goes to, if we see some really good progress here, I'm not even looking in terms of, I haven't seen, what I mean is in terms of his prior history. Is it an extensive history? Why would he get 8 years on an evading with a vehicle? Was there another?
I haven't checked his background, Judge, lately.
What I mean to say is if we start on for a significant amount of time on and have good results and he does not, fall off track, on deferred, right?
He's on deferred, yes, Judge.
Yeah. I'd entertain any kind of recommendation from probation, but let's get him started first, okay? let's get him started and see how he does. Okay, and then dismiss that MTR. So if you'll send me a dismissal, Mr. Vandenberg,
Yes, Your Honor.
thank you very much.
May I
And
be
I'm,
excused, Judge?
you may, and I don't need to come back unless I hear from you, Mr. Edas, if we're having any issues, okay? Good
Yes,
luck to
Judge,
you.
thank you.
Good luck to you, Mr. Grego. Is he speaking? All right. Mr. Hoffman, sorry, I didn't ask if you had anything. See you later. All right,
No,
Nick, do you have any more?
Yes, yes, Judge, one more.
Mm.
Page
Oh.
8,
Mm-hmm.
in cause number 2020-0D04283 and 2023-0D02308, State of Texas versus Christopher Jesus Lozano. Announcement of council, please.
David Vandenberg on behalf of the state.
Rick Huffman on behalf of Mr. Lozano.
So let me just ask, did he check in?
Judge, he's actually in jail. He was
in jail
picked up a week ago. Yeah.
Yeah.
And then
Okay, so do we have a number?
Well, he kind of, Judge, he does have a newly indicted case. It's a case that allegedly occurred before he got put on probation. But it's been, you know, it just got indicted. So we have to figure that out but we're hoping we got 6 months, Judge. We're hoping that the court would consider the minimum.
Mr. Lozano, isn't he, I'm going to Houston, no, I'm gonna stay here, no, I'm gonna go here, never complies with anything and just,
That's him, Your Honor.
yeah, no.
The newer case is, all his cases are burglaries of buildings. He has a
Where is it? Oh my. Yeah, when is his new case set for trial? Well, he is in jail.
I don't think we have.
Yeah, it's set for December.
Okay.
Is that the P file 6613, Your Honor?
No, 2023-0D02308. Is there another case coming?
Yes, there's one here, which is a P file, burglary of a building, 2023 06613. P file.
All right, what's the offense date on that? Do you have that?
Let me see.
Is it 4/5/2000 or 2000?
I don't see any new.
415.
Or 4/15? I think that's the same one.
Yeah, I don't see any new cases other than the one that we have here, but I'm hearing it's predates this case, but it was indicted late. Yeah, so let's look at a number. 660.
As for a rec number, Your Honor, you know, state was unaware about this new case.
It's not new.
It's not new. I mean, it's a 2023. It's already gone past arraignment, so you all should have conferenced it already. Arraignment was May 25th.
On which case?
On
23.
Christopher Jesus Lozano, cause number 2023-0D02308.
Yes, we have
That's
that.
that's a burglary of building. The arraignment was back on May 25th. Our 28, we won't be back until August on 2801s. I don't know. Is there restitution? Was there restitution in any of these cases?
With the 2308, we would require restitution of about $7,200.
Oh.
In that one, he stole a number of televisions from a business. I think it was in Socorro.
Was there restitution on the probation case, Carla? Let me go back and see.
Yes, Your Honor, there was. There is.
Okay. Well, he's not paying that. So how much? Let me see.
There's an outstanding balance, Your Honor, right now.
3290.
290.
Yeah, so he paid 700. When did he pay that? All right. Bueno, we're going to the next setting. Carry the probation case. I was going to say time. That's a lot of restitution. So does he have the means? He didn't have the means to pay no restitution, Mr. Huffman.
Oh, man. I'll reach out to his father and his mother.
Oh, no.
Yeah, I don't know.
Don't give him the Zoom ID, please.
Oh.
I'm at 15 months on both cases.
Okay.
And then maybe if
Okay.
he pays the restitution, We can do
If
six,
that comes in with, what,
maybe-
30, 10,000, $11,000?
No. no,
Yeah.
no.
Odd, huh? Ándale, pues, we'll just carry the case, Mr. Huffman. Tell him
Okay.
he wants to do time. He's already in. He's been in before. He's in a lot. Sounds like it's where he wants to be.
I'll talk to him.
Ándale, pues, who's next?
Judge, on page 13,
Mhm.
on Blanco, Jose Blanco, does not have an attorney, Judge, and he's here.
Okay, let's bring him in. Let's see.
Mr. Blanco, could you unmute and turn on your camera, please?
Sorry about that. Mr. Blanco, this is Judge. Can you say your name and date of birth, please?
Jose Javier Blanco, date of birth is 12/03/1986.
Mr. Blanco, we have you scheduled for your arraignment today. In looking at your case, don't tell me anything about the facts of the case. You don't have an attorney. Have you hired an attorney?
No, ma'am, I was barely gonna get to working on that to get one of the free attorneys.
So you're trying to apply for a court-appointed attorney, is that right?
Yes, ma'am.
When you applied back on October 18th, well, can we get somebody in here to do another application on him? Because his application was from October, it looks like, of 2022. And back then you didn't qualify.
Yeah.
Let's go ahead and have him screened. Can we get somebody to come in and screen him?
I will call them, Judge.
Okay, Mr. Blanco, we're gonna put you back in the waiting room. Do not leave. As soon as we get someone here to take your application, we'll see if you qualify. If you do, I'll go ahead and appoint you an attorney, okay?
Okay, thank you.
Yes, sir. All right. Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket from March 13, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Monares, would you go ahead and call our first case, please?
Calling cause number 2022 DCV 1483. Jose Carlos Vega and Maria Gomez Vega versus Evelyn Medrano and Texas Farm Bureau Mutual Insurance Company.
May I have announcements, please?
Good morning, Your Honor. Manny Morgan on behalf of the plaintiffs.
Good morning, Your Honor. It's Randy Grambling on behalf of the defendant Medrano.
And we're scheduled for entry of judgment. How are we doing?
Your Honor, we're waiting funds from Mr. Grambling, and once we have those, we'll file the dismissal paperwork.
Your Honor, I was following up yesterday with the insurance company. We've got clarification on the Blue Cross Blue Shield liens. I would say that I'll have the settlement checks in hand anywhere from 1 week to 2 weeks, and I'll take them to Manny if I have to. I'll hand deliver them to him.
So we can reset for 30 days, anticipating everything will get taken care of. Is that good?
Yes, Your
Or
Honor.
plaintiff, Your Honor.
Thank you very much.
Thank you.
Anything else? Thank
No.
you. All right, who's next?
We have cause number 2024 DCV 0487. Felix Alvarez versus Arturo Alvarez and Billy Cruz, Inc., individually, jointly, and severally. May I have announcements, please?
Show that as being Brock Benjamin. Is there somebody here in his place? Because otherwise I don't see him here. Are all the parties here on the next case, 1585, Mary Horton Keel, Connie Flores, I see Miss Flores, and Eric Weborg?
Good morning, Your Honor. Connie Flores for the plaintiff.
Do we have opposing counsel here?
I don't.
No, ma'am.
Okay. So who's ready? Mr. Dickey, you're here on, let me see. I think, you're not here on the Donna Moore case, are you, Mr. Dickey?
Yes, Judge, and I think there's a little confusion. Donna Moore is not to the case against my client. There's an outstanding check owed to Jose De La O, who's an intervener with Guadalupe.
Oh, okay.
That check, I've been told, is in the mail by the carrier, so I'm hoping to have that by Friday. The other remaining plaintiff is Guadalupe. She's already been paid.
Right.
And the releases have been signed, so we're just waiting. Hopefully by Friday, I have the check to Connie's office and we'll get the non-suit filed and we'll be done.
Okay, and so I'll put this out again, 30 days, anticipating we won't need another setting, okay?
Okay.
Perfect, Your Honor.
Thank you, Judge.
Okay, so, Mr. Monadas, let's go ahead and, is there anyone who everyone is here? Are there any cases that are ready?
There's a few missing opposing counsels, so I don't think we're
So
ready.
let's
All right, are you waiting for Bridget Garza? All right, have you called her?
Yes, it said, I don't, a lot of confusion that's going on. She said that she isn't here.
No, she didn't say she was here.
No.
She said she wasn't able to make it. She was trying to get a hold of him. He wouldn't answer. His mother was calling all the time. She said that her son was here in court this morning on time. I asked a lot of stuff. He wasn't here. He had.
What's your name?
Orlando de la Cruz. I got here.
No. Let me check. What page is he on?
He's toward the last page.
The last page?
Judge, the one that you had called and said if anybody's name wasn't called, stand up, he stood up.
Yes.
I had pulled the file because I had, he was ER.
All right, so can you call Bridget and let her know he's here for her?
Okay.
Yeah, because he was in the docket, right? I had the file already pulled because, not the attorney letter.
Oh, I got it.
About it, and I just haven't had it out.
Yeah. I was mistaken.
All right, Bashan, felony drug court graduation, October 4th. Yes, I will be there. You did that, awesome. Okay, from now on.
Yeah,
you're-
you need
you're
to.
the rapper. Okay.
Because you know, there's a lot of allergies going on during those graduations.
Oh, thank you. Okay, so let me put that on the calendar. All right, if anybody's ready, just let me know and I'll take you up. Those graduations are always so exciting. And Bashan, Kleenex time when we go there. Yes.
I remember when you went to your second, what happened?
There were allergies. That's what we always say. There's allergies in the air. Well, since they're having graduation, they may be ready for more participants. Oh, Bashan, on September 28th, if you know anybody who is about to go to college, they have this free Ready Set College resource fair at 626 North Flores on September 28th, 2 to 4 p.m. Yeah, they'll give you SAT prep advice, federal aid information, admissions counseling, and virtual tour of colleges. I may just show up just to show up because I always want to know about valuable information. Michelle, I'm not going because they're giving away free snacks and popcorn and food prizes. I'm going to get informed. All righty. And that's 2 to 4 p.m.
Yeah, no problem. Another judge.
And then that's it.
Yeah, no problem.
Okay.
He was hiding in Nevada, Sean. He was hiding in Nevada on his property with a white little dog that he stole from that. He stole another dog. He stole a dog. From the last chick? Yes.
All right.
He
And,
took the dog.
and Deputy Laura, they're bringing them up now, right?
I'm sorry, who judge?
They're bringing them up. Let me see.
Yes, they're bringing 6 people that we have downstairs.
Okay, awesome. All right, let me see the file on Daniel Ramirez.
That's fine. The motion is it was accepted as well. I'm not gonna do that. You're not even yet. He's got, we want to swear him tomorrow morning. He's got some health issues. I just wanted to talk to you. I know that's what I wanted to actually talk to Judge, see if she'll just allow the clerks to do it once he's in jail. Set the bond. In other words, if she orders it, but don't put it on the system until he's actually in the jail.
All right, Daniel Ramirez. All right, if you come down, please. Norma, did you call David McLean?
Yes, Judge, I sent you all the messages. To your text.
All right. So it appears that Odyssey is doing some crazy things with the system. So even though we have you brought over, your attorney didn't get notice to be here. So what we're going to do is we're going to recall you. And we are going to recall it for September 9th. So not next week. And the reason why not next week, that's a short week. And if we recall it for September 9th, that'll give your attorney a chance to look over information with the states. Okay. All right. Do you have any questions? All right. Thank you so much for your patience. Daniel or Andrew, I don't know which one of you would be on Daniel Hernandez Ramirez. It's a possession 1 to 4 grams. That's going to come back on the 9th. If you all could confer off docket with David McLean. All right. Thank you. Daniel Ramirez. It's coming back on the 9th.
Appreciate it. Thank you.
All right. Let me see the file on Jesus Trevino. All right, Norma, on this one, did you contact Teresa Garcia?
She's doing a plea the 227th and she'll be right over.
All right, your attorney will be here shortly. Okay, thank you.
Reverse the motion to set bond.
Who's your client?
Kruger, Judge Joseph. It's a motion to set bond.
All right, let's bring him down. Who is the prosecutor on Kruger? Hello. All right, court is calling 2023 CR 10268 and 2024 CR 3168. State of Texas versus Joseph Kruger. Could I have parties announced for the record for the state? For the defense?
Adam LaHood.
All right, in each of these cause numbers, the defense has filed motion to set bond. State, have you had a chance to review the cause numbers?
No, Your Honor.
And have you had a chance to review the motion to set bond?
No.
All right, if you all will step back, he'll review it and then we'll take it up immediately.
Sounds good.
Thank you. Let me see the file on Joseph Grosso. All right, so this case is supposed to be set for November 18th.
Yes, Judge. He came in early, Judge. I went to take off the dog.
Okay.
Yes, yes, basically.
Let me see the file on Arturo Villanueva. All right, Norma, on Arturo Villanueva, I need a jury trial date.
I'll do that one for,
Yes, I think this one.
I'm sorry, when? Okay.
Yes.
Make sure that's in the system and email the defense counsel that his jury trial is November 12th. All right, thank you. Let me see the file on Jason Montez. Oh, I have it. I'm sorry. What is the update on Montez's competency? He had a competency hearing.
John, you've heard,
Yes.
and I think we have an agreement for you.
Okay, just give me one moment.
Of course, Judge, we'll wait. It's until 2 o'clock.
morning last night. Or this morning, whatever the hell it is.
You left your days already.
Well, night, it's a night or morning, I don't. I had 3 trials from or 2 nephers, 0.
Judge, they ordered the eval on May 1st and nothing has come back yet.
All right, so reset this for the end of September.
September 30th.
Yes, is he in the box?
Yes.
Mr. Montez, if you'll come down, please. Hello. Hi. So, Mr. Montez, has a doctor come see you yet?
For what?
Just to talk to you about any issues.
Yes, I think so. They talked to me, like, they did a psychiatric thing on, for rehab and they checked my pill medication.
Okay.
And they said, what would I like to do? And I told them rehab. And then I still haven't.
Okay.
Called since.
So this is what's going to end up happening. They're going to give a report to me and we'll bring you back as soon as that report is done. I'm going to set it for September 30th, but if they're done sooner than that, we'll bring you back sooner. Do you understand?
No.
Okay. So I cannot go forward with your case until a doctor tells me that you're okay to go forward.
Okay.
All right. So I have to wait for them to send me a report.
Yes, sir.
Are you okay?
Yeah, I'm all right. I'm doing fine.
All right. Have you been getting facial tattoos while you've been at the jail, or that's before the jail?
That's before.
All right. Do you have any questions?
Would I be able to go for time served next September or? do I
Well,
have to
that'll
go
be
to-
something that your attorney will have to work on, okay?
All right.
That's what's called plea negotiations. So what will end up happening is your attorney will speak with the state, you know, after he's reviewed your case, because he may say this case needs to be dismissed and you don't want to plead to something that should be dismissed. Or he may say, okay, let's see if we can work something out. You understand?
Yes.
All right. Do you have any family?
Yes.
Have they been visiting you or calling you?
No, I've been contacting them.
Okay. So have they been answering your calls?
Yes.
All right. How old are you?
25.
Okay. All right. So what's going to happen, Deputy Laura, they're going to take you back. And then what will end up happening is I'll make sure that we get in touch with your attorney, because if he wants you brought over sooner than September 30th, we'll bring you over sooner. All right. All right. Have a good day. Okay. All right. 2 seconds and then I'll be ready.
I love it.
I do too.
Yeah, the eyes will
Yes,
follow you.
That's all I'm saying, man. It's weird. No matter, it's the same being in trial with them, like.
Okay, it's gonna be Kruger and then it'll be Igu. All right, Mr. Kruger, come down. All right, we are back on the record in 2023 CR 10268 and 2024 CR 3168, State of Texas versus Joseph Kruger. And if the parties could re-announce for the record, please.
Adam LaHood for the defendant, Your Honor.
And are you Mr. Kruger?
Yes, ma'am.
All right, in each of these cause numbers, the defense has filed a motion to set bond. State, have you had a chance to review the motions?
Yes, Your Honor.
All right, defense, you may proceed.
Yes, Judge. I believe we have an agreement, if the court is inclined to follow it, between the defense and the state. You said, is it 20 and 25 injured?
20,000 on 2023 CR 10268.
I'll slow down. So on what case?
2023 CR 10268.
And what's the amount?
20,000.
Okay,
For CR 3168. 25,000.
all right, and that's what you're requesting?
Yes, Your Honor.
All right, is there a reason why he doesn't have a bond?
He got rearrested towards the beginning of the month. At that time, that's what triggered the remand without bond. He has a bond on the new case, but he was remanded without bond on these cases.
All right, and what's the new case?
It's an evading arrest in a vehicle. I don't know much about it. I think Discovery just got uploaded this morning. I haven't had a chance to really review it, but the allegation is for evading in a motor vehicle.
All right. All right, Mr. Kruger, I have a few questions to ask you. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Judge.
All right, you can lower your hand, state your name for the record.
Joseph Krieger?
All right. Do you have any type of employment?
Yes, ma'am. HVAC, I do HVAC work and I'm already lost it now. I haven't had no communication with them. Joe only called
I'm
collect.
sorry, I can't hear what you're saying.
I have no communication with my work employment. I had no access to the phone numbers. Jailers won't give me no phone number for me to call. My phones were thrown in the back of the trunk of my vehicle. I was very disrespectful, handed as a citizen. As the video showed, I was asking them what I do wrong.
No, here's the thing. My question for you is,
I have a job.
do you have employment? Yes or no?
Right now, I don't know. It's up in there because I've been locked up for 3 weeks now.
If I may clarify something, Judge, before you were arrested, were you working?
Yes, sir.
Where were you working before you got arrested?
Blanco Heating and Cooling.
Assuming that you didn't lose that.
Sorry, what?
Blanco Heating and Cooling in
But-
Blanco, Texas.
Yeah. Assuming that you weren't terminated because of the arrest, is that your intention to go back and work for Blanco Heating and Cooling?
Yes, sir. To plead, if I lost my job, to plead back for my employment.
Okay.
Have you ever used any drugs?
In the past history, yes, ma'am.
What?
Marijuana, cocaine back in the 90s. Marijuana was my thing back. Got to speak in the court a couple of times, and I was straight up with you about it. But I haven't done it since I got my job. And I was doing side jobs here and there before I got the Blanco Heating and Cooling job. But I'm clean.
Any mental health issues?
No, ma'am.
Ever been diagnosed with mental health issues?
No.
All right. So I don't know the circumstances behind this case, but if he's working HVAC, I don't think he should be working inside people's homes. So is the primary work that he does outside the home?
Commercial, residential, but I have my license. Got that when I was in federal prison, ma'am.
All right. So based upon his charges, I don't think anyone would want him working in places where he has the potential to have access to documentation.
Yeah, so thought, Your Honor.
Yes.
My thought is that if I understand correctly, Mr. Kruger was performing these tasks while he was previously on bond.
For evading, I think, and for these two cases.
Well, just at least for the fraud and the two fraud.
That would be my understanding. It's the evading came at the beginning of August, so he's been more or less, well, he has been locked up since that date.
And these
2001.
two cases are 3 and 4 years old. So while I understand the court's concern, it does seem a little bit like closing the barn door after the horse is already asleep.
Well, what I can say about closing barn doors, sometimes I'm not the person who opened the door. Whoever gave the conditions left the door open. And so sometimes I see it as my duty to close it. What I can tell you is that as part of your conditions of bond, I'm going to order that you let employers know what you're charged with. And you're gonna have to do it in writing.
I was in a vehicle, rental car, not my vehicle. I don't know whose car that was.
No,
We'll talk about it.
I'm just doing strictly with this. I don't know the facts of your case. Nobody has presented any facts of your case to me because I guess people don't want me to know what the facts of your case are. But what I'm just telling you, based upon what you're charged with, I don't think anyone would want you working in a position where you have access to identifying information. If this is commercial, if you're only working outside, then maybe you don't have access to identifying information. If it's
True.
somebody's home and you're working outside, and maybe you're never coming inside to get access to identifying information.
Residentials that we do, ma'am, it's brand new homes. There's no residents living inside there.
I don't think you should be inside a home, period.
Right.
So I don't know, counsel, how do you want to address that?
And it's certainly within the court's discretion as far as what conditions he'd want. I would tell him if it's not to be within the home, if he does work on the commercial basis, it would have to be exterior of the buildings. I know HVAC units are on the outside on the roof
Yeah.
or things of that nature. And I'll make sure, like I said, he notifies in writing. I'll even draft a letter for him to give, explain the charges that are pending.
Okay. Then, and the cause number ending in 10268. I'll follow your agreement. Set your bond at $20,000. There's to be no employment. Within residential homes. Or inside commercial buildings. Which are occupied. And there is to be regular, random UAs, waive fees. And in the cause number ending in 3168, I'll follow your agreement. And set your bond at $25,000. There's to be no employment within residential homes or inside commercial buildings. Which are occupied. All right, your jury trial is scheduled for November 4th.
Yes, I believe that's correct, Judge.
All right, and was he given a reset form at the last time?
Yes, ma'am.
Okay.
We signed, we had two, it got a little confusing. We had two reset forms though, one for today and then one for the 4th of November.
Okay,
And both dates show up on Odyssey if you look at them.
yes. Okay, you'll be back on November 4th for your jury trial.
If you get out.
All right, good luck to you.
Is I want to get you a business card when you get out. Just get in touch with me, okay?
Yes, sir. Thank you, Judge. You
You're
have a good-
welcome.
Hang on. Oh, here's my right. That's all I need. That's fine. Not hard to find.
Hello, just 1 second.
No, ma'am, it's, yeah, 25,000 and 20. Yeah, my card. It's all in the system. Yeah, you're good. Yeah. Yes, sir. Yeah, I'm gonna turn it on.
I would hire you 100%.
Oh, is that Bear Tree? I'm sorry.
I would hire him too if needed. And I would hire you if needed.
I would find you out, he would represent you.
Oh, thank you. And I would make sure I would show up for court ahead of time. I'd be on time. All right. And Adam, if you want a copy of that, they can have you take a photo of it.
I'll be all right. It's in the
Okay.
system.
Oh, the system is not to be trusted.
I was gonna say,
Tune in right now.
I'm waiting to hear back what we're doing about directives, because directives aren't attaching their money.
Oh,
But
boy.
as soon as I.
Isn't the whole
get-
thing down?
Yeah, well, next week when everything's shut down, they should just pull the plug and restart all over again. Because nothing works.
No.
Well, I have a very particular problem right now.
What's that?
It's creating warrants that are not attached to cases.
Oh, that's fun.
It came from the city mag.
City mag.
Yes, and I have to wait for them to go into shift. I called Tony, he told me to call Ben.
What city mag do you want?
2 different clerks. I don't think they meant to. I think something went wrong.
Well, you know, there's a defense attorney that got appointed to a JP court case this morning, right? I'm not joking. It was a client, they picked up a speeding ticket and it said you're appointed to represent them on a speeding ticket.
I mean, this is the second time that's happened to this week.
I don't know. Good luck with that. Thanks, Andrew.
I have to now make sure I put everything in Odyssey. Okay.
I'm praying it stays there.
Oh, gosh, yes. If it doesn't say there, I'm gonna be very disappointed. Because the system moves so slow, it takes a while to put it in there.
You can also access it on client.
I know where to find it. Just don't know where it's called.
Fair enough.
No, find it.
Are you talking about involvements for September 1st, 2023 or after September 1st, 2023? Because there are different versions of the offense codes depending on the offense.
No, you're right.
Yes.
Judge, we were on the record.
Yes, it was.
Actually, I have to go with whatever.
Yes.
Judge, may I approach?
Yes.
This is purely just for your reference in case I have to address it later.
Okay.
It is a very new indictment. It has not even had a proper setting. I don't even think you have a file. It just came out a couple of days ago.
All right.
Bonds have been posted and cleared. For some reason, City Mag created 2 warrants that are not attached to any cases spontaneously yesterday. I am trying to undo them. The
All right.
reason I wanted to apprise you was because this defendant is set to report to pretrial tomorrow.
Mhm.
And the pretrial officer was actually the one that said, hey, he's been really good. I see 2 warrants that he didn't have last week, just letting you know. I would be hopeful that before any kind of warrant was signed, that they would send a violation report to you, so you can have some context perhaps, and I could
Well, I
approach.
will tell you, pretrial services, whenever they send a violation report to me, I send them an email and ask them if the person is still in compliance
Excellent.
and non-compliance. And if they say no, then I have Norma set it for hearing.
Understood.
Yes.
Okay, it's probably we're probably gonna forget, but just in case, the defendant's name is Christian Ruiz.
Christian what?
Christian Alan Ruiz Garcia.
Okay. It's here.
I don't remember. I don't remember.
Oh, it's up here.
I'll just say incorrect warrant created at MAG and it'll come back.
It's a steel trip.
I am doing everything I can to fix it before his reporting date tomorrow.
Okay.
Thank you very much, Judge. I'm sorry.
Welcome. No
Thanks,
problem.
Jen. Thank
All
you.
right, can I see the file on Della Garza, please?
2 different clerks. It's gotta be a mistake. It's gotta be.
It's Bridget Garza's client,
something.
Dela Cruz. Yeah. All right. Dela Cruz, come forward.
How you doing today?
Oh, I'm doing fine.
Judge.
Pretrial services says you're not reporting to them. They haven't had contact with you.
I have been. I actually just got off the phone with, I forgot what his name was. I think it's McCoy.
Mm-hmm.
Mr. McCoy. Yeah, he said he's gonna send you a letter and everything to clear everything up. Cause I was leaving, they had another officer that I was supposed to report to. I was leaving messages on both ends. And then I also emailed them as well. And then he says he's gonna send a letter. I think that was either Monday or Tuesday. And then I know I don't want you to repeat yourself, but I know you did say that's not the same with reporting to your bondsman, but I have been reporting to my bondsman as well.
All right. What I'm going to do is I'm going to send an email
Yes, ma'am.
to pretrial services and have them zoom in.
Okay. Yes,
All
ma'am.
right. So just have a seat and
Yes,
we will take it up.
Thank you.
You're welcome. All right, Ms. Garza, as soon as they zoom in, we'll take it up. Michael Egu.
Judge, Mr. Ugu has a warrant and had been wanting to surrender him tomorrow. But I understand the court's not going to be here. So I filed the motion outlining what's going on with Mr. Ugu health-wise. So that the court would consider setting a bond on him. Attached also is the MTR, Judge, and I believe that there's a mistake in the MTR in that the allegation of the new number one is the 2023 offense prior to his being placed on probation. And I did provide a counsel with a copy of the information, but I don't know what happened to it.
All right, so if you all can find that, because the new number one.
I'm sorry, I have it.
They have the date as August 8th, 2024.
Yes, Judge, and I believe that's incorrect. I believe it's a July 2023 offense date, Judge.
All right.
I pulled a copy of the.
If you all want to look at that to see if you want to.
Apologize for interrupting, Your Honor. I'm looking at it right now, and the information in cause number 2024 CC 735522 alleges an offense date of July 22nd, 2023, which does seem as though it would predate Mr. Ugu's placement on supervision.
Okay, and that's family violence, correct?
No, Judge.
Is it or no?
It is not.
That I do not know, Your Honor.
All right, then it seems to me that maybe you all should speak with probation. Because he's on probation, correct?
He is, she's on.
All right, so you want to speak with probation?
Certainly.
All right.
Whatever the court wants. Well, I don't, I said, maybe I have one copy for probation.
Okay.
Well, thank you, Jen.
You're
I'm a
welcome.
little off today, Jen. I apologize.
All right. Oh, you're excused. And Jennifer, Rodney Brown isn't here. So you can go ahead and put that in the system.
Yeah.
Yes. And can I see the file on Arnold Garza and Francis Medina? Yes. Actually, you can just give me the remainder of the files. Okay. Let me see if I have it. No, I do not.
I think she was one of the people.
Okay, I am
On
looking.
that one, Judge, they're gonna plead in misdemeanor court, so they're holding off on the pre-indictment, they're gonna get away with it once she does the misdemeanor. And Medina, Francis Medina.
Okay. So when are they planning on doing that? Daniel, what is happening on Francis Medina?
Judge, what's happening there, they're leaning on all of the cases in Martin Court. And then it's gonna be evaluated for us around the court on custody. We were told by the CLO in court next door that, in order for her to be evaluated for us around the, I have no idea. I checked with it.
Okay.
We don't.
All right, Miss Medina, come down.
That's the only. What's the one percent we don't have?
Hello, you understand what's happening?
No. I wanna say that's a big-
All right, so they're saying that you're gonna be taken to misdemeanor court and that they're gonna have you evaluated for Esperanza Court, which is a treatment court.
Yes.
And if Esperanza Court accepts you, then this case will be dismissed. Is that correct?
Because she's still in the States, it's just this remain open.
All right, so this case is a drug case? All right, so do y'all have the labs? So why are we not just doing that here and then I can order Esperanza Court?
That was one thing that we put forward. And that could be a possibility. I think the issue is that, when this community CLO's concern is that if we were to do that, the evaluation wouldn't happen because he's got approaches.
No, it'll happen in custody. So Ms. Ferguson, if you can have Anita Garza come back here. All right, we'll take care of it today.
Thank you, ma'am.
You're welcome. Arnold Garza, if you can come down.
Hey, Your Honor, how you doing?
Hello, how are you doing?
I can't complain.
All right, just give me one moment.
Yes, ma'am.
All right, Mr. Dela Cruz. Officer McCory. He's connecting to audio.
Okay.
Hello, Officer McCory. You're on mute.
Oh,
Hello.
hello.
Hi, thank you so much for zooming in. I appreciate it. We're here on Mr. Dela Cruz. Have you had contact with him?
Yes, we actually spoke and completed our orientation on the 22nd.
All right. So is there anything else that he needs to do? Do you have all of his correct contact information?
Yes, I do.
All right. And you have his contact information?
Yes, ma'am.
So this is the officer you will be in contact with for your pretrial services?
Yes, ma'am, going forward. I also received a text as well today to contact you.
All right. And so pretrial services is different from showing up to court and different from what your bondsman, because
Yes, ma'am.
maybe your bondsman will just know about your court dates,
Yes, ma'am.
but not about this. You understand?
Yes, ma'am. Yes,
So
ma'am.
make sure that you stay in contact with them.
Yes, ma'am.
All right. So Ms. Thank you so much for zooming in, officer. You're excused.
Thank you.
All right. So Ms. Garza, on this case, have you received any of the discovery?
I have not.
All right. Ms. Ferguson, recall this in 30 days for discovery. All right, so we'll be back on September 30th.
Yes, ma'am.
At that time, your counsel will let me know she's received all of the discovery.
Okay.
Do you have any questions?
No, ma'am.
All right, once you sign the reset form, you'll be excused. Thank you for dressing
Thank
appropriately.
you. I appreciate that.
All right, just have a seat and Ms. Ferguson will call you up with the reset form.
Have a
Excuse
blessed.
me, hold on a second.
Yes.
Mr. De La Cruz,
Yes, ma'am.
I need to be able to contact you personally.
I know I'm getting all that situated. I do apologize.
Okay.
It's been a little rough these past couple of weeks.
All right, I need to
I'm
be
getting
able to
situated.
contact you.
Yes, ma'am.
All right.
Okay.
Do you have
Thank
her
you.
number?
Yes, I do have her. Yeah, I got everything in mind.
All right, and you have her email and everything?
Yes, ma'am.
All right, so
All right.
this is what you need to do. You need to text her, you need to email her your information,
Mhm.
because it does no good to have an attorney and you're not in
Yeah.
contact.
No, I understand. I understand. It's just, it's a lot of stuff on this.
All
side.
right, you
Yes,
got to
ma'am.
put it on the calendar, okay?
I will. Yes, ma'am.
All right, thank you.
Have a blessed one.
All right, you too.
Thank you.
You're
May I
welcome.
Excuse, Judge?
Yes,
Okay, thank you.
you're welcome. Bye-bye. Still can't believe y'all had me watching The Worst Ex. And that was a true story.
It is a true story. We were not done, Judge. You just cheated. You went to the clip notes.
I did.
Yeah, for sure.
Yes.
They're gonna withdraw the NTR.
Okay.
We'll finish it.
All right. Ms. Abrams, on this case, are you all going to be able to address his issues?
Yes, Judge. I'm going to speak with the officer.
Okay. All right.
Oh, I'm sorry. I'm
Judge,
sorry.
here's with Bridget.
Yes,
It's system for the 17th. I'm gonna leave the 17th or change it to the 30th.
change it to the 30th. Gotta give them time to get discovery.
Thank you, Judge.
You're welcome. You still want your bond heard?
No, Judge. Thank you.
See, I knew, there are thoughts that are happening. Once I knew that the new number one was gone.
I appreciate that, Judge. Thank you.
You're welcome.
Judge, Anita said she can submit it.
Yes.
Sit down.
Did you put your email?
Yes, ma'am, at the bottom.
Is there anything else you're waiting for, Tony?
Just gonna get a copy, just,
Okay.
question.
You may want to take a photo of it.
That's what I was
because we
thinking.
have, I handed it to them.
Okay, I appreciate it. Thank you.
Oh, you mean the motion to withdraw?
Yes.
She has it. so
Oh, I'm
she'll-
sorry. That's nice. Thank you again, Judge.
You're welcome. Have a good one. All right, Deputy Laura. They have a warning out. CDC warns against eating recalled deli meats. Fatalities rise. So I don't know what that's about.
I think it's forehead cat features.
Oh. And there's a new species
Thank you.
in marine life. Okay, have you ever heard of a Casper octopus? Looks like Casper the ghost, but it's an octopus.
You could give Benjamin extra bench.
Oh, has everyone signed the card for Norma Laura? I'm sorry, not Norma Laura. Sorry, Norma. Norma Nero.
I have not.
Okay.
What is this for?
The interpreter is retiring. Whenever you all are ready, just let me know.
I'm ready, Judge.
Okay. And your client is Mr. Garza?
No, Jesus Trevino, Judge.
All right, could I see the paperwork on Jesus Trevino or his file, please? I think so. So how's it been going?
It has been going very well, Judge.
And the traveling Garcias?
The traveling Garcia, I can't complain.
Yeah.
Because I did the Camino. Listen, Judge, it was life-changing.
See, I need to do that. So how was the?
But you have to
walk?
go for a while. You know, you can't just go for the last, because then it's like not so hard and you're like, ooh. But if you do a little bit longer, it's so exhausting that you're like, when you finish, you're so proud of yourself. And plus you go, my God, home is my cheese.
Yeah, but you know what, too? I think people have told me it's sort of like a spiritual awakening. You know, when you get to sort of commune with nature and you really see
Yes.
what's what.
And then doing it with Jude, it's like, I would cry about that one. That's like so lucky.
Because my mom always would tell us, well, still tells us, you know, God's taking care of birds and plants. You're going to be fine. He'll take care of you. So I'm like, you know what? You're right. And you know, the birds are happy. They're chirping.
Yes.
So
You're
surely.
right. When we get nervous or something, you're right. I didn't even think about it. How's she doing?
Oh, she's doing well. So I want to go back and see her next week.
Always tell her I send a love.
Okay, I will. She's always, is Richard doing crazy
Yeah,
things?
that's not Richard.
She says, Richard, she's like, Stephanie, Richard, he's always doing things where he has his foot on a banana peel next to an open grave. She's like, stop doing dangerous things. She's like, it makes my heart races.
Like, it makes mine too. And he's always like, you're like, oh my God, then what is it? You know?
When he was telling us he was driving on the narrow roads and then a diesel's headed at him, we're like, Richard. Because Richard, I mean, my mom always considered you and Richard part of her children.
I know.
She's like, why must my children be doing dangerous
I
things?
don't post anything. I don't want anybody to know because like my dangerous things, I'm like,
So then my mom will say, and I thought it was only my son, Richard. Now I see my daughter Teresa's doing crazy things.
I know. She's so cute.
All right. Jesus Trevino, if you'll come down, please. So Teresa, on this one, we're awaiting an evaluation.
Well, the evaluation came through. Tomorrow we have our hearing.
Okay.
And so then after that, I think we'll be good to go.
All right. So do you know what they're saying the results are?
Well, they're saying that he is competent. And so we have to.
All right. So what I'll do.
I was thinking of, I was almost thinking about getting a second evaluation, but you know, in talking to him throughout all the months and stuff that I've had him as my client, he does sound much better. So it might be correct.
When do you want him brought back here?
Here. Well, I don't know, 30 days.
I mean, we can do.
Because he's got so many cases.
Oh, how many cases does he have?
He has a few, Judge. Let me get my phone just for my phone.
All right, I'll be able to look on our docket sheet. Let me see.
I think some just got cited.
Well, he does have an evading. And a
Right,
theft case, and then he has a drug case less than a gram.
right. So I don't know if all of them have been indicted yet,
Mhm.
or just some of them, or,
All right, how about this? I'll recall it in 3 weeks to see where we are.
okay.
All right, Ms. Ferguson, can I have a 3-week reset on Trevino, please? You know Jimmy Allison is retiring.
No.
Yes, they're having something for him today at, let me see, I want to say it's at 3:30. And they want us to line up on the civil side to see him off.
Oh, that's so nice.
So-
So this could be next door or what?
Yes, and it's on I'm assuming it's on the first floor. And then the interpreter, Norma Nero, is retiring.
Norma's retiring too?
Yes, and they're having something for her at 4:30 at the Gavel.
Oh my God.
That's right across.
The luck of people who have worked. It's like-
All right. All right, we'll be back on September 19th.
Thank you.
All right, is that good for you, Ms. Garcia?
Yes, it is, Judge.
All right, we'll see you back on the 19th.
Thank you.
You're welcome.
Have a seat, sir.
Okay. We'll go from there. All right, Judge, thank you.
All right, have a good one.
You too.
I'm gonna try to get my mom to Italy, so we shall see.
Oh my God. If you go to Italy, if you go to Rome, I'm gonna give you the name of this little family-run restaurant. It's inexpensive, but it's the best food.
Okay, you have to give that to me because we're gonna eat our way through Italy, but I also want her to see the Vatican and everything.
Right. So this is in Rome. And many years ago, I was with some friends of mine who were like, they are UTSA professors and they had some kids. And we were traveling, just walking, and we found this restaurant. We're like, oh, let's stop. Oh my God, Judge, delicious. So when I went back with Jude, I'm like, Jude, I'm going to take you to my favorite restaurant. And it was out of this world.
Okay,
Delicious.
you're gonna have to give me the info and I'm gonna tell them Teresa sent me here.
Yes.
Everybody will know you there.
Daniel.
Picture.
Okay. All right, have a good one.
Okay.
No, it's a less than a gram. That's what it actually is.
Because on the docket, it has possession 1 to 4.
That's what it was initially charged at, but then the weight came back.
So on the docket, and it honestly, it's still 1 person.
And Ms. Perez, just give me a moment.
And Judge,
Yes.
I don't know how to do the waiver.
Okay. All right. We're gonna walk ourselves through it. Let me see.
Well, it's just one case, so do I print out my out? Yeah, it does. No, no, no. I mean, no, no, it's just like, that is not like that. I don't think so.
All right, so Ms. Perez, on your case, the state informed me that there was going to be a plea on this case, but that this felony case needed to remain open so that she could be reviewed for Esperanza Court.
That's correct,
I
Judge.
can hold her for Esperanza Court, so that's not a problem. So they're gonna send you paperwork and we're gonna take care of it today.
The problem with that, Judge, is that Esperanza Court, I believe, I guess Judge Vara spoke to the director, Natalie, I believe, and she stated that she will be released if she pleads out on both cases, and so that's not,
Not
No.
if I put a directive in that she's to be held until interviewed by Esperanza Court, she will not be released. So Esperanza Court will be able to interview her at the jail. But I'm not going to have this case out here if the whole purpose is she's gonna plea on this case also, but we're just afraid that they're gonna release her. She could make bond on this case, then she'll be released anyway. So we'll
That's
do the.
correct, Judge, but I guess the other issue is that this case is still unindicted. I had Norma set this case so that we could confer because we kept getting reset on the misdemeanor and there was already results back. And so there is not an indictment as well, so.
Oh, that's why they do it as a waiver plea.
I don't know, Daniel, it's up to you. I mean, can I confer with Daniel real briefly, Judge?
Sure. I'll put you in a waiting room. Yes.
said that you found.
Oh, okay, I'll wait till she finishes.
Okay, Judge, I'm back. So I spoke to Natalie Perez from the Esperanza Court and I was on the phone with her. And she does say that she does want another order of referral, even though the County Court 15 did one for her. She said that we'll probably have to do another one. So I don't know if I can fill that one out and I just email it to the court for them to sign.
Oh, you all just do the plea bargain agreement and then I'll take care of that.
You'll fill it out?
Once you all enter your plea, then I will take care of that.
She gave me the form for me to fill out so I can email it to the court.
No, you all need to, are you all entering a plea on this case or is this case going to trial? That's my question.
Well, I'm comfortable, Judge. I just want to make sure to let my client know that this is going to be for a longer term before we sign anything.
My understanding is that you all had already talked about a plea bargain agreement. Where is your office, counsel?
Right now, I'm at my home office, Judge. I'm not there right now. I'm not
All
down
right.
anymore. I'm like 30 miles away.
All right, so we'll wait for you unless y'all can do the plea by Zoom. So it's completely up to y'all, whether y'all want to do it by Zoom or you can come back down.
I think Daniel said that he had prepared the paperwork.
All right, then you need to come back down and take care of your client's case.
So she's not allowed to execute the documents electronically, Judge?
Okay, so here's the thing. I don't understand why people are leaving court before seeing me, but we are where we are now. And where we are now, if that paperwork cannot be produced by the state because there's been some issues, then you're going to have to come back down to take care of that. So that's where we are.
I mean, I guess that's fine. Judge. We don't need that paperwork because we've already got it in County Court 15.
All right, so here's the thing. County Court 15, which I think that judge is great. I think County Court 15 is great, but this is the 187th Judicial District Court. District Court takes precedent over misdemeanor court. I don't know why there was some sort of an agreement where people were like, oh, she's going to plead to the misdemeanor case, but then she's going to come back and plead to the felony case at a later date. We are taking this felony case now. Whatever County Court 15 is doing, that's their jurisdiction over misdemeanor cases. I'm in felony court. Felony courts takes precedent over misdemeanor court. So here are y'all three choices. One, state, are you able to do the paperwork electronically?
Judge, I can. It's the thing, again, confirming with defense that the agreement that we talked about in County Court 15 and for this case is that the agreement that they're going.
All right. So
what? I didn't hear what he said, Judge.
All right. So what he's saying is that you need to come back down to the 187 District Court and we'll wait for you here. All right. You're here on your case?
Yes, Your Honor, we reached an agreement. So we're ready to go whenever recorded.
All right. So who is your client?
Mr. Arnold Garza right here?
Arnold Garza?
Yes, ma'am.
All right. And then after this, I'm going to go next door to see Mr. Allison off. I hope I have not missed it. Court is calling 2022 CR 7734, State of Texas versus Arnold Garza. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Leland McCray on behalf of Mr. Garza, who's to my right.
And are you Mr. Garza?
Yes, ma'am.
All right. Did you all do a trial court certification?
I did.
Thank you. All right. Mr. Garza, did you review the document entitled Motion to Revoke Community Supervision with your attorney?
Yes, ma'am, I sure did.
Did you understand it?
Yes, ma'am.
Are you the same Arnold Garza who was placed on community supervision in 2022 CR 7734 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on May 9th, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
State?
In Bear County, Texas, the defendant Arnold Garza did then and there failed to report to the supervision officer as directed
for the months of June and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State and the other violations?
Waive and abandon the remaining violation allegations, Your Honor.
Any objection?
None.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 6 years in the prison and a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes.
Yes, Your Honor. Revoke supervision, judgment, and assess punishment of confinement at 3 years, Your Honor, in the penitentiary.
Is that the agreement?
Yes, ma'am.
Mr. Garza, are you asking the court to follow that agreement?
Yes, ma'am. I should.
Are you waiving your right to appeal?
Yes, ma'am.
All right. Probation, do you know if the lab testing for SAPD, if that fee was paid?
It was not.
It was not?
It was not.
All right. Do you have amount?
Judge, I actually don't have an amount.
All right. All right, the court will follow your agreement, grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's to be restitution to SAPD for laboratory testing. Showing you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, ma'am. I should do.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am. I should do.
All right, we can go off the record. How old are you?
At 40.
All right, 10 more years. You're going to be on the downside of your life unless you're expecting to live past 100.
Yes, ma'am.
Maybe you will. Who knows?
Yes, ma'am.
You're going to have to change your life.
Yes,
If you don't, you're going to end up living in prison.
I understand that.
All right. Good luck to you.
Thank you. You have a good day, man.
You too. All right, so I'm going to take a break, everyone. I'm going to go to this retirement celebration with him, and then I'll be back and.
All right, we are back on the record in the matter of the people of the state of Michigan versus Randy Kiefer. So, Mr. Murphy, you would ask to speak with Mr. Kiefer. How would you like to proceed today?
Your Honor, at this time, I'll just ask if we could enter a not guilty plea on the contempt for the failure to appear in the drug test.
Mr. Murphy, I have no idea what's going on with your audio. I heard you say you'd like to enter a not guilty plea, and then it was garbled.
And then we would ask again just to enter a not guilty plea and set these for a pretrial along with the underlying case. I know that we had a pretrial that was that Mr. Kiefer admitted, which send the contempt, but I believe that we'll have this case resolved. I need to speak with Mr. Kiefer about the circumstances involving the contempt, but he is aware that if Honor would give him a PR bond on the contempt, which is what I'll be asking for, that he has to.
All right, so you're just asking for an adjournment?
Yes.
Okay, Ms. Adams, I know that I have no available pre-trials on the 5th or the 19th. Do I have any spaces available on July 26th?
You have 18, not including arraignments.
All right, August 2nd.
Yeah, 15, not including arraignments.
That would work. So August 2nd, Ms. Adams, I can't.
Yeah,
I'm
you
getting a lot
have,
of.
you have 15 that morning.
Okay, so that's not bad. All right, I'm just kidding. So we'll set this over for a pre-trial on August 2nd at 8:30 in the morning. Mr. Murphy understand that if you're able to reach a resolution on Mr. Keeper's case, just let us know. We'll get you in any other day than a Wednesday.
Yes, Your Honor.
All right, so Mr. Keeper, your bond's continued, and we'll see you back here on August 2nd at 8:30 in the morning, all right?
Your Honor, would you be willing to address bond at this time for his contempt?
I can't hear you. What?
Would you be willing to address bond on his contempt?
You can file a motion.
Yes, Your Honor.
All right. I mean, he's here on a contempt of court for failure to appear and for drug testing. So, you can, I mean, I'm not going to release him.
Yes, Your Honor.
But if you want to file a motion and set out a basis, I will obviously hear that. All right.
Thank you, Your Honor.
Thank you. You're all set, Mr. Keeper. Could you tell them I'd like to see Mr. Rose?
Yeah. Mr. Rose.
All right, Mr. Seeley, I'd like to apologize. For some reason, our Zoom is acting up. Anytime I put people in a breakout room, they come back with no audio and no video. So I had to disconnect you, so I appreciate your patience, all right? It's not us, though. It seems to be the device itself. So, Mr. Malaro, have you had an opportunity to speak with Mr. Seeley?
I have, Your Honor.
All right. Mr. Seeley, have you had an opportunity to read and review the pre-sentence report?
Yeah, I don't fully understand what's going on, but yeah.
Okay, no, that's important. So you don't fully understand what's going on. What are your questions?
I don't understand why if I get sentenced today, my time don't start today.
Okay, so we had a discussion about that as a bench conference as well. So under the laws of the state of Michigan, if you're on parole at the time a new offense occurs and you are serving time on that original offense, and so we went through this. So on the offense date for this charge that we're here for sentencing on today was September 1 of 2020. Okay, you got that?
Mm-hmm.
Yes.
Yes, ma'am.
Okay, on June 16th of 2014, you were sentenced in Hillsdale County on a home invasion second degree, right?
Of what year?
June 16th of 2014.
Yes, ma'am.
Okay, and would you agree June 16th of 14, when you were sentenced, was before the date that you're currently here on today for, right?
Yes.
And you are currently serving a prison term for violation of your parole on that home invasion second degree out of Hillsdale County, right?
No, ma'am, I'm serving on possession of meth and CCW. The home invasion got ate by the new charges. What was left of the home invasion, because it was possession of meth and carrying concealed weapon, there were still 7.5 years left on the home invasion. So what they did, because I'm a new bit, they took that 7.5 years and added it to what I'm serving on now to the end of it. So instead of a 15-year tail for the possession of meth and CCW, I have a 22.5-year tail for possession of meth and CCW. My paperwork does not show that I'm serving on home invasion anymore.
Okay, let me look here. So your sentence will run concurrent with the carrying concealed and the possession of meth charge. Do you understand that? It'll
Yeah,
run
which is
together.
what I'm serving on right now.
Right.
The only, because if this doesn't run all consecutive or concurrent, then I would have to do until 2044, because what was left, like I said, of the home invasion got put on the end of this. The new charges ate the parole violation. So in order for this to run consecutive, I would have to do until 2044 for these charges to start.
Okay, so Mr. Sealy, I am very limited by what the law allows, okay? You will have, let me finish. So when I look you up right now, it says you have 3 active sentences. It says you are serving 1 year to 8 months to 7 years, 6 months on the carrying concealed. You are serving 1 year, 8 months to 15 years on the possession of methamphetamine. And it says that you are serving 5 years, 11 months on the home invasion, 2nd degree. So, inactive larceny, so we are stuck and limited to decisions based on the dates of offenses. So if you are serving a sentence, and Otis is telling me you are currently serving a sentence on the home invasion. If that's wrong, it won't impact it. But according to this, it says you are. My sentence has to run consecutive to the home invasion 2nd degree.
So in other words, I would have to do. So in other words, I have to do the next 5 years and some odd months before this sentence starts.
Well, when did you go to prison on the home invasion 2nd degree?
Originally or now?
No, this time.
I don't know, June, July, 2021.
Okay, so yeah, my sentence today has to stack on that one, but you also, it will run concurrent to the carrying, concealed, and possession of methamphetamine. So you shouldn't be serving time yet on the methamphetamine and carrying concealed, right?
It's all concurrent. Yeah, it's all concurrent. I'm serving time on all of it right now. I'm on a flop right now because of these charges. Because of these pending charges, the parole board gave me a continuance. And as long as I have pending charges, the parole board is just going to continue giving me a continuance. So,
but Judge, if I may, once as I understand this, once he's sentenced here, then he begins the parole, he enters into the parole process again. Now, I'm not exactly sure how all of that works out, but if he's accurate and he's done with his home invasion, then he would immediately start getting credit for these cases because they would run concurrent to the drug charge.
but here's the thing. If I get a parole on one, I get a parole on all of them. They're not, when it comes time for me to parole, I'm not paroling on one or the other. If they give me a parole, they give me a parole on all of
Mr.
it.
Sealy, but you have no credit on my case. So whatever you get sentenced to, you have to serve. So even if they parole you on those 3, you're still gonna have to serve your time on this one.
I understand that, but what I'm saying is, what you sentenced me today isn't gonna start until all that's done.
Right.
So it's not gonna start until 2044.
Judge, just for the record, I don't know practically what the DOC is gonna do in terms of their decisions, but as soon as Mr. Silly serves his home invasion 2nd degree parole sentence, the day that's done, he starts serving this sentence.
So, Mr. Sealy, if for whatever reason, I don't know if Mr. Jones has any other information on this, but if, for example, you're on a flop right now, and once I sentence you, you're done with your sentence on the home invasion, you start getting credit on mine.
I'm not done.
But that's not, what am I supposed to do about that? I mean, that's what happens when you commit new crimes. When you commit new crimes, when you're on parole, they stack, and that's the law of the state of Michigan.
I understand this. I'm not questioning your judgment, Your Honor. I feel like I'm stuck in a loop because I'm currently on a flop. I'm currently on a continuance is the proper term for it. because of these charges pending. So
It is a cycle. I understand that, Mr. Seeley. And I understand your frustration with that because it is kind of a vicious cycle. But
So in
the
other
law
words, what you're
doesn't-
saying is I'll come home when I'm like 69 years old and have nothing left to lose and nothing I care about. It works
Well,
for me
I don't know that.
with no
that's-
supervision. Works for me.
Seeley, I
Let's
don't know
proceed.
So
that-
Mr. Seeley, when you continue to get criminal offenses, that's what happens, unfortunately. And I understand your frustration.
I understand
but
I'm
it
wrong. Can we proceed, please?
Okay,
I-
all right. So.
Let's not drag it out
have you
anymore.
had a chance to speak with Mr. Malaro and ask him questions?
Yes, ma'am.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, ma'am.
All right, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, I think we've covered everything in bench conferences and on the record.
Right, Ms. Arnold?
No, thank you, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show he has 10 prior felonies and 6 prior misdemeanors, and he has 3 current offenses he's serving prison time. Do you find any issues with those, Mr. Malaro?
I do not.
Probation Department has recalculated the guidelines, and that was provided to Ms. Arnold, Mr. Malaro, and myself. The guideline minimum range is 7 to 23 months. Do you agree with that computational guidelines?
I do, Judge.
Right. And Ms. Arnold?
Yes, I'm a criminal sexual conduct 4th degree, Your Honor.
Okay. And before the court passes sentence, Ms. Arnold, is there anything you'd like to say on behalf of the people?
If the court's inclined to follow the recommendation of probation, we don't have anything to say, Your Honor.
Okay. Mr. Malaro, is there anything you'd like to say on behalf of your client?
Yes, Judge, I would. Judge, Mr. Seeley, I think is kind of sort of alluded to, the issue he has to face and deal with. Certainly, he's not suggesting that any of this is not of his own making. But I would just ask the court to consider a couple things when fashioning a sentence. That he's not getting any credit. This case certainly had some sordid details to it. But Mr. Seeley, during the entire process, was cooperative, worked readily towards a resolution. And I think, Judge, that irrespective of his history and record, the fact that he worked towards a resolution which saved these young people having to go through a preliminary exam and a trial should, in my request, that the court consider, carry some weight in departing, or I should say not departing, but not following the recommendation of the probation department, or the probation department. And so, Judge, I would ask the court to consider either sentencing on both cases to the minimum, or somewhere below what the maximum which is recommended. Because having done many of these cases over the 30-something years I've been an attorney, I think there is some benefit to not having the families go through this. They have closure. Mr. Seeley has accepted responsibility for his behavior. And so I would ask the court to take that into consideration and perhaps coming off of the maximum as recommended. Thank you.
All right. So, Mr. Seeley, is there anything you'd like to say on your own behalf?
Yeah, Your Honor, like my attorney says, I accept full responsibility. I wasn't arguing that I shouldn't have committed more crimes while on parole. I fully agree that you're right in that. I did a crime, I'm gonna do the time. I'm not arguing that. I was just confused on why I didn't start now. I've never had this happen before, but I've never committed a crime on parole before. So, as my attorney said, I don't want to drag anybody through any hardships or, depression or stress. I've gone through it all my life. So I don't want to drag anybody else through that. I'm just trying to get home as soon as possible, so, you know, I still have something worth living for. I'm almost out of everyone and everything, so I guess I'm at your mercy. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. So, Mr. Seeley, you have 10 prior felonies, and you've spent a great deal of your time in prison, as you mentioned. You have multiple CSC convictions, and this offense was committed while you were on parole. And I know it gets confusing and it's kind of convoluted, but we do look at date of offenses. I don't think the recommendation is out of the ordinary or over the top. So it is the sentence of the court that on count 3, casting children for immoral purposes, you will serve 2 years, 5 months to 4 years with the Michigan Department of Corrections. And count 6, criminal sexual conduct, 4th degree, sentence of the court that you will serve 1 year, 4 months to 2 years with the Michigan Department of Corrections. Those sentences will be concurrent to each other. They will be concurrent with your current charges out of Jackson County, which are carrying concealed weapon and possession of methamphetamine. But because you were on parole at the time this offense occurred, your sentence would be consecutive to the time you're serving on the home invasion 2nd degree out of Hillsdale County. You will pay $130 crime victim rights fee and $136 in state costs. You would have no contact with the victims with the initials AB, KG, and the other KG. You must remain active on the Michigan Sex Offender Registry for life. Mr. Jones and Miss Arnold, we determined there is no requirement for lifetime electronic monitoring on these counts. Although you may have to for other prior offenses. So, Mr. Seeley, we are going to send to the Michigan Department of Corrections, to the caseworker there, 3 copies of your notice of right to appellate review. 1 copy will be noted for you to initial and date, and then they'll send that back just so that we know that you received it. The other 2 copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, or give it back to the caseworker. Okay?
Yes, ma'am.
All right. I wish you the best of luck, Mr. Seeley. Thank you.
Thank you.
Thank you, Your Honor. Thank you, Mr. Seeley.
Yep.
Yeah, I lied about it.
And Mr. Rose from MDOC.
Judge.
Yeah.
I have Mr. Rose from the jail.
Is that ours?
I think so.
We're gonna get Mr. Rowe right now. He's officer safety for us, so it takes 2 people.
Oh, not a problem. I understand. Looks like he is a request of warrant for probation violation by Mike Stevens.
Am I needed, Judge, or I'm free to go?
You're always needed.
Yeah, right.
You're a bright spot in our day, Mr. Malaro. All right.
Is that when I get here or when I leave?
Well, I didn't say when, but all right. Thank you, Mr. Malaro.
Have a good weekend, Judge.
You too.
Third with Brandon.
Miss Adams, I did send a message to Miss Underwood, but I don't know if he's gonna ask for counsel. All right, are you down, Jack Rose?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Donald Jack Rose, file number 22-20793FH. Mr. Rose, can you hear and understand me?
Yes, ma'am.
All right, Mr. Rose, are you under the influence of anything legal or illegal that could impair your ability to understand the proceedings today?
No, ma'am, I just woke up.
Okay, all right. So Mr. Rose, we are here on file number 22-20793FH on a request and warrant for probation violation. It states that they allege that you violated the articles of your probation dated January 3rd of 2023, and that you failed to report on April 12th of 2023 or any time thereafter, and that you failed to notify, hold on a second, you failed to notify the probation agent of your change of address on or about March 17 of 2023. So do you understand those are the allegations against you?
Sure.
Yeah.
All right, so Mr. Rose, you had pled to count one, malicious destruction of personal property, 1,000 or more, but less than 20, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine. Mr. Rose, if you're not able to sit up, I'm gonna move this to Monday because it makes me wonder whether you're okay.
No, sorry, ma'am. I just had my head down. Somebody had walked in the doorway and I looked over.
All
Sorry,
right, well,
ma'am.
sit up. So, and there was initial, there was an agreement, I think a kilogram, at the time you took the plea that you would receive no upfront jail, but do you understand that doesn't apply anymore?
Yeah.
So if you plead guilty or found guilty of this violation of probation, you could be facing up to 5 years in prison. Do you understand that?
Yes, ma'am.
All right, now, Mr. Rose, you do have the right to have an attorney represent you at this or all subsequent hearings. Do you understand that?
Yes, ma'am.
If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
No.
You want to proceed today on the violation of probation without an attorney?
Yeah.
Okay.
I've never used an attorney on a violation before. I just don't, it's really just all up to you and my PO, you know?
Right, but you do have a constitutional right to have an attorney offer you legal advice or so forth. So if you want a court-appointed attorney, you can have a court-appointed attorney.
I'm okay.
Okay, now, you want to raise your right hand so I can see it, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. So, Mr. Rose, do you understand that you do have a right to contest the violation of probation charge and have a trial?
Yes, ma'am.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask your witnesses questions or ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yeah.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
All right, so Mr. Rose, how do you plead to the charge that you violated the articles of your probation by failing to report on April 12 or any time thereafter of 2023? Guilty or not guilty? All right, and how do you plead to the charge that you failed to notify your probation agent about a change of address on or about March 17th of 2023? Guilty or not guilty?
Guilty.
All right. Has anyone, do you understand that by pleading guilty, you'll be giving up the right to a trial, as I've already explained to you?
Yeah.
Do you understand you're also giving up your right to have a lawyer assist you?
Yeah.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes, ma'am.
All right. So Mr. Rose, you were placed on probation, and one of the terms of your probation is that you were to report as directed to the probation department. Is that correct?
Yes.
Ms. Underwood, he waived court-appointed counsel.
Thank you, Your Honor. I apologize for the Wi-Fi issues.
Not a problem. Everybody's having problems today. I don't know what it is. Thank you. So, Mr. Rose, and did you report typically, it looks like on the second Wednesday of every month or something like that?
Yes, I was doing video, like FaceTime reports with my probation officer.
All right. So would you agree you were supposed to report on April 12th?
Yes, ma'am.
And did you report via video on April 12th to Mr. Stevenson?
Yes, ma'am. No, I don't. I transferred my probation the day I got out to Allegan County.
Okay, so did you report to the probation officer in Allegan County on April 12th?
No.
Okay, how come?
I had a friend go to jail and they went through his phone and found pictures of me and him, and they were gonna try to like violate me for that, and they wanted me to come in person, and I just didn't go. I decided not to go because I was up north working. And so I just figured I was gonna do it over video. I was up north working, and then I told my PO that I would come in the next day, and I just didn't go. No excuses.
Okay, now, did you change addresses on or about March 17th as well?
No, I got kicked out of my sister's house and I didn't have another address to live at.
So, okay, all right. Okay, and did you tell your PO that?
No. Well, I did, and he just said that I have to notify him on stuff like that.
Okay. All right, has, all right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent he waived counsel. So Ms. Adams, I'm looking for a sentencing date next week. It can be morning or afternoon. I don't really care.
Judge, can we push that back a little bit? I'll be gone next week.
Okay, Ms. Adams, let's see, how about Ms. Adams? I'm gone the next week, Mr. Stevenson,
Okay.
so I don't think we can push it out that far.
Okay, we could try this July 7th. Would that work?
Yes. What time would work for you, Mr. Stevenson?
First thing in the morning.
All right, Ms. Adams, can I set this for July 7 at 8 a.m.?
Yeah, we play like 10-7, but that's fine.
Okay, so Mr. Rose, I'm going to set this for sentencing on July 7th Mr. Stevenson, would you like a breakout room this morning to chat with them? Just to make it easier?
Sure. Yeah.
Okay, so Mr. Rose, I'm going to set this for sentencing on July 7th at 8 a.m. I'm gonna put you in a breakout room with Mr. Stevenson now so he can do the interview because he's going next week, so we're gonna cobble this together so you don't have to wait as long. So when you talk to Mr. Stevenson, be truthful about the events that occurred and what's going on in your life. He'll prepare a pre-sentence report. Do you want an attorney for sentencing?
Dustin or me? I mean, wait. Oh, we're going to the breakout room.
Mr. Rose, do you?
An attorney at my sentencing? No.
Okay, all right. So we'll see you back July 7th for sentencing. I'm gonna put you in a
Yes,
breakout
ma'am.
room and I want you to talk to Mr. Stevenson. And then when you're done, you're done. You can go back to your room, all right? Yes.
Will that be Zoom?
Oh, yeah. And Mr. Rose, do you have any objection to being sentenced via Zoom?
No.
Okay. All right. I'm gonna open up that breakout room. So you're all, go talk to Mr. Stevenson. Thank you, Mr. Stevenson.
What is the session? Please be seated.
All right, we are back on the record. Just because not everybody was here this morning, just a reminder that each side is permitted 15 minutes of argument. My understanding is that the department and the Child's Council will be splitting time. I also understand that counsel for the mother is appearing via Zoom based on a motion she filed this morning, which we've allowed, but that you will not be able to see the timer. So I will advise you when you are running out of time. I want to remind everybody that this case is impounded, so please do not use any of the parties' names. With that said, this is the Department of Children and Families and another versus Mother and another, docket number 24P1110. Attorney Clay.
Thank you. Good afternoon, Your Honors, and may it please the court. Thank you again for allowing me to appear virtually today. My name is Kyla Clay, and I represent the mother. When a parent has cognitive impairments or limitations that affect their ability to organize and follow through with services on their own, DCF has an obligation to make reasonable efforts to make reunification with their child possible by providing services that accommodate that parent's specific needs. Unfortunately, that didn't happen here. Since the start of this case, DCF knew mother's cognitive impairments required additional services and support to help her parent her child. And DCF knew that mother needed hands-on support to access these services. But despite its statutory obligation to do so, DCF failed to provide mother with the reasonable efforts necessary to help her reunify with her child, and then blamed her for the agency's own failures. And the juvenile court agreed with DCF.
Could I ask you a question? At record A14 through 16, there's a letter from counsel to the department regarding ADA accommodations. But I didn't see anything in the docket or in the transcripts that brought this issue before the juvenile court judge. And under Daisy, aren't you required to do so, and therefore isn't the question waived?
No, Your Honor, this issue is not waived for two reasons. First, as you mentioned, contrary to DCF's claims that Mother never had, discussed the adequacy of her services, Mother did actually raise this issue through DCF, through her lawyer with DCF, well before trial. But even if she had
with the judge?
So even if she had never directly raised that issue with DCF or the judge, it wouldn't matter because of the second reason, which is that this court held in adoption of Chad that a claim of inadequate services is not waived when the parent's cognitive deficiencies and resulting needs for services were a theme that ran through the life of the case. And here, Mother's cognitive limitations and resulting difficulties accessing services were a recurring issue throughout the case from the very beginning. Indeed, DCF voiced early concern about Mother's capacity to utilize services given their concerns for her intellectual disability. And then DCF repeatedly informed the court that it was working on reconnecting Mother to DDS services and repeatedly dropped the ball. So the court had numerous opportunities through the DCF court reports and the DCF and the court investigators report to see that Mother needed certain services, which DCF was very aware of. Yet DCF was not taking the steps necessary to make sure Mother was getting those services. So the fact that Mother didn't raise the claim of inadequate services through a traditional reasonable efforts argument at trial does not mean that this issue has been waived.
But don't we have to read Chad in the backdrop of Rashida and Rashida 2 and the progeny, which talk about the parent's obligation to raise it? Chad's an older case.
Right. So there are some more recent cases that we can look at as well as, for example, adoption of Elena, where this court talked about why a claim of inadequate services normally needs to be raised in advance, which is to provide both the judge and DCF the opportunity to make accommodations while the case is still pending. As noted in Adoption of West, a 2020 case, this is so that way DCF has noticed that its efforts may be inadequate and has the time necessary to remedy that issue. But here, when the parents' cognitive deficiencies and their corresponding service needs were repeatedly a center of the case, that notice has essentially been baked in. DCF already knew exactly what Mother needed. They knew what services she needed and what would work for her, and they dropped the ball. And the judge knew as well because the judge was receiving the DCF court reports, which made it very clear that Mother needed to re-enroll in DDS services and was supposed to get help from her social worker, but her social worker failed to ensure that she completed the application appropriately. They then never provided any further updates on DDS services. They also made it clear that Mother needed, at one point they say, quote, Mother needed DV 101, unquote. And yet, throughout the entire case, they repeatedly say how much Mother needs domestic violence services, but they never discuss in the DCF court reports what they're doing to refer Mother to services or assist her in getting those services. So the court knew and DCF knew that Mother needed services that she wasn't getting.
Right,
so
I ask you, I knew Yelena sounded familiar. It turns out I wrote it. And what I say in there on behalf of the court is that while the department has an obligation to make reasonable efforts, the parent also has an obligation to substantially fulfill her parental responsibilities, including seeking and using appropriate services. So can you address that second component?
Yes. So the most important thing to note here is that Mother needed, and DCF knew that Mother needed a, quote, significant amount of support, unquote, with accessing and maintaining services. And DCF also knew that Mother would be unsuccessful at engaging in services and treatment without someone directly helping her. So the most important resource that Mother needed was help re-enrolling in the Department of Developmental Services, which would have provided her with the hands-on support she needed to both enroll in services and keep herself organized and maintain the ability to actually follow through with services. DCF knew from day one that was the most essential thing that needed to happen in order for her to participate successfully in this case. And mother did do the steps of filling out the DDS application to re-enroll in services. And mother repeatedly told DCF she wanted to re-enroll in DDS services. But she was missing a signature on the DDS application, and DCF knew this. Her social worker made no attempts, however, to help her get that missing signature. Even though her social worker spoke to her on the phone every week, all the social worker did was tell mom to go to the DDS office and figure it out on her own. And knowing that mother needed this support with accessing and maintaining services, it wasn't enough to simply go send her off with an address to DDS and expect her to be able to re-enroll in those services on her own. She needed DCF to help her with enrolling in DDS services, and then she would have received the help that she needed to more successfully engage in the services and referrals that DCF was trying to send her. So that's one crucial part there that I think that that DCF failed to ensure mother had support with. And they knew additionally that mother was struggling to, quote, participate in the warm handoff, unquote, approach to the referrals early into the case. They knew that mother was not able to keep up with everything that DCF was suggesting that they do, and that she was overwhelmed with all of these referrals to services. And essentially that meant all of those services that they were referring to her would be rendered meaningless, because again, mother didn't have the DDS services that she needed in order to participate and enroll in services.
Can I ask you about a different issue that you raised, because I want to make sure I understand it. You are not necessarily saying that any of the judges, I think 234 factual findings are clearly erroneous, but that somehow the conclusions of law under 210(3)(c) are erroneous because of the findings the judge made? I just want to make sure I understand that claim.
Yeah, so I'm essentially saying that, you know, in addition to the fact that, you know, there was a lack of reasonable efforts, there's also this abject failure to provide these services under 210 Section 3C. And the trial court decided to apply these factors and essentially say that, yes, DCF did provide the services that were intended to correct the circumstances of mother's parental unfitness. Yet, when we look at when we look at the case, we can see that DCF did not provide those services. DCF did not make sure that mother had DDS services. DCF never provided her with mental health referrals. They never provided domestic violence referrals or services. And the court, in holding that the department did meet this obligation and applying the 3C factors, this raises to a level of legal error beyond just an abuse of discretion, because these 3C factors are in place to ensure that courts are distinguishing whether a parent's unfitness is merely temporary or long-term. And so I think it rises beyond the simple abuse of discretion review for a lack of reasonable efforts. And if mother had received these efforts, you know, then we don't know whether mother would have remained unfit. So the court essentially holds that mother would be unfit for an indefinite period of time, even though mother never received the appropriate services necessary to help her correct her alleged parenting deficiencies. And so, for example, she never received any referrals to domestic violence services. She never received any referrals to mental health services. And again, the most important thing, receiving DDS services, even that DCF failed to ensure that she had. And so when we're looking at the judge's findings here that mother would be indefinitely unfit, that is also an error because, again, DCF didn't provide the services that were necessary for this court to determine that unfitness was going to continue into the indefinite future. Indeed, DCF themselves believed that mother had the potential to be a good parent and demonstrated an ability to improve when she was provided the right guidance. And we do see that she did engage in services when she was provided the support necessary. For example, mother does engage with her parenting aides. She also does engage with the family nurturing program. She takes some parenting classes. She finds housing with the help of the family nurturing program. Mother needed more hands-on support, but there's nothing in the record that would say that mother would have completely refused that support if she was provided it. In fact, mother repeatedly said she wanted to re-engage in DDS services, and DCF was the agency that failed her here.
You have 3 minutes. You have 3 minutes.
Thank you, Your Honor. So DCF has an obligation to make sure that reasonable efforts to assist parents in reunifying their children are provided, and that those efforts must be tailored to that individual parent's specific needs. And in this case, DCF knew exactly what mother needed. They had
interrupt you for a moment.
Yes.
What exactly did DCF fail to do? What specific, other than physically walking to the DDS office location to have her sign, but what exactly are you alleging that DCF failed to do? For
the first obviously is the DDS services. They understood how incredibly crucial DDS services were for mothers to participate and engage in any of the other services. And really all mother would need was that support with signing and finishing the application. It was a very simple step that DCF could have taken to connect her to the most crucial services possible. And yet they didn't take that step. And then the other most important things are DCF focuses a lot of time, and so does the court, on the mother's relationship with father and how they believe that this is a controlling relationship. Yet at no point does DCF try to help mother get services to domestic violence resources or help. At no point do they even try to have a serious conversation with mother about why they think that this behavior could be considered domestic violence, which was essential because they knew that mother had cognitive limitations, and women with cognitive limitations can take a little longer to recognize intimate violence like this. And so the department completely failed on that end, and yet they repeatedly said that if they wanted mother to be able to participate in addressing her mental health, for example, they thought that they would also need to address the domestic violence concerns as well. They made no effort to do that.
1 minute, counsel.
Thank you, Your Honor. And then finally, they made no effort to refer her to mental health services, even though they repeatedly say that that was a serious concern for them as well. So when a parent has cognitive impairments that make it difficult for them to connect and follow through with services, like here, DCF cannot meet its statutory obligation to provide reasonable efforts by merely flooding the parent with meaningless referrals to services, especially when they know that that parent's cognitive impairments make it impossible for them to simply take off and run with those referrals. If reasonable efforts is to hold any meaning, it requires more than this. Therefore, mother respectfully requests that this court vacate the lower court's judgment and remand the matter with instructions to hold another trial after DCF provides mother with appropriate and accessible reunification services. Thank you.
Counsel. Please just put yourself on mute while we have the rest of the argument. For the Department Attorney Fasoli, good afternoon.
Good afternoon, Your Honors. Carol Fasoli on behalf of the Department of Children and Families. The mother's overwhelming parental unfitness was proven clearly and convincingly at trial, and as found by the trial court, the department properly made reasonable efforts towards reunification with mother. I would agree with Your Honors that in the first instance, this argument of reasonable efforts was waived. It was never brought up at trial. In fact, I believe what is now technically on the record, but is part of the reply brief that my sister provided, was a a letter at the beginning of the case requesting, services accommodated, and it was the department's, also, she included the department's response to that letter, which showed the different services that we were providing, and if they had any problems with that, they could have filed a further appeal, given our ADA
Are
policy.
these letters in the trial court's records?
They are not. That was attached to the reply brief, because it wasn't before the trial court, because, as Your Honors pointed out, this issue was never raised at the trial court. And even if it wasn't waived.
They were never filed as exhibits or anything like that?
Correct. Even if, hypothetically, the issue of reasonable efforts was not waived. The fact is, the department, in this case, went well overboard in providing services. Now, keep in mind, this child was born, was not removed till 7 months after the child was born. There were concerns at the hospital, maybe even warranting a removal, but the department chose to try to work with this family. Maternal grandmother was involved. The parents had no medical, no supplies for the child or anything, but they thought, all right, let's try to work with this family, which is exactly what they did. So the first, they provide services, they provide family stabilization services. Again, recognizing, no one is disputing that mother had some cognitive limitations. And they were also questioning father's cognitive limitations at the time. Again, working with a family stabilization unit that could, or service, that could work with this family. The problem was the parents, mother particularly, they refused these services. In fact, in the first 7 months, there were 2 separate family stabilization services provided. The first one, the department didn't feel was sufficient enough because mother needed a primary care in order to have a neuropsychological exam done. So they provided a second one, which was, I believe it's youth villages. It was a higher step up that could work. These services worked with the family. They come in 3 days a week. They try to connect you to service providers. Again, knowing mother's cognitive limitations, trying to have a special family stabilization that could have hooked her up with individual therapy, mental health treatment, and I mean, the starting point was getting that neuropsych done. Again, in addition, they did referrals to early intervention, 4 referrals to early intervention, even set up the appointments. Mother no-showed with the child. Again, there was also the social worker testified. She walked mother to the family nurturing center to set up the input. The family nurturing center could have connected her with family stabilization as well as domestic violence, which is what the social worker testified at trial. Again, the intake was done, and then the services were terminated because mother didn't follow through. The fact, after the removal, these same services were offered. In fact, because the removal involved one of the family stabilization social worker, they changed that that family stabilization person to work with the family. Right after removal, they tried to reach the parents, tried to work with the parents. Mother repeatedly said she didn't want extra people in the house. She didn't, again, understanding that mom had those cognitive limitations, the department was trying to work with this mother and trying to, they provided weekly visits, which, again, the social worker testified about 50% were missed of these visits.
What about the issue of domestic violence? It seems that the trial judge did spend some time talking about sort of father's presence and overarching control, I think, over mom's decisions. What did the department do vis-a-vis domestic violence and mom as a victim?
So the social worker was asked that at trial, and she referred to this family nurturing service. Again, it's not specifically focused on domestic violence.
We see so many cases where DV is an action plan, and there are very specific programs and resources. Doesn't seem like that was provided here.
But in context of mother refusing and not participating in all services that had been recommended to her, a separate DV, which there is no likelihood, I mean, mother wouldn't even go through with the family nurturing, which isn't even as, and furthermore, mother herself denied any, or she didn't acknowledge any DV. There was no physical violence according in the record between mother and father. And I would agree with Your Honor that there was controlling.
There was sort of at least an inference that some of mother's poor decision-making was as a result of influence by father, like she wouldn't sign the action plan because of him. Doesn't that send up a red flag that there is some power imbalance between mom and dad?
Oh, and I don't think anyone disputed that, that there was concern, they shared a cell phone. Mother even said to the social worker, if I do some of my services, and he doesn't do any, can I still co-parent with him? Because that was her plan, was to co-parent with him. No one is disputing that there wasn't domestic violence issues. The problem is, what would go attend a domestic violence separate group? Mother had demonstrated throughout this course of this case that she wouldn't even participate in the simplest of services like a family nurturing center, wouldn't even work with a family stabilization social worker who was coming to the house to connect mother with all these various services. So there's nothing to say that if you added another task on her action plan of go to a separate domestic violence group would have made a difference in this case.
I mean, they're in the unenviable position. I mean, and it's difficult in the one hand because you don't want to be criticized for stacking services that aren't attainable, so small steps. But then when the decision seems to really highlight the issue of control and domestic violence, and there isn't a specific domestic violence that I saw.
No, and it is true that, but again, that's the social work, again, working with someone who they all recognize has some limitations. If they can't even accept someone who works for the department, a third party, if they won't work and connect you with, a party, how could you expect them to be able to go separately to a domestic violence group? I mean, and the thing is, the mother, I believe, there was a parenting course she took 5 out of the 14, but again, stopped going. The DDS application, the social worker and the family stabilization service worker worked with mother on the application. They filled the application out. Again, DDS services is a volunteer service. The department can't force the mother to participate in DDS services. So at every visit, the social worker testified at every visit, she contacted the DDS previous worker that the mother had. So they were waiting for it. They tried to contact mother. Again, mother and father shared a cell phone, and throughout the course of the case, it was very difficult sometimes to get a hold of the parents. So other than the worker walking the mother down to the DDS office, which again, heroic measures are not expected, yes, the mother's pattern was to not participate in services.
Can you, only because of your time, can you speak to the 210-3C argument that mother has raised?
The department would dispute that this is, I guess the premise is the department didn't provide the proper services. The department contends it did. It tried to work with this mother, by these family stabilization services, by providing early intervention, offering daycare for the mother, to help her. And she said, I can watch my own child. Again, all these services were provided, and that's why the trial judge properly considered them in measuring the mother's parental deficiencies that were never cured throughout this case. So if there's no further questions, I would rest on my brief.
I don't see any. Thank you very much. And now we will hear from Child Counsel.
Good afternoon, members of the panel. Ana Maria Joy on behalf of the appellee child. My client is asking this court to affirm the lower court's termination of mother's parental rights because the judge properly evaluated all of the evidence and found by clear and convincing evidence that mother was unfit at the time of trial, that her unfitness would likely continue into the indefinite future, and that it was in the child's best interest. As Chief Justice Blake correctly noted, the trial court made 234 separate findings of fact, all of which were very specific and detailed in their analysis. I'm going to briefly address two issues. One, mother's lack of parental fitness at the time of trial was her own doing and not because of her low IQ. And two, DCF's efforts to help mother. As to the first issue, there's no question that mother did suffer from low IQ. But there are three very specific examples that this court can rely on where mother showed an ability to assess a situation, go through a thought process analysis, and show problem-solving capacity despite her low IQ. Example number one, when father was incarcerated around March 2022, mother discussed leaving father with her social worker. And she wanted to pursue a DNA test to potentially show that the child was the biological child of someone else, not father, even though he is the one that signed the birth certificate. Mother reported that she was in a different relationship and that she was looking to move into a different apartment. Example number two, again in March of 2022, mother realized that she would not be feeling safe with a visit with the child and the father because they were sharing visits, and she canceled the visit. And she specifically said that she told the social worker she did not feel safe having visits with the father due to threats she received from the father and his sister. That's finding of fact 182. So this shows that mother realizes she's not safe with this person and trying to get some distance from him. And example number three, which I think is the most telling, is in October of 2022, the parents were supposed to, they did attend a joint visit, but mother was incredibly late because she had to bike from Jamaica Plain to the DCF office in the rain because the father would not transport her in the scooter. So this is finding of facts 53 and 196. So the mother did not call the social worker to say, I'm overwhelmed by traffic, I don't know how to get there, what do I do? She showed initiative and she showed tenacity, and good for her. She thought, I'm gonna do what I have to do to visit my child. She showed up late and soaking wet, but she was there. This isn't someone that said, I don't know how to get there, social worker, please help me, I'm not gonna go. This is someone who showed in this instant, this is a problem, this is how I'm gonna solve it, I'm gonna do what's in the best interest of my child. And again, good for her for doing that. Unfortunately, she was not able to be consistent. And briefly, I'll just touch on DCF services for mother. Before DCF removed the child, on my brief in pages 13 to 16, I list all of the services that DCF provided. After DCF removed the services, after DCF removed the child, on pages 17 to 19, I again list all of the services that mother was provided. And again, mother was repeatedly offered services and rebuffed them at every turn. There's only so much DCF can do other than literally moving a DCF social worker into mother's home or physically forcing her to accept these services and follow through.
Thank you. We'll have to leave it there. These are always very difficult cases, and I appreciate the arguments of all counsel. The matter is under advisement.
Thank you.
That also concludes today's sitting. I'd like to thank our court staff, in particular our clerk's office, for quickly pivoting to a hybrid hearing this afternoon. Of course, our court officers and our law clerks. We are now in recess. Thank you all.
Right. All right, thank you all very much. Good morning. We're on YouTube simply for the fact that we're not in the courthouse. And so we will allow anybody who wants to join in the session to log on if they want to. But anyway, we're here on the continuation of the July 22nd, 2020 docket, the 9:30 docket. And we're here on in the interest of Maximus V. Garza, cause number F2587-13-4. And good morning, Mr. Ramos.
Good morning, Judge. For the record, Juan Ramos here on behalf of the petitioner, Chris Strom, the father in this matter, Judge.
All right. And what do we have, Mr. Ramos?
Judge, we're set for a motion to appoint an attorney ad litem and a motion for a drug screening, a hair follicle test. And by way of background, the reason we're set for these two motions, Judge, is because at the previous hearing, the court awarded Mr. Strom temporary custody of his child, his son, Maximus, because there are ongoing CPS issues in the household with the mother that involve alcohol and drugs. And unfortunately, in contacting with the CPS, we found out that the mom has Miss Jessica, I believe, I forgot her, Miss Garza, has not undergone any of the drug testing that's mandatory as per the CPS household plan. And so we believe that the hair follicle is necessary given the circumstances for the safety of the child, Judge. And of course, the attorney ad litem can perhaps provide some more insight as to what's going on in both households.
Okay. Court will go ahead and order the hair follicle test for Ms. Garza. And as far as an attorney ad litem, we'll go ahead and appoint Jane Sheen. I'll put Jane Sheen, and that'll do it. Is there anything else?
Nothing further, Judge.
All right. So the orders. Yeah, go ahead and e-file the orders as soon as possible. Okay, sir?
Will do, Judge.
All right. Thank you very much. You all may be excused.
You too. Be safe. Take care.
You too, sir. Be safe.
Are on the record in file 23-21293-FH as well as 23-21294-FH. People of the state of Michigan versus Jason Michael Adams. We are here today for a pretrial conference, and we are proceeding today by Zoom video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
James Daly on behalf of the defendant.
All right, and Mr. Daly, you indicated off record that you wanted to make a motion with respect to Mr. Adams' bond. So if you'd like to do that, you can proceed.
Yes, Your Honor. We would ask that his bond, there's already a note in the file that he can be released to go to a Harbor Light if he has a bed. He has a bed, it's paid for. He's everything set up. He just needs a court order saying that he can go to Harbor Light. We're working on a plea. We would have had a plea worked out already, but I can't get him into drug court because of a prior CSC conviction. So we're still resolving what I can plead him to, but it's our intent to resolve this matter.
When you say he already has a bond to be released to Harbor Light, is that in district court or?
Circuit court.
Oh.
It's not a bond, just a note in the file that if he gets set up for an approved place for drug rehab, he could go.
Your Honor, I guess I would leave that in the court's discretion. I don't know how they monitor when somebody goes to rehab, you know, if they stay, if they get to leave whenever they want. I don't know how that works, but I would leave it in your discretion, Your Honor.
All right. Reviewing the file, it obviously based on the charges, it appears that Mr. Adams has an issue with substance abuse. I do think it's appropriate to give him an opportunity to seek inpatient treatment at Harbor Light. There's apparently been some discussion to allow him to do that previously, but regardless of that, I think it looks appropriate here. So I will modify his bond conditions so that he can be released directly to the Harbor Light program to participate in inpatient substance abuse treatment. And he shall complete that treatment and comply with all the terms of that complete treatment while he is released to do that.
Thank you, Your Honor.
So this was also a pre-trial. So Mr. Daly, how do you want to proceed from here?
Your Honor, I just need to talk to the prosecutor to resolve this problem. We have no intentions of trying this case.
Can I say something, too?
All right, I don't know if Mr. Daly wants you to speak directly, Mr. Adams.
That's fine with me.
Okay, what is it you want to say, Mr. Adams?
I just want to say I got everything set up for rehab. The only thing I needed was just a signed paper by you and the prosecutor stating. So I already did like my medical intake. I took all the steps to go forward with this process, release the information from CMH and everything. I just need to do the main intake for rehab, which they said I couldn't do until I had paperwork signed by you and the prosecutor stating that it was okay.
All right, so what I'm going to do is set it for pretrial on June 7th at 8:15 a.m. And as we discussed, in the meantime, Mr. Adams can be released to the Harbor Light program. Mr. Daly, would you prepare that stipulation in order?
I will, Your Honor.
Okay, thank you then. Mr. Adams, you can let the officer that's with you know that you're done in court for today.
All right, thank you.
Thank you, Your Honor.
Thank you. Good morning, Mr. Wallace. Can you tell me what case you're here for?
For a PPO.
All right, I'm going to place you back in the waiting room until we get to the case you're needed for.
Okay, thank you.
Your Honor,
Yeah.
I was just going to suggest that maybe I could have a breakout with Mr. Wallace while we're waiting.
Okay. Mr. Wallace, I'm going to place you in a breakout room with Ms. Underwood from the Public Defender's Office.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Mr. Sala, do you have Mr. Bishop at your office with you?
Yes, Your Honor, he is here with me.
Your Honor, I'm on that case for the prosecutor's office.
Okay. All right, we are on the record in file 23-21238-FC, People of the State of Michigan versus Nicholas Joseph Bishop. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. Can I first have the attorneys place their appearance on the record?
Right, Your Honor, Dave McCready for the people.
Thank you.
Stand silent on behalf of Nicholas Bishop.
And Mr. Sala, where do we stand with this case today?
We have a motion filed on it at this point. And depending on what happens with that motion, it may be dispository in the case.
Your Honor, I do plan on filing a response to that motion, and my understanding is that there's a hearing set for June 12th.
All right.
Yes.
Yeah, looks like the hearing date is June 12th. Mr. Saul, is there anything we need to do between now and then?
No, Your Honor, I don't believe so.
All right, so what I'll do then is adjourn the pretrial to June 12th at 10:30 a.m. So the same date time as the hearing on the motion to preclude evidence. Is there anything else we need to address today?
On behalf of the people.
Nothing on behalf of Mr. Bishop, Your Honor. Thank you.
All right, Mr. Saul, would you be willing to prepare a stipulation in order for that adjournment to the motion hearing date?
Yes, Your Honor.
Okay. Thank you. Then you can go ahead and log out.
I have two more, I think, with you.
Oh, I'm sorry.
Malik Owens and Mackenzie.
All right, and they are both in jail or jail
Yes.
rooms at the moment, so we'll get to those as quick as we can.
All right, thank you, Your Honor. I'll be here.
I'm on Owens as well.
Okay, thank you. All right, Mr. Trushan, are you representing Mr. Green Blaker?
I am, Your Honor, Mr. Murphy, filling in for Mr. Murphy today.
Okay, so,
The only one I have with you.
all right, Mr. Green Blaker is here by Zoom. So we are on the record in People of the State of Michigan versus Trenton Jonathan Green Blaker. File 22-21192-FH, file 20-20114-FH, file 23-21274-FH. These are all set. Let's see. The 22 file is set for a pretrial hearing. The 20 file is set for a probation violation pretrial. The 23 file is also set for a pretrial hearing. So first, can I have the attorneys place their appearance on the record? Let's start with Mr. Wood on the child support case.
Good morning, Your Honor. I believe two of those should be, one of them should be a pretrial on a child support case, and one is the violation of probation on a child support case.
Yes, you are correct. So the 2020 case and the 2023 case are Attorney General child support cases.
Right.
And then
And good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood, appearing in those matters.
And Phoebe Meir on behalf of the people for the 22 case.
And Mr. Tucci.
Your Honor, George Trushan, 37255, appearing for Mr. Murphy from the Public Defender's Office today.
All right, and Mr. Trushan, where do we stand with Mr. Green Blaker's cases today?
Your Honor, I had a discussion, a good discussion yesterday with Mr. Wood in regard to the AG's participation with a couple of these cases. I think it's my understanding that we would like to petition you, Your Honor, put this all together at one time. Mr. Murphy's familiar with this. I'm not familiar with this gentleman whatsoever, but in deference to protecting his rights, I know the AG's office, I think, indicated they were obviously ready and willing to go forward further. So if the court would indulge and put these all together at one time for a hearing date that works out with the court, I can certainly let the Public Defender's Office know.
All right, so are you asking for another pretrial or?
If I could defer to Mr. Wood for a second. Mr. Wood, would that be fine with your office? Combine this for either a pretrial or a hearing date on the VOPs with a pretrial connected?
Yeah, you know, that's fine. We've extended an offer. That there was some indication back in March that potentially the defendant was prepared to plead with the offer that Ms. Brenner extended. I know that he had our notes say that he had a domestic violence trial on May 5th. I don't know if that went forward. Yeah, if we want to set this over once more, Your Honor, I actually don't have paperwork on the VOP. I think I know what the allegations are. I don't have, I was not able to get any paperwork from the AG, so I haven't seen MDOC's allegations on the VOP. But so if the preference is to set it over, Judge, I don't know what we're looking at, couple weeks, 30 days, and what about Ms. Meyer as far as whether she's okay with setting hers over?
Yeah, Ms. Mayor, where do we stand on the R&O case?
I'll defer to defense on what they want to do.
All right. So just for my own clarification, Mr. Trushan, is Mr. Murphy returning, or are you taking over for him?
No, he's returning, Your Honor. I'm just filling in today.
Okay. Do you know when Mr. Murphy might be back?
I think he's back. I see the assistant public defender on the TV. I believe he's back Monday, Your Honor.
That's correct.
All right, so let me set it for next week, if that works for everyone. So that'd be May 17th at 8:15 a.m. And we'll have Mr. Murphy back and have an better understanding, I think, of whether we should set it for trial or whether there's going to be a plea.
Thank you, Your Honor. I will notify their office.
Thank you, Judge. And I assume the AG may once again appear via Zoom, Your Honor.
Yes, Zoom appearance is fine.
Thank you very much, Judge.
Mr. Trushan, could you have the public defender's office prepare a stipulation in order for the adjournments in each of those files?
I will, Your Honor. Thank you.
Okay.
Mr. Trushan, that stip and order should be submitted to the AG, not to me. You can send that to Ms. Brenner at the AG's office, who's the attorney of record.
Okay. Thank you. Let the office know.
All right, thank you. Mr. Greenblaker, you can let the officer that's with you know that you are done with court for today.
I need to step out just for a moment.
Okay. Mr. Trushan, before you leave, I had you or Ms. Van Duzen down for Nathan Hernandez.
I was told yesterday, Your Honor, that Ms. Van Dusen is handling all of Mr. Hernandez.
Okay, I just want to make sure. So we're all set then. Thank you.
Thank you. And if there's something further, I'll go right next door.
Okay.
Your Honor, and Nathan Hernandez is the probation officer and the prosecutor there.
Let me see who's probation officer. Tomorrow, are you the probation officer for Mr. Hernandez?
Agent Holly is, but I'll handle it.
Okay.
Mr. Moore, do you have any objection to putting this out? He has new charges downstairs.
No, we do not.
Okay, I had just sent a message to the jail asking for him. Do you still want to proceed with him on the record or no?
I don't need him on record now because I will see him tomorrow.
Okay, let's see, Mr. Glazer, we do not have Mr. Taylor logged in yet from the Hillsdale County Jail.
Your Honor, I got one over in Judge Anselm's. I'm gonna go over there and do that and come back if that's okay.
Yep, that would be fine.
Thank you.
All right, Ms. Underwood, are you ready to proceed with Mr. Wallace?
Yes, Your Honor, I believe we are.
All right, we are on the record in file 22-49399-PP. Lisa Arlene Meadows versus Leon Wallace. This is before the court today for an alleged personal protection order violation. We are proceeding today by Zoom video conference. First, let me ask the attorneys to place their appearance on the record. Ms. Mir, are you appearing on this one?
Your Honor, I'm sorry, I didn't see it on the docket.
All right, you want to place your appearance on the record then?
Phoebe Mir, on behalf of the people.
Ron Underwood on behalf of Mr. Wallace this morning, Your Honor.
All right, where do we stand then, Ms. Underwood, with Mr. Wallace's case?
Your Honor, I think what we would ask is to set this out for another pretrial or a hearing in this matter. I don't believe that the parties want to pursue it, but just to do some investigation on that issue, Your Honor, just set it out for one pretrial.
All right, so I'll set it out for a pretrial on June 7th at 8:15 a.m. At that point, if it's not resolved, otherwise I would intend to set it for a trial at that point.
Understood, Your Honor.
Ms. Underwood, would you prepare that stipulation in order?
I will be happy to do so. May I sign with your permission, Ms. Mayor?
Yes.
Thank you.
All right, Mr. Wallace, you are all set for today. You can log out. Your next date to log in will be June 7th at 8:15.
Okay, thank you, Your Honor.
Thank you. Yeah, Mr. Malero. Okay. Mr. Malero, we have Issa Thomas here in the courtroom. Are you ready to proceed with him, or we can set up the iPad in the hallway if you need a breakout session?
I'm ready, Judge, unless he wants to talk to me.
Okay, Mr. Thomas, could you come forward, please? This is file 23-21318-FH, People of the State of Michigan versus Issa Thomas. We are here today for a pretrial conference. We are proceeding today partially in person and partially by Zoom. Sir, you are Issa Thomas?
Yes.
Mr. Thomas is here in person. Can I have the attorneys place their appearances on the record, beginning with Ms. Muir?
Be Mayor on behalf of the people.
And Mr. Malero?
Yeah, Salvatore Malero on behalf of Issa Thomas. Your Honor, I got some information on this case, and if Ms. Muir is the assigned prosecutor, I would ask to adjourn this so that I could take that to her and see if we can't work this out.
Okay, Ms. Muir?
Yeah, I have no objection to that. I need to do some follow-up of my own on this, and then by the next pretrial, I think we'll either have this resolved or ready to set for trial.
So I'll set this then for pretrial on June 14th at 8:15 a.m.
Sounds good, Judge.
Mr. Malero, could you prepare that stip in order?
I can.
Okay, anything else we need to address today?
No, Your Honor.
No, thank you.
Mr. Thomas, come and see me in about a week. Okay?
Okay, I will. All right, then, Mr. Thomas, you are all set. You're free to go. All right, thank you. Sir, yes, sir. Are the other people here for cases?
No, they're, yes, Mr. Lambert, Michael Lambert. So, no cause. Didn't have him.
All right, sir, at the jail, you're Mr. Madison?
Yes, sir.
All right, Ms. Van Dusen, are you handling this one?
No, Your Honor. That would have been George, probably.
Sergio, could you run over to
No,
Judge
no.
Angelo and let Mr. Trushan know that we're gonna need him back?
Yes.
These are all closed journal. Is this Robert Madison?
Oh,
This is Brant Madison.
Oh, I have him. Sorry, Your Honor.
All right. Okay, do you need a breakout session with him?
Yes, please, Your Honor.
Okay. Sorry, Mr. Trushan, we don't need you. Ms. Van Dusen initially said that she wasn't handling one, and then she realized that she was, so false alarm.
Judge, I'm ready anytime you are.
We're just making sure you get your steps in going back.
It was
and
just
forth.
good to know that you wanted. Thank you, Your Honor.
Thank you. All right, Mr. Lambert, would you come forward to the podium, please?
Mr. Lambert?
Yes.
I'm sorry, sir, I have hearing aids and I'm very hard of hearing.
Okay, I will try to speak louder. We are on the record now in file 22-49696-PP, Janice Lynn Gout versus Michael Dwayne Lambert. Today is date set for an appearance on an order to show cause for an alleged violation of personal protection order. Sir, you are Michael Dwayne Lambert.
I am Michael Dwayne Lambert.
Mr. Lambert, you are here today on an order to show cause. That order to show cause alleges that you violated the terms of a personal protection order on February 21st, 2023 by sending mail or other communication to the petitioner. The maximum penalty for a violation of a personal protection order is up to 93 days in jail and or a $500 fine. You are entitled to have an attorney represent you here today and at any other proceedings that we might have on this matter. If you can't afford an attorney, you can tell me that now and I would appoint one for you at public expense. Do you understand that, Mr. Lambert?
I truly cannot afford an attorney at this time.
Okay. Would you like to be represented by the public defender's office?
I would.
All right. So we apparently have lost our public defender to another courtroom. So what I'll ask you to do now is if you'll just take a seat back where you were. When we have our public defender back, I will set up the iPad in the hallway so that you can have a discussion with her.
Yep.
If you could have keys. Or the yellow file. Yeah. Show cause over, send that. Yes, sir. Mr. Malero, do you happen to have Mr. Young in your office with you?
Judge, I think he's in jail. He had a pretty good bond on him, so I'd be surprised if he had made bond.
Let me look. He is.
Judge, that's not Mr. Young.
Yeah. Okay, Ms. Van Dusen, are you ready to proceed with Mr. Madison?
Yes, Your Honor, I am.
All right, we are on the record in file 23-21242-FH, People versus Brandon Lorenz Joe Madison. We are here today for a final pretrial conference in this case, and we are proceeding today by Zoom. First, can I have the attorneys place their appearances on the record, beginning
Good morning, Your Honor. Chris Fleming, appear on behalf of the people.
Don Van Dusen on behalf of Mr. Madison.
All right, Ms. Van Duzen, this is set for trial on May 16th. Where do we stand with the case today?
Mr. Madison will be pleading to count 1 habitual fourth with count 2 and 3 dismissed. And there's a Killebrew, no prison, and he is approved for drug court, which he is accepting.
Okay.
No initial prison.
So count 1 plus the 4th habitual.
Yes.
And a Killebrew to no initial prison and drug court. Mr. Fleming, is that a complete and accurate statement of the plea agreement?
It is, Judge.
Mr. Madison, would you raise your right hand, please?
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
You are Brandon Lorenz Joe Madison.
Yes, sir.
Mr. Madison, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, assaulting, resisting, obstructing a police officer causing injury?
Yes, sir.
You can put your hand on if you like, Mr. Madison. Is it also your intention to admit today the 4th habitual offender?
Yes, sir.
Are you satisfied with your attorney and the advice that she's giving you?
Yes, sir.
Do you understand that with the 4th habitual offender notice, the maximum penalty for this case would be up to 15 years in prison?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Mr. Fleming?
That's correct, Judge.
Ms. Van Duzen?
That's correct, Your Honor.
Is that also your understanding, Mr. Madison?
Yes, sir.
If a plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
Yes, sir.
You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Madison, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you plead to the charge that on or about January 18, 2023 in Lenawee County, Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer causing injury?
Plead guilty, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept the plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning? Or that
Yes, sir.
Or that
Yes, sir.
your own
Yes, sir.
Is the prosecutor or the defense counsel aware of any promises, threats, or inducements to induce the defendant to plead guilty?
No, Judge.
No, Your Honor, sorry.
Mr. Madison, other than as we've discussed on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Ms. Van Duzen, would you like to cover the factual basis?
Yes, Your Honor. Mr. Madison, were you in Lenawee County in, I think it's Madison Township at Joanne Fabrics on January 18th, 2023?
Yes, ma'am.
Okay, and during that time, while you were at Joanne Fabrics, did you come across an officer named Joshua Perez?
Yes, ma'am.
And he was in uniform?
Yes, ma'am.
And he was doing his job, talking to you, correct?
Yes, ma'am.
Did he order you to stop and go with him at one point?
Yes, ma'am.
And did you run from Mr. Or Deputy Perez?
Yes, ma'am.
And during that altercation of you running, did he fall and injure himself?
I believe so, ma'am.
Nothing further, Your Honor.
All right, Mr. Fleming, are the people satisfied?
Just a couple questions. To your knowledge, is Joshua Perez a deputy with the Lenawee County Sheriff's Department?
Yes, sir.
And also to your knowledge, he said he got injured. Did that require medical attention or medical care?
I mean, I don't know if he did, but they say he did. Like, I got took to jail, so I wouldn't know, you know what I mean? But from what I know is yes.
Okay, perfect. No further questions, Judge.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Fleming?
You have, I do believe we have to go over the previous convictions, though.
I apologize. Yeah, we
Okay.
did.
Mr. Madison, you had prior convictions of felonies on December 19th, 2002, convicted of offense of attempt felony obstruction in Lenawee County. Is that correct?
Yes, ma'am.
Okay, and then on 2/12/2003, you were convicted of assault with dangerous weapon in Lenawee County at that time too, correct?
Yes, ma'am.
That was a felony.
Yes, ma'am.
Okay, and then on September 2nd, 2009, you're convicted of an offense of weapons, firearms, receiving and concealing in Lenawee County. Is that correct?
Yes, ma'am.
And that's a felony?
Yes, ma'am.
Okay. Nothing further, Your Honor.
Thank you. Okay, at this point, Mr. Fleming, has the court complied with MCR 6.302 B, C?
Yes, Judge, people are satisfied.
Thank you. Ms. Van Duzen?
Yes, Your Honor.
I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Madison has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 22nd at 8:15 a.m. Mr. Madison, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
We'll continue.
Can I ask a
on.
question, Your Honor?
Yeah, I'm sorry. Go ahead, Mr. Moore.
Mr. Madison, have you already been assessed for a drug court, or do we need to assess you?
No, I've been assessed already.
He's been approved.
Okay, thank you.
All right, so you are all set, Mr. Madison. You can let the officer that's with you know that you're done with court.
Okay, thank you. Have a nice day.
Thank you, Judge.
Thank you. Okay, are you Mr. Taylor?
Yes, sir.
All right, Mr. Glazier, do you need a breakout session with Mr. Taylor?
Yeah, just for a few minutes, Your Honor.
All right, Mr. Taylor, I'm going to place you in a breakout session with Mr. Glazier.
All right, yes, sir. Thank you.
Okay, Mr. Sala, they should be bringing us Malik Owens next.
Okay, I have you as well as Miss Angelo, Judge Angelo. So I'm multitasking here.
All right. Sergio, could you go set up the iPad?
She's sitting in there.
Your Honor.
Ms. Underwood, did you receive the information on Mr. Lambert?
I don't believe I have, Your Honor.
Okay. So I will take the that in. And you wanted just a pre-trial? Yes, we're gonna need pre-trial. No trial date.
For Mr. Lambert. Okay. Could you try emailing the sheet?
June 14, and it, you know, I feel that.
Okay, Mr. Glazier, are you ready to go on the record with Mr. Taylor?
Yes, I am, Your Honor.
All right, we are on the record in People of the State of Michigan versus David Curtis Taylor. File numbers 19-19313-FH, 19-19314-FH, 19-19315-FC, 19-19367-FC, and 19-19433-FH. These are all set for pretrial conferences this morning. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
John Glazier on behalf of Mr. Taylor.
And Mr. Glazier, where do we stand with Mr. Taylor's cases today?
Your Honor, we need to adjourn this probably the same date as Cecil's, or maybe like the week after. I think he's set for June the 7th.
That's correct.
Okay, does it make more sense to do it the same day or the day after or the week after?
Probably the week after.
Yeah, that's probably correct, Your Honor.
Okay. So that would be June 14th. We'll set it for June 14th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Glazier, could your office prepare stipulation and orders for that adjournment?
I can actually do those since we've prepared them in the past. They're already ready to go. I just have to change the date. Can I sign for you, Mr. Glazier?
Yeah, that's fine.
Okay, thank you.
All right, thank you very much then. All right, anything else we need to address?
No,
No,
thank-
Your Honor. And that's all I have for you this morning. Thank you.
Okay, thank you. Mr. Taylor, you can let the officer that's with you know that you're done with court for today.
All right, thank you.
Ms. Underwood, have you received that information on Mr.
I
Lambert?
did receive the Lambert information and I've reviewed it, Your Honor.
Okay, Mr. Lambert, if you would step into the hallway, there's an iPad out there. I will put you in a breakout session with Ms. Underwood, Public Defender's Office.
Tanner, can we get a date for Nathan Hernandez?
Yeah. How far out did you want to go? How far out did you want to go?
At least 30 days.
About June 14th.
That works good. Thank you, Your Honor. We'll do the stipulation.
Okay, thank you very much. Do you have the number for intake at the juvenile? Yeah. This is Judge Olsaver calling. We need to see Nathaniel Funk in a Zoom meeting. Thank you very much. All right, Mr. Lambert, you can come back to the podium, please. We are back on the record in file 22-49696-PP, Janice Lynn Gout versus Michael Dwayne Lambert. Mr. Lambert has had an opportunity now to speak with Ms. Underwood in a breakout session. Ms. Underwood, do you know how Mr. Lambert would like to proceed?
Yes, thank you, Your Honor. Rhonda Underwood for Mr. Lambert. At this time, Your Honor, we would ask the court to enter a not guilty plea on Mr. Lambert's behalf and set this matter for a hearing, Your Honor. We are going to request discovery in this matter and prepare for a hearing, Your Honor.
All right, how long would you expect the hearing to take?
I wouldn't say anything over an hour, Your Honor. That would be my suspicion.
And Judge, I just wanted to inquire, I guess, of Ms. Gout. It says on the docket that her attorney is Mr. Daly.
I'm sorry, I can't hear Ms. Muir.
No, I guess we'll just go to the file. First 2:30. Okay. All right, June 21st at 2:30 p.m.
What was that date, Your Honor?
June 21st at 2:30 p.m.
Thank you.
Judge, can you hear me?
Yes.
Okay, on the docket, it's showing Ms. Gout is represented by Mr. Daly. I just want to double check if she is or not, so I know whether we need to appear on that.
I am not represented by Mr. Daly anymore. I was just doing that to get the PPO in place, to add Michael on. So I do not have an attorney at this point.
The show cause was filed by the prosecutor's office.
Okay, I just saw Mr. Daly on the docket, so I wanted to double check.
Yeah, that gets carried over. Unfortunately, it's for some reason hard to get that changed out. So, all right. So June 21st at 1:30 p.m. That will be in person, since the court will be hearing evidence in that case.
Is the court going to send notices, Your Honor? Or,
Yes.
okay, thank you.
Thank you, Mr. Lambert. You are free to leave.
Thank you, sir.
Ms. Gout, you are free to log out.
Okay, thank you, Your Honor.
Thank you. Hi, this is Judge Olsay. We're calling. We were looking for Owens. Yes. Yes. Thank you. Ms. Underwood, who do you have left today?
Hang on. Let me check, Your Honor. I believe we have Mr. Funk.
Yeah, I've called for Mr. Funk, so I hoping they'll have him any minute. And Mr. Stepanski, have you heard from him? All right, we are on the record in Janelle Marie Scott versus Nathaniel James Funk, file 18-45437-DP. We're here today on a bench warrant for a failure to appear at a show cause hearing related to non-payment of child support. Sir, you are Nathaniel Funk?
Yes, Your Honor.
Mr. Funk, it states here that you have a monthly child support charge of $272, and there is currently an arrearage in those support payments of $8,820.50. With respect to the bench warrant, a bench warrant was previously issued for your failure to appear at a show cause hearing in this case that occurred on March 22nd, 2023. Sorry, that's the date the warrant was signed, not the date of the pretrial.
Yeah, Your Honor, I think you guys have the wrong address for me because I haven't been getting none.
All right, Mr. Funk, just stop for a minute. I need to advise you of your rights before you say anything, all right?
Yes, Your Honor.
Do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, Your Honor.
Do you understand that it's a crime to fail to appear in court when you've been ordered to appear?
Yes, Your Honor.
Do you understand that if you plead guilty to either of these offenses, I could sentence you in jail for up to 30 days?
Yes, Your Honor.
You're entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You're entitled to have an attorney represent you here today and in any other proceedings we might have on this matter. Do you understand that as well?
Yes, sir.
You're entitled to have an attorney represent you here today and in any other proceedings. Do you understand that?
Yes, sir.
If you want an attorney and you can't afford to pay for your own, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Would you like to speak to an attorney?
No, sir.
You are entitled to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they are under oath at your trial. You understand that?
Yes, Your Honor.
You're also entitled to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes.
You are not required to say anything at your trial, and if you don't say anything, no one can hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir.
How do you plead to the charge that you failed to appear in court for your original show cause hearing?
I plead guilty, sir.
How do you plead to the charge that you failed to pay child support to the very best of your ability up to the amount ordered?
I plead guilty, sir.
I'm gonna represent myself or.
All right, so you are aware that you have a child support charge of $272 per month?
Yeah, I am, Your Honor.
Do you agree that the current arrearage is $8,820.50?
Yeah, it sounds right.
Yes, but at other times.
According to the information I have, the last payment that you made was on November 29 of 2021. Do you agree with that?
Yes, Your Honor.
You've not made any payments since that time?
I've tried, and for some reason it wasn't accepting my card, and I tried to contact my caseworker, and then they changed my caseworker, so it kind of confused me, and I was having difficulty.
But not like a lot of income, nothing much for, you know.
Right, and the court conducted a show cause hearing on this matter back on February 6, 2023. You were not present at that hearing, is that correct?
Yes, Your Honor.
What is your current address?
2110 Nadu Road.
I'm sorry, that was not clear. Could you say that again?
2110 Nadu Road, Monroe, Michigan.
Can you spell the name of the road, please?
Neadeau. Neto.
And that was 2110?
Yes.
And that's in Monroe?
Yes.
I'm sorry, I forgot to bring Ms. Fetzer-Wallet in from the Zoom waiting room. So Ms. Fetzer-Wallet, we have Mr. Funk present from the Lenawee County Jail. He pled guilty to the failure to appear and the failure to pay support, and stated that his current address is 2110 Meadow, was that road, Mr. Funk?
Neto with the N. Neto. Neto Road.
Can you try to get closer to the microphone? There's a lot of, it's just difficult to understand what you're saying.
It's Neto Road. With an N.
Okay, it's Neadeau.
Yes.
And that's in Monroe.
Yes.
And what is the zip code?
48162.
Are you employed, Mr. Funk?
Yeah, my employer's work just kind of picked back up because I do catering for weddings, and in the wintertime it's really slow. So yeah, I work for Keeping It Fresh Catering.
Okay, are you a W-2 employee?
No, sir. I can make it that way, I'm pretty sure. I haven't worked throughout the winter, so when I get out, I imagine I'm gonna have work, so.
Well, if you understand that if the business slows down and they're not hiring you to do work, you have an obligation to find a new job?
Yes, Your Honor.
Do you have any payment that you can make today?
It wouldn't be today. In the next few days, I can make payment. Yes.
How many days and what can you pay?
I could pay 500 in 3 days.
All right, I'm going to adjourn your sentencing to May 22nd at 8 a.m. And I will release you on a personal recognizance bond on the condition that you pay $500 by Monday, May 15th.
All right. Thank you, Your Honor. I appreciate that.
Your Honor, does he have a public
Yes.
defender?
He does not.
Okay, thank you.
All right, Mr. Funk, you can let the officer that's with you know that you're done with court for today.
All right, thank you.
Thank you.
Mr. Sala, I believe we have Mr. Owens now at the jail. Do you need a breakout session with him?
Yes, Your Honor, if you would, please.
All right, I need to keep it quick. I have a jury trial set to begin at 10:30, so
All right, we'll be back.
Then I have this Kyle O'Brien left.
okay, I'll call for him next. All right, Mr. Sala, you ready to proceed with Mr. Owens?
No, Your Honor, I need a breakout room with him. You put me in a different cell without anybody.
Oh, I'm sorry. Let me get this sorted out.
No worries.
Mr. Hart, on what case are you here for?
Mr. Bilaro's file, Eric Young, I don't know if that's been handled or not yet.
It has not.
To be Brian Dennis, PPO show cause on the docket. Didn't see it. I also thought it was up there.
Yes, let me find it. So that is, there is a show cause order and a notice of hearing for today, but I don't see a proof of service on Mr. Dennis.
Sorry, Judge, did you say something about the Brian Dennis PPO?
Yes, I don't have a proof of service on that one.
I don't know that we did one, but I remember he got arraigned on this when he was here on his other show cause. And then we set this date. I thought it was supposed to get set with his other PPO though. That's why I was kind of confused why it was on here. Because it was supposed to be set with his other one.
With another PPO?
Yes, he has another, this is a second PPO violation. He has an underlying felony, a PPO violation, and this was a new one, and I thought we had arraigned him on this one when he was here for the last one. And then set them all out together. And I didn't know that we did a show cause because I thought it was just all in one notice, I guess. Maybe not though.
Okay, so this is a new show cause. And the original date on the notice of hearing is today. So this was filed April 20th.
So maybe it's a third one then.
Let me take care of Mr. Owens while you look into that.
I do have the other one down for 5/17 for next week. Could we maybe just adjourn it and we'll send the show cause to the agency to try and file? Or I can
Okay.
send it to his attorney. I know his attorney would get it to him.
Yeah, that's fine. So next week, May 17th.
Okay, thank you.
All right, Mr. Ursal, are you ready to proceed with Mr. Owens?
I am, Your Honor.
We are on the record in file 20-19882-FH and 22-20974-FC, People versus Malik Antonio Owens. The 20 cases set for probation violation, pretrial. The 22 cases set for pretrial hearing. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready for.
Morning, Your Honor. Dave McCready for the people.
Stan Sala on behalf of Malik Owens.
And Mr. Sala, where do we stand with Mr. Owens' case today?
Well, I need to talk with the prosecutor a little bit more about his case. If we could set it for another pretrial, I'll see if I can get a resolution. And I think Miss Weiss is actually handling the case, so I can get a hold of her.
Actually, I have the case now, so you're happy to talk to you, Mr. Sala.
I don't have your cell number, so you.
But I can get it to you.
All right.
All right, so this was bound over in July of last year. So at this point, I would say that this will be the last adjournment. I will be setting this for trial at the next pretrial if there has not been a resolution.
Yes, Your Honor, I understand.
But for purposes of today, we will adjourn this to June 14th at 8:15 a.m.
Thank you, Your Honor. That'll work.
Mr. Saul, would you prepare the stipulation in order for those adjournments in each of the files?
Yes, and can I sign the prosecutor's name?
That's fine here. Got it.
All right, thank you.
Thank you, Mr. Owens. You can let the officer that's with you know that you are done in court for today.
I just sent over the other one to June 14th.
And
All right, Ms. Van Dusen, I just requested Mr. Bryan, so he should be coming up next.
Thank you, Your Honor.
That stays here.
Eric going? Full favor? Mary, you're done on number 3. One. That's right here, number 22, all favor.
Are you Mr. Bryan?
Yeah.
Ms. Van Dusen, do you need a breakout session with Mr. Bryan?
No, I don't, Your Honor.
All right.
Yeah.
We are on the record in People versus Kyle Dennis Bryan, file 22-21165-FH. This is set today for a competency hearing. Courts previously entered an order for competency evaluation as well as a criminal responsibility evaluation, and has received reports back on both of those matters. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
Me, Mayor, on behalf of the people filling in for prosecutor at record, Isaac Seed.
John Van Dusen on behalf of Mr. Kyle. Or Kyle Bryan, sorry.
All right. And as I've indicated, the court has received the reports from the State Department of Health and Human Services, Center for Forensic Psychiatry.
Hi, Stan.
Are the people in defense going to stipulate to admission of that report at this point, or how do we want to proceed?
Your Honor, I'd like to file a motion for MCL 330.2020 for the court to determine his incompetency pursuant to the report.
All right, so you would like to file that motion, and then I'll leave it to you to contact the court and schedule that hearing then.
Yes, thank you, Your Honor.
All right, is there anything else then that we would need to address today?
Maybe another pretrial date?
I think we have one coming up. We put this on because we received a report back and we're required to deal with those within
Okay.
5 days. So let me just check and make sure, but I think we have a pretrial coming up in the next couple of weeks.
It's May 24th.
Okay, thank you.
May I speak?
I don't know if your attorney wants you to speak at this point. Anything you say could be used against you. So Ms. Van Duzen, I don't know if you have a position on that.
I was just gonna request a PR bond, that's it.
Mr. Bryant? I please just wait and let Ms. Van Duzen answer first before you talk, all right?
Yes, sir.
Yeah. Mr. Bryan, PR bond isn't appropriate at this time because you cannot go back to your house where you're living. So we need to do this motion for competency first.
What if I have other places I can live?
Well, I'll give you a call after this so that we can discuss that, okay?
Okay,
Okay. So I will talk to you later today.
all right.
So Dawn, you're gonna file a motion to have a competency hearing. Is that what we're doing?
Yes.
Okay. And
You
you'll get
read the
date-
report, you'll understand.
Okay, but you'll get the date for that.
Yeah, and I'll file the motion with you and I'll also discuss some other things with you.
And Judge, just because we don't typically have competency challenged, would you want the doctor there on that hearing date or after, like set a different date for the judge or for the doctor to testify? Like, do you want to hear arguments and then set a date for testimony? or would you-
Yeah, I guess if we're gonna have testimony, to me, it makes the most sense to schedule that all initially and do it all in one day.
Okay,
Ms. Van Duzen, do you have any issue with doing it that way?
No, not at all, Your Honor.
okay.
Otherwise, we have to set 2 hearings and it just makes things take longer.
Yep, that's fine. I don't know, as a matter of procedure, I
Yeah.
wasn't sure how we wanted to handle it, but I'll make sure they get here for that, or I'll send a subpoena. for
Okay.
that.
Thank
Okay,
you, Your
very
Honor.
good. Thank you. Mr. Brian, you can let the officer that's with you know that you are done with court for today.
I'm done. I'm done. All right, go ahead, come on out.
All right, Mr. Hartung, Mr. Valero, I just requested Eric Young, so we should hopefully have him shortly.
Thank you, Your Honor.
Judge, do you still have David Hendricks and Casey McKenzie?
Yes.
Okay, just wanted to double check.
Yeah, I have not seen Mr. Dagger Margosian or Mr. Hendricks yet, though, so
Okay.
I was actually just gonna try to figure out if there was something going on with that one.
I am on Mackenzie, so.
I can check with Allison on Hendricks. I know she's on that one, so I'll see if she knows anything about it.
All right.
Oh, yeah.
Good morning, sir. You're Mr. Young.
Yes.
Mr. Malero, do you need a breakout session with Mr. Young?
I would, Your Honor. Real brief.
Give me just a second to set that up. Ms. Arnold, are you here on the David Hendricks case?
I am, Your Honor. Michael and I were both in Anzalone's court. He told me he's going to be popping on this Zoom in just a minute. So he should be here soon.
Okay. Good morning, Mr. Dagger Margosian. We're just waiting for Mr. Hendricks to get his audio connected.
Okay, thank you, Honor. Good morning.
Sorry, Judge. Mr. Dagger Margosian was legitimately in Anzalone's court. I just had gone to the wrong Zoom by mistake.
Okay, no problem. Okay, Mr. Hendricks, are you able to hear us?
Yeah, I can hear you now.
Okay. We are on the record in file 23-21267-FH, People versus David Wayne Hendricks. We are here today for a pretrial conference. We are proceeding by Zoom. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
Your Honor, Michael Dagger Margosian for Mr. Hendricks.
All right, and Mr. Dagger Margosian, where do we stand with Mr. Hendricks' case today?
Your Honor, today is a pre-trial in front of Your Honor. We, there a couple things that Ms. Arnold and I are still trying to work the case out. Part of it, part of the negotiations depends on an opinion from a potential DNA expert. We do have the materials for an expert to review. I'm just in the process of trying to get said expert. So I'm asking the court at this time to adjourn the matter. I would probably in the range of about 6 weeks or so. I think I would be able to do what I need to do in that time.
Okay, Ms. Arnold, is there anything we need to address from the people's side?
No, Your Honor, I believe we've supplied all the discovery and we're just waiting for Mr. Margosian to confer with his expert so we can have meaningful plea discussions.
Right, so Mr. Dagger Margosian, that I could do June 28th, or if you don't think that's enough time, July 12th would be the next available date.
Really, either of those work. Maybe to be on the safe side, I would probably ask for the July 12th.
Okay, so we'll go July 12th at 8:15 a.m. Mr. Dagger-Mogosian, do you prepare a stipulation in order for that adjournment?
I will, Your Honor. Thank you.
And you can sign my name to it.
Thank you.
Anything else we need to address today?
No, thank you, Your Honor.
No, Your Honor.
Thank you very much. Mr. Hendricks, you can go ahead and log out. Again, your next date is July 12th at 8:15 a.m.
Thanks.
All right, thank you, Your Honor.
Thank you. Mr. Malero, are you ready to proceed with Mr. Young?
I am, Your Honor.
All right, we are on the record in the People State of Michigan versus Eric Michael Young, file number 23-21305-FH and 23-21306-FC. These are both set for pretrial conferences this morning. We are proceeding today by partially by video conference, partially in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people today.
Salvatore Malero on behalf of Eric Young.
Okay, Mr. Hartung is here in person. Mr. Malero, Mr. Young are here by Zoom. Mr. Malero, where do we stand with Mr. Young's cases today?
So Judge, we ordered the transcript of the preliminary examination, so we are, till we get that, there's not a whole lot I can do in terms of any motions I intend to file. So we're gonna ask to adjourn this so that we can see where those are at and get them done as soon as possible.
Okay, is that something that happened recently, Mr. Malero? I don't see orders for the prelim transcript in the file yet.
We did it on March 28th.
Your Honor, I'm aware that Ms. Spade is preparing that.
Okay. All right, so maybe if that happened in district court, then I didn't,
Yeah.
might not get back far enough in the file. Okay, I just wanted to make sure that that it had in fact been ordered and there wasn't, an oversight or an accident and it hadn't, but Mr. Hartung has indicated that Ms. Spade is preparing that. So is there anything else we need to address today?
No, Your Honor.
No, Your Honor.
So Mr. Hartung or Mr. Malero, do you have any sense of when that transcript might be prepared and how far out we should look?
Judge, it says we ordered it on the 28th of March, so I'm gonna find out what an expected date is. I don't know what that is.
So I believe that I don't know how long it was or whether there's any special circumstances this one, but we're generally allowing 60 days for those, so we should be coming up on that at the end of the if I set this for June 14th, would that work?
Did you say June 14th?
Correct.
Yeah, that's fine, Judge.
That works.
So June 14th at 8:15 a.m. Mr. Malero, would you prepare that stipulation in order, please?
I will, Judge.
Okay. All right, if there's nothing else we need to address, then thank you, Mr. Hartung and Mr. Malero. Mr. Young, you can let the officer that's with you know that you are done with court for today.
Thank you, Judge. Thank you, Mr. Young.
Thank you.
All right, Judge, I'm gonna bounce. And if you need me.
Okay, thank you, Mr. Malero.
Thank you.
Mr. Marshall, I do not have Mr. Allen logged in on Zoom. I don't know whether you were anticipating him being present for this hearing or not.
I was, but I just got a text from his wife who said they weren't bringing him down. So rather than delay things, I'll just waive his appearance.
Okay. We are on the record then in file 20-20083-FH and 22-21002-FH, People versus Ronald Sanford Allen. We are here today for a hearing on the defendant's motion to correct an invalid sentence or withdraw plea. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Brueggemann.
Jennifer Bregman on behalf of the people.
And good morning, Your Honor. Hugh Marshall, P48269, Appellate Counsel on behalf of Mr. Ronald Allen. Your Honor, I did anticipate Mr. Allen and had made arrangements for him to appear by Zoom, but apparently there was a mix-up at the jail and he's not available. So rather than delay things, I'll waive his appearance and argue the motion.
I'm sorry, is he at the Lenawee County Jail or is he in an MDOC facility?
He's MDOC.
Okay, I just want to make sure if he was at the jail, I could call over and get him. So, all right, if you are willing to waive his appearance at this point, then we can proceed and you can continue with any oral arguments you have with respect to your motion.
Yes, Judge. I'm not going to obviously read my whole motion and brief into the record. I'm sure the court has read it and explained it, or read it and analyzed it. But basically, it's two arguments. This is a sentence that was outside of the guidelines, and it's very clear from the United States Supreme Court that a sentence that departs from the guidelines will be reviewed by an appellate court for reasonableness. I've cited some case law and some other issues, and my argument is that it was an unreasonable sentence when you measure that against the principle of proportionality. I've set out the factors in Steenhouse, Lockridge, Anderson, and the other case law. So no disrespect, Judge, to you, but I'm making that argument on behalf of my client. As regard to withdrawing his plea, I read through the transcript and it appeared to me that Mr. Allen was totally confused throughout the whole thing. I did read the prosecutor's response. They have a different interpretation, but there were multiple times when he seemed confused, didn't understand what was going on. His attorney tried to explain to him things, and then directly afterwards, he didn't appear to understand what he'd just been told, and he was in a total state of confusion. I've cited some case law that talks about, what does establish a knowing and voluntarily and understandingly made plea. And in a nutshell, Judge, I don't think my client entered that because he was totally confused and didn't understand what was going on. I rarely throw in an ineffective assistance of counsel case, but I did in this matter because I don't think that the trial counsel fully explained to Mr. Allen what was going on. And you could tell that between the interaction on the record between the attorney and client, and there was total confusion. And there was somewhere in the transcript.
No, I think it was a mutual between him and Swan. The TV on. Oh, it's still on. Sorry, guys.
I apologize, Mr. Marshall.
No,
Go ahead.
and there was somewhere in the transcript that Mr. Allen was under the mistaken impression that he could be facing life in prison. So when he had that misinterpretation, that factored into his decision-making process, and that's why he took the plea when he was given this information by his attorney. So again, reasonableness, proportionality. His plea was not knowingly, voluntarily, or understandingly made, and he was provided ineffective assistance of counsel.
All right, Ms. Bergman.
Thank you, Your Honor. I think I lay it out pretty well in my response, but essentially this was a bargain for sentence plea through a Killebrew, and this court accepted that agreement and sentenced Mr. Allen in accordance with that agreement. So there's nothing in Lockridge or any of the case law that's come down since Lockridge that prohibits a defendant for bargaining for a sentence under a Killebrew agreement. Obviously, he was originally charged with indecent exposure with the sexual delinquent enhancement, which is potentially a life offense. It's a 1 day to life. That has the potential of life. And so from that standpoint, defense counsel was not ineffective. He was advising his client appropriately. That statute is unusual, but it is what it is. It's either you have an indecent exposure 1 year misdemeanor, you have indecent or aggravated indecent exposure, which is a 2 year, or you have the indecent exposure with a sexual delinquent enhancement, which is a 1 day to life offense. So he had that hanging over his head, as well as the habitual offender notices, which I believe was dropped entirely on the indecent exposure charge, and then he had one habitual offender on the weapons charge. In any event, I think even if there was some confusion at the beginning of the plea, based on, and I think the transcript's pretty clear that in the beginning it does, or the defendant asks some questions and does seem to be a little bit unclear on how things played out, but I believe defense counsel adequately explained that, as well as defendant at the end indicated on the record that he agreed with everything that was said during the plea, or that's what he was agreeing to. And so I think it's quite clear when you take the record as a whole that he was very much knowing what he was pleading to, what bargain he received as a result, and this court sentenced him in accordance. So I believe, again, from a departing perspective, Killebrew, if you bargain for your sentence, knowing what you're exposed to, and this court agrees with that and imposes that, the departure issue is a non-issue. I would agree that if we had sentencing guidelines where this court departed from the sentencing guidelines without the Killebrew, that the court would have an obligation to say why it departed. And again, I believe you acknowledged on the record the bargain and things that go into the plea, and that the parties knowingly and understandably came to that agreement. So again, I don't believe, certainly there's no ineffectiveness here, and I believe the sentence is valid, and therefore there's no, there should be no right to change that sentence or amend it, if you will. And certainly he has not met the burden for withdrawing his plea. So I'd ask the court to deny the motion.
All right, Mr. Marshall, if you care for any rebuttal, you can do that now.
No rebuttal, Judge.
All right. With respect to the plea being voluntary and understandably entered. I think if we look at the totality of the transcript, that it is clear to me that Mr. Allen understood the plea that he was entering and the bargain that he was making at the time he entered it. There is in the transcript some initial confusion on the part of Mr. Allen with respect to what exactly he was pleading to. I believe Mr. Goldstein cleared that up on the record, as well as any question about what his potential sentence on the aggravated indecent exposure charge would be. Looking at page 9, starting at line 1 of the transcript, Mr. Allen says it's a 2-year max, but he said 24 to 36 on 1. And then he said that would be, Mr. Goldstein states at that point, well, that's because you have a prior felony. And Mr. Allen says, okay, that's fine. I again asked Mr. Allen at that point if he wanted to proceed with his plea, knowing that information, and he agreed. And after that, I again advised him of the maximum penalty on the aggravated indecent exposure charge being 4 years. He said that he understood that, and he continued with his plea thereafter. So I disagree with the notion that Mr. Allen was totally confused when we look at the context of the entire transcript. With respect to the proportionality of Mr. Allen's sentence, I believe that it is proportional. I believe that there was an adequate basis for exceeding the sentencing guidelines, that being the Killebrew agreement entered into between the people and Mr. Allen. That is something that is obviously not considered by the sentencing guidelines. It's simply, the fact that there's been a sentencing agreement is simply not taken into account in any way by the sentencing guidelines. As indicated at the sentencing hearing, a sentencing agreement reflects the parties' perceptions of the strengths and weaknesses of their case. And Mr. Allen, in this case, did receive a significant benefit as a result of entering into this plea. The defendant in this case was charged with aggravated indecent exposure as a sexually delinquent person. The potential sentence for that, as Ms. Brugman indicated, is 1 day to life in prison. And the people in the defense created a bargain in which that potential for a life sentence was removed in return for the sentence that was imposed. And so I think that is reasonable and provides an appropriate basis for departing from sentencing guidelines. I don't think that Mr. Goldstein in this case was ineffective. I do recognize that there was, again, some initial confusion on the part of Mr. Allen during his plea hearing. But as indicated earlier, I believe that in looking at the totality of the transcript of that hearing, that Mr. Allen's confusion was cleared up and that he voluntarily and knowingly entered his plea. And so we will deny defendant's motion for those reasons.
Very good, Judge.
Mr. Marshall, would you prepare an order that's consistent with that?
I will do, Judge.
Okay. If there's nothing else, thank you for your time. You can both go ahead and log out.
Thank you.
Your
Have a
Honor.
good day.
All right, sir, you are Casey McKenzie.
Jose Pango.
Yes, sir.
Mr. Sala, are you there?
I am.
Okay, I'm gonna put you in a breakout session with Mr. McKenzie. If you give me just a moment.
No, I think Ms. Mears is on this case. We're waiting for the preliminary exam transcript to be printed, transcribed. He's
Okay,
there.
so you don't, yeah, sorry. So you don't need a breakout room.
No.
Could I ask you a question though?
Well, then I need a breakout room.
Yeah, I need a breakout.
Sorry, Your Honor.
No problem. Let me set that up. Give me just a second here. Ms. Underwood, have you heard from Mr. Stepanski? Ms. Underwood, are you there? Ms. Underwood, have you heard from Mr. Stepanski?
Your Honor, unfortunately, I have not. I just, Mr. Stepanski, I just spoke to his attorney from Oakland County, Your Honor. Mr. Stepanski was supposed to be in court there yesterday and did not appear. At this point, I am concerned. So, with that being
Okay.
said, I would
Let me-
ask the court.
Let me call the case.
Thank you.
This is file 18-18984-FH, People versus John Robert Stepanski. This is set today for a pretrial hearing on probation violation. We're proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Stepanski, Your Honor.
And you were just discussing, or we were just discussing off the record, Mr. Stepanski is not present here in the courtroom. He's not logged into the Zoom session.
Your Honor, I have had communications with Mr. Stepanski. I know he planned on being here. However, I just spoke to his attorney in Oakland County, because I know he had a sentencing there yesterday, and he did not appear for that. I would ask the court, if the court is going to issue a bench warrant, to give it a 48-hour period, grace period, so we can attempt to locate Mr. Stepanski.
All right, so this was set for a hearing this morning at 8:15 a.m. It's now 10:27 a.m. Mr. Stepanski has not been present in person in the courtroom at any point this morning, nor has he been logged into the Zoom session. I would indicate for the record that at our last hearing, I allowed a personal recognizance bond GPS tether. in looking at the court's file, it does not appear that the GPS tether was placed. I don't have that paperwork in the file. So it appears to me that Mr. Stefanski is not on the GPS tether as required by his bond conditions at the last hearing. In addition to that, Mr. Stefanski has apparently not appeared for a sentencing hearing in Oakland County. And the court is previously aware of Mr. Stefanski's serious issues with substance abuse and a history of things like this occurring. Mr. Stefanski just dropping out, not appearing, not reporting, and unfortunately slipping back into his substance abuse. And so I don't think that a 48-hour grace period is appropriate under those circumstances. I think we need to find Mr. again. And for that reason, I'm going to revoke and forfeit Mr. Stefanski's bond. I'm going to issue a bench warrant for his arrest, and I'm going to set bond on the bench warrant at $100,000 cash or surety.
Thank you, Your Honor.
Thank you, Ms. Underwood. Mr. Sal, are you ready to proceed with Mr. McKenzie? You are muted, Mr. Sal.
I am, Your Honor. Thank you.
Okay, so we are on the record in People versus Casey Michael McKenzie, file number 21-20677-FC and file 23-212. I'm sorry, 23-21324-FH. These are both, 21 cases set for a probation violation pretrial. The 23 cases set for a pretrial hearing. We are proceeding today by video conference. Ms. Mayor, would you like to place your appearance on the record?
AB Mayor on behalf of the people.
Stan Sal on behalf of Mr. McKenzie.
All right, Mr. Sala, where do we stand with Mr. McKenzie's cases today?
We're awaiting the preliminary exam transcript to be transcribed, and we're anticipating a motion in that regard. We did address bond last time. The court issued a PR tether for the probation violation, but he also has some pending charges that he has a $4,000 cash or surety bond on, and we're asking that he be allowed PR tether on that one as well, so he can actually be out of jail until we get the motion filed and proceed in that regard. The probation violation, I don't know if the court recalls, but it's because he missed one of his meetings. Miss Holly violated him because he failed to report as instructed on November 15th, and he failed to notify of a current address. So it's not like he's a risk or anything at this point. So we're asking the PR tether on both files.
Ms. Mayor.
I guess as far as him being a risk, I do think he's alleged to have committed these new crimes while on probation, but as far as bond goes, I'll leave it in the discretion of the court if they want to mirror those bonds. I do think that some motions are going to be necessary in this case that could take a little bit of time. I think if he has a GPS tether on, that'd be sufficient to get him to comply with both probation and bond conditions.
So this is the first time that Mr. McKenzie has appeared on the 23 case. Because he waived arraignment, and this was set as the first pretrial. So the court's not had any experience with the bond in this case. And at the time that I issued the PR bond with GPS tether in the 21 case, which was the violation of probation for failing to report, don't believe I was aware of the current charges, which are carrying a concealed weapon, possession of a firearm by a felon, and felony firearm, and assaulting, resisting, obstructing police officer. Bond on that case is $4,000 cash or surety. Note in that case that Mr. McKenzie is charged as a fourth habitual offender. And although it's listed as a fourth offense notice, there are 5 prior convictions listed in that offense notice. Which include carrying a concealed weapon, assault with a dangerous weapon, another assault with a dangerous weapon, and home invasion. I think that given those circumstances, Mr. McKenzie clearly has an assaultive past and has assaultive behavior charged in this case, as well as the carrying a concealed weapon and weapons charges. I think that the $4,000 bond is reasonable in this case, given the circumstances. So,
all right. The only other thing I would
buy that bond.
Okay. My client was going to add in that he wanted to go on Vivitrol if that would help, but it doesn't sound like that would help in this case, Your Honor.
And I'll contact community mental health and get into an outpatient rehab as soon as possible.
All right, well, maybe I can look at that after we have a hearing on the motion that Mr. Sala is going to file, but at this point, given Mr. McKenzie's past conduct, I'm not willing to modify the bond. I think it's reasonably, frankly, very reasonably set in this situation.
Okay, thank you, Your Honor. Mr. McKenzie, just before you leave, don't get the tether and pay for it, because then you'll potentially be out on bond with your probation violation and you won't get credit for any time served. So
I think they already paid it at 8 o'clock. Would I get it reimbursed or no?
Well, you're going to have to find out through whoever paid it.
All right.
Okay.
Do you have a motion hearing date set, Mr. Sala?
No, we're still waiting for the transcript, Your Honor, to be transcribed. We don't have it. It'll be quite a while before that happens.
All right, let me set it for June 14th for our next pretrial then at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Mr. Sala, would you prepare that stipulation in order, please?
Yes, Your Honor. May I sign Ms. Mears' name on it?
Yes.
Thank you.
All right, thank you. Mr. McKenzie, you can let them know you're done with court.
Thank you.
Great. Thanks, Judge. I don't think I have anything else.
Yeah.
Okay, thank you, Ms. Mayor. Thank you, Mr. Moore. I think that is everything.
All right, thank you, Your Honor.
You can go ahead, come on out. Put that up, thank you. Take a brief recess and I'll be right back.
Thank you. Can you put that up one more time? Thank you. Yes. You want me to- Everybody ready to go? Ready to go? Good. Thank you. So.
All rise. Circuit Court is in session. The Honorable Michael Saber presiding. May see. Good morning. We are back on the record in file 20-206-488-NO. Are we ready to have the jury brought back in?
Judge, I just have one matter I want to inquire of the court about. I know the court has made rulings. It's been subject to back and forth. I went back to the office and I just wanted to bring to the court's attention. There's a case evaluation summary previously referring to a facilitation summary placed on October 21st, 2021. In that summary, it was stated, although Mark returned to work for some time after the accident, his job was initially modified to limit the use of his arms, driving a forklift with one arm, and he was later moved to doing computer work. He's currently unemployed because when that work ran out, he was unable to perform his prior job duties at Antiva due to the pain. So that was information was before a case evaluation panel in October of 2021. My question to you is, and I respect the court's ruling, he's talked about his work as a quality auditor. He's talked about that he did the high-low. And given that this was something that was before a panel where defense counsel was in October, I'm asking if I can ask him, are you still working at Antiva? Which the answer would be no. And ask him, if so, why not? And it's consistent with what was outlined in the case evaluation summary. It was also consistent with what he talked about, pages 65 to 69 of his deposition, that if he had to go back to the other job, he wouldn't be able to do it. I respect the court's ruling. I'm concerned that the jury is going to be left with a gap and believe that he's still working at this job. And if he had pain that prevented him from working, it does go to the quality of his life and his injuries. And I don't want to cross the line. So I'm bringing that question to you so that you can tell me and give me direction before he goes back to his.
I would at this point rely on the reasoning and logic of my previous ruling in that if you plaintiff were intending to proceed on a wage loss theory, that they needed to do more to update their calculations of damages than make a statement in a case evaluation or facilitation brief. I referenced the tax returns that had been provided for the years in which he was still working that were apparently not updated for the years in which after which he stopped working. And as I indicated, I believe that deprived the defense from an opportunity to investigate and further develop a defense with respect to those issues.
Just one point of clarification, the actual tax returns, I have the copy, were actually, they were requested by the defense. So it wasn't like they asked us for them, we provided to them. Mr. Bishop would have signed authorizations for them to produce those. When they requested those, the date of that request, January 27th, 2021, after his deposition, they requested the United States Treasury to produce them on February 10th, 2021. There was a notice of deposition taken. The tax returns that they had requested were encompassing 2013 through 2019. And my final point would be, given that this case evaluation occurred and they knew that he was not working, if they wanted to update their request, they could have. He provided and signed any authorizations that were necessary to obtain that information. And then I'll sit down and respect the court's ruling.
All right.
and we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before their honorable, the justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and my apologies for the late start, but I'm glad you could both be here. We will be hearing argument by Zoom this morning in number 23P 431, Darren Whitman versus Department of Correction. Each side will have 15 minutes. There's no rebuttal. We have read your briefs. We've looked at the relevant parts of the record. And so our suggestion would be to get right to the heart of your argument. And with that, Mr. Whitman, why don't you go ahead?
Okay, I'm not good at this, so please forgive me if I don't come across very well. My name is Darren Whitman. I'm serving a natural life sentence for first-degree murder, a crime that I have stated and maintained my innocence to. This appeal from an order of the Superior Court dismissal for declaratory judgment pursuant to MGL 231A was requested for 1, to permanently enjoin the defendants from further violations of duly enacted state law, and 2, to obtain the determination of the legality of the administrative practices and procedures of the Department of Corrections to house 2 inmates to a cell despite state law that's contrary to the defendant's practices.
Mr. Whitman.
Sorry, this is back to you.
No, go ahead.
Can I ask you just whether you yourself are currently or have at any time during the course of this litigation been double bunked?
Yes.
So you are currently?
No, not right now. What they do is that they say single cells are a privilege. So you have to go through this long drawn out process of staying out of trouble and to obtain a single cell. But that's not what the law currently states.
And then my second my follow-up on that would be, part of your argument seems to be that the MCI Norfolk is no longer overcrowded. Yes?
No, in fact, the DOC has seen a significant drop of inmates.
How do we know what the right number is? Is there?
Well, they do. DOC has a fact sheet, a fact card that comes out. If I'm not mistaken, they're currently at, as of July 1st, 2023, they're at 5,477 prisoners within the Department of Corrections. And this is according to the DOC fact card of 2023. Now, in 2009, there were at 2009, they were at 11,173 inmates that were currently housed at that time.
How many are there at Norfolk?
Oh, I do believe it's over 1,000.
And how many cells are there at Norfolk?
Oh, that's a good question.
Let me put it this way. Are there enough cells so that each inmate currently at Norfolk could go into an individual cell? Or would that involve transferring inmates to other institutions?
Well, some of the inmates should not be here. If the DOC would do the proper assessment of individuals with low scores, those individuals will be going to minimums or pre-releases or something like that. A lot of individuals are not even supposed to be here because of their high score. They shouldn't be slated for medium security.
So here's my question. The statute on which you rely, section 22, says, nor unless the crowded state of the institution so requires, shall any 2 prisoners other than debtors be allowed to occupy the same room. So it doesn't seem like the statute requires DOC to distribute inmates throughout its entire system so that the maximum number can have a single cell. It seems like that's done on an institution by institution basis.
That may be right, but the beginning part of the law clearly states that each person is supposed to be in a single cell. And
Well, I'm not sure what part says that.
well, that comes at the beginning. It says male and female prisoners shall not be kept in the same cell, in the same room. That comes off that's first part of the law. It also says in there that the commissioner, let me find it here. Come on, where you at?
Mr. Whitman, we can look at the law itself. My question is, were you allowed to get any information or discovery from DOC as to how many cells there are at Norfolk and how many inmates they are currently at Norfolk? Were you able to get that information?
No, I did not ask, and that was my fault. Like I said, I'm new to this. This is me bringing it forward. I did not think to request that. But I would tell you like this, they have a unit that they started here maybe about 6 months ago, where they said, okay, we're gonna start this as single cells. So they started moving people into unit 7-1 that they decided they wanted there in a single cell. If that's the case, then why haven't they done it with the entire institution? The entire institution should be single cell. I mean, this will be in keeping with rehabilitative progress and everything else. Right now, we're sitting here and we're going through more problems, dealing with drugs, dealing with theft and things like that. And this is because you have too many people in one place doing absolutely nothing. And
well, Mr. Whitman, I understand all those issues, but my understanding of your lawsuit, it's specific as to the fact that you're alleging that the institution is violating the statute because they are double bunking when it is not overcrowded. So what the Superior Court needed to look at was, is there overcrowding and is there double bunking? And I'm not sure there was enough information, and I'm not faulting you. I understand you're not a lawyer. I understand you may not have requested it, but that is the sort of the gist of your lawsuit. Am I correct?
Yes, yes. It basically, I'm just saying that 127.22 should be implemented as written. It calls.
Can I ask you a question on that? And they're admittedly older cases, but we have some cases in our court, in the Supreme Judicial Court, that talk about situations where there are problems with sanitary conditions at correctional institutions and enforcement of Department of Public Health regulations. And those cases seem to say that the solution for someone in your spot is to contact the Attorney General's office, and then the Attorney General's office would have to sue or try to force the institution to do something different. Why is this a different situation where you as an individual inmate get to file this lawsuit on behalf of everybody, basically?
Well, I wasn't so much doing it for everybody. It was just, first and foremost, it was something that I've seen. We're held to a standard when it comes to following rules and regulations and everything else. When this was brought to my attention, I'm like, well, why isn't the DOC following it? So my thing was, I asked about it. The deputy superintendent said up there, well, if we got to do it for you, we got to do it for everybody. Where's the state law? Yes, you do. So they never got back in contact with me. Put in the grievances and everything. What am I supposed to do?
I wanted to ask about the grievance. Did you ever get a final decision on your formal grievance? Or was the last thing that you heard that they were extending the time for response?
No, the final decision, if I'm not mistaken, was that they said single cells was a privilege and they denied it. So I'm like, okay, where is this saying that this is supposed to be a privilege? Because there's nothing written that says that single cells is considered a privilege.
Okay, so just to make sure I understand, though, so in the record of this case, we do have the, I believe, a copy of the notice from a grievance official within the institution that they were extending the time to respond. Did you hear something from them after that?
Yeah, that's when they gave me the now. They said the single cells is a privilege and left it as that. So once that occurred, I took it further. I took it to court. Because once I started looking further and I didn't see anything that suggested that single cells was a privilege. I'm like, then where are they getting it from? Even their DOC policies does not reflect none of this stuff. If anything, if they created a DOC policy when it comes to housing, the authority on that would be 12722, separation of prisoners. I mean, by its very name, it tells you how the prisoners are supposed to be. They want the legislation wanted the prisoners housed. Now, I understand that you have the emergency clause and things like that. Well, if you're going to contend that Norfolk is doubled up and it was appropriate, then what started it, all this doubling up in the first place? Because there has to be a start point somewhere for this to go for this to start. You have a law that strongly says we're supposed to be single cell, unless there's an emergency. Well, what's the emergency? What was the emergency? Because the last time I looked at when we had a influx of inmates coming into the institution, that was back in the 80s when they got the tough on crime bill. We don't have that now. In fact, we got the decarceration bill that's saying that, listen, prisons are to be, more inmates that got to be let go. And this, did you
get cleaned out pretty well during COVID? I know a lot of the institutions did.
For me, yeah, because I'm in my 50s. I'm not trying to catch anything.
No, my question is though, during that time period, a lot of there was a pretty good push to reduce the population. Did that happen where you are?
I do believe some people left. I can't say how many left, but I've known a few dudes that attempted to do it. They got denied and then ended up passing away. You know, and one has to think, what's going to happen to me? I'm working on my case. I'm trying to get back out there in the streets and everything. I don't want to die in here. But you got to, from my standpoint, if I don't take responsibility or if I don't think about myself more, I can't rely on the DOC to do it.
May I ask, Mr. Whitman, when you have been double bunked in the past, have your cellmates been convicted of first-degree murder or only other crimes?
I've been in cells with people of all kinds of crimes.
I guess what I should ask is, have you been in a cell with someone who has not been convicted of what you might call an infamous crime? Because the statute uses that term.
Yes, I have quite a few times, both infamous and non-infamous. But I've actually gotten into a fight that got me put in a hole over the fact that I have a medical issue. I got into a fight. I got, guy jumped on me. I defended myself. I went to the hole for it. I shouldn't have to go through that because I have a medical condition, and it requires me to use the bathroom. He didn't like that. I told the administration, well, they done nothing. And the end result was me getting jumped on. I shouldn't have to go through that. No one should have to go through something like that, especially when you have other ways of dealing with things. Put inmates in a single cell the way they're supposed to be. There'll be far less of a negative atmosphere within the institution, especially at Norfolk. You got too many people here that's not even supposed to be here. There's been an influx of people from maximum security prison. I'm like, a lot of these dudes don't even have the score, the points to come down to a lower security, but yet and still they're here. And it's been a big problem. So why should anybody walk around look about over their shoulder just to make sure that they're caught up in anything? But that's my issue is, listen, this law is self-explanatory and it should be followed. In fact, it tells the commissioner to make sure that they make rules and regulations that is following the actions that is written in the law. But there is none. There is none. So where do we go from here?
All right, well, your time's just about up. So unless other members of the panel have further questions, we'll hear from Attorney Gordon for the Department of Correction.
Thank you, Your Honor. Richard Gordon for the Department of Correction, and may it please the court. Your Honors, first, I'd like to start by stating that this case was decided on a straight Rule 12b6 motion to dismiss. So I was not aware that Mr. Whitman was housed in a single cell. I'd suggest to the court that would moot this case, even if it is now on appeal. But even if it isn't moot, Your Honor, the lower court, Judge Cloutier, did correctly dismiss this case. She did not rule on a blank slate, judges. There were 3 cases that I cited in my memorandum, albeit federal district court cases involving 3 federal district court judges, all of whom held that this particular statute, General Law 127, Section 22, does not create a private cause of action. And she expressly adopted that in her endorsement of the motion to dismiss.
So Attorney Gordon, if there is a clear violation of the statute, and I think we're going to get to in a few moments, at least from my perspective, whether there is a clear violation, but assuming there is a clear violation, what is an inmate supposed to do?
Well, as Justice Brennan pointed out, certainly contacting the Attorney General's office to have a private suit. Certainly the Attorney General has the ability as the chief law enforcement officer of the state, of the Commonwealth, to enforce this statute. And so that would be the first recourse. And I'd note, Your Honor, that oftentimes these double bunking types of issues might involve something where there's an altercation between cellmates or some such thing where there's an actual injury, in which case, the inmate would have a cause of action for alleged failure to protect. Certainly if, say the statute states that male and female prisoners shall not be put in the same room. And if we do that and there's an incident, certainly there would be a cause for damages under 42 USC 1983. So there are other remedies other than simply relying on this statute.
Why not a grievance? And then seeking judicial review if the grievance has been finally determined.
That's an interesting point, Justice Sachs, that I hadn't thought of. I certainly had not read Mr. Whitman's complaint as asserting a review of a grievance, which is why I filed the straight motion to dismiss. I read it as solely relying upon the statute.
Well, those are also relying on the declaratory judgment statute. So even if there hadn't been a grievance, why isn't that a permissible way of asserting a violation, a continuing violation of a statute against a state agency?
Well, Your Honor, I think to assert, a grievance review type claim under 127 Section 38H, which is a statute that's available to inmates, they have to sort of stylize their complaint in such a way that the attorney at the Department of Correction is on notice that that's what they're doing, so that we can file an administrative record, and that the administrative record will presumably state, what the grounds, what the grievance coordinator did to investigate the claims, what the superintendent did to deny the appeal.
Well, it sounds to me like the record is pretty good on that, in the sense that Mr. Whitman filed the grievance and the response was, which is problematic in my opinion, that it's a privilege to be single bunked. It seems to me the statute doesn't say anything about privilege. It seems to me it's the opposite. It's the default position, according to the statute, is they're supposed to be single bunked. And it's the institution that decides by, and I'll quote your brief, unless the crowded state of the institution so requires.
Yes, Your Honor, that is what the statute states. There simply aren't enough bunks to single bunk every single inmate. And so as a result, inmates can get a single cell through a number of mechanisms. First and foremost would be if there is a medical or mental health need for that inmate to be in a single cell. Certainly those types of orders do occur.
So is it the institution's position, and I would love to ask specifics if you know them, which I believe, I can't remember which one of my colleagues asked Mr. Whitman, is, are there 1,000 cells and are there more than 1,000 inmates currently at Norfolk? What's the numbers?
Your Honor, none of that is in the record. Again, it was decided on a straight Rule 12b6 motion to dismiss. So none of that is in the record.
Well, except you're arguing in your brief that unless the crowded state of the institution so requires. So what is the crowded state of the institution which so requires that this statute not be followed?
Your Honor, I'm arguing first and foremost, and the reason that Judge Cloutier allowed the motion to dismiss is that there's no private cause of action here.
And if we don't adopt that, let's move on to the next argument.
Yeah, absolutely, Your Honor. Whether or not the crowded state of the institution requires that some inmates be double bunked is certainly something that is left to the sound discretion of prison administrators. And I'd point the court to a couple of other statutes which have to be read in harmony. Certainly the statutes which delineate the commissioner's duties and responsibilities and powers, and certainly the statutes that delineate the superintendent's powers to take charge of the institution.
But your argument.
Can I just stop you for one second? Do you agree that designation is based on seniority and good behavior? Those are two of the criteria.
Yeah, absolutely. Absolutely.
And what authority do you point to? And maybe that's where you're going. What authority do you point to for the commissioner to designate single cells on those bases?
Well, certainly the commissioner has authority to classify and transfer inmates. I mean, that's in 124 section 1. That's in the transfer statute.
Right, but I'm talking about designating, saying within a particular institution, saying, okay, we only have a certain number of single cells available. And so the way we're going to figure out who gets what is if you're on good behavior, if you've been around for a while and on good behavior, you get the single. And as opposed to, where does that come from? It seems to me that it's not, I mean, it makes sense, but it seems rather arbitrary in the more generic sense.
Again, Your Honor, I think it emanates from the general laws that I stated, the duties and the powers of the commissioner and the duties and powers of the superintendent, which are in the general laws. In addition to the cases over the years holding that there's no right to a single cell. Bullfish, going back to
right. There may be no constitutional right, but the statute does seem to put certain rights on when the commissioner can house certain kinds of inmates together. My question is, under the other statutes that you cite, the commissioner may well have some discretion to determine whether the crowded state of the institution requires, but is that discretion reviewable by a court? Could a court say, look, the undisputed facts are, and they're not shown here, obviously, but hypothetically, could a court say, look, the undisputed facts are there 1,000 inmates, 500 inmates at Norfolk. There are 1,200 cells, and yet they're all double celled. And the commissioner doesn't have any explanation of why that is, other than that single celling is a privilege. Could not the commissioner's decision be reviewed either on review of an individual grievance or under the declaratory judgment statute for abuse of discretion?
I suppose it could be reviewed in the sense that if the hypothetical that you posed, it might sound to cause unconstitutional conditions.
No, I'm
Certainly,
just talking about a statutory violation.
again, Your Honor, I think that it would be, that case involving the DPH regulations against the Sheriff's Department. I think it would be up to the Attorney General's office to have to bring.
Why doesn't the declaratory judgment statute allow a court to review what the commissioner did and is doing on an ongoing basis, if that were proven, for abuse of discretion? I mean, I don't know that you've cited any case that says the declaratory judgment statute is not available, or that, for that matter, the grievance judicial review statute is not available.
Yeah, Your Honor, the grievance review statute, I'll be honest, that one caught me by surprise. I hadn't thought about that, and it wasn't raised.
This did start at the grievance, right?
It did. Well, they have to, Your Honor. I mean, you have to exhaust, as you well know, Justice Sachs. I mean,
and did he exhaust?
I believe so. Yes, I did not argue, failure to exhaust under the Prison Litigation Reform Act. I just never read, usually an inmate would have to plead in his complaint that he's seeking judicial review of a grievance. I read it as certainly him stating that he had a statutory right to have a single cell. And for that reason, I moved to dismiss, because there's a number of cases, as I stated, federal cases that don't bind this court, but I would say are persuasive, that there's no private cause of action under this statute.
Well, they might be more persuasive if they had considered and rejected theories of review that involve the grievance or declaratory judgment, but I didn't see any of the 3 federal cases that you cited considering either of those theories.
No, Your Honor, and I don't think that. I mean, look, if Mr. Whitman was asserting a claim for a grievance review, I mean, it's certainly news to me. I think it's up to him to plead it, and pro se complaints are construed liberally. Sure, the cases very much stand for that proposition, but I have to be on notice to address things when they're, whether or not that's a count, and I didn't see that anywhere in the complaint.
Counsel, is Norfolk overcrowded?
Norfolk, the court can take notice, I suppose, of the fact that that the inmate count is down, Your Honor, but also that the number of facilities in the past several years has closed.
I'm not asking about facilities, and I know maybe I'm going outside the record, but I'm going to ask it again. How many cells are there at Norfolk, and how many inmates are there currently in Norfolk?
I don't have that. I am happy to find those 2 numbers out and submit a 16L letter if it will, if the court wishes.
I would appreciate that.
Yeah. So, Your Honor, just so I am clear, you want to know how many inmates there are today and how many cells there are?
Correct.
Yeah.
It seems to me, again, if you black letter of the statute, and I know there might be other reasons why the commissioners say there's overcrowding, but again, hypothetically, if there are 1,000 cells and there are 1,005 inmates, that to me would be legitimate for the commissioner to say the crowded state of the institution requires at least some double bunking. If there's 1,000 cells and there's 800 inmates at Norfolk, then there might be an issue. Again, that's just, I'm reading black letter. There might be other reasons, but.
Your Honor, I will have a 16L. Oh, I'm sorry.
How fluid is that number? I'm trying to get it, because I looked at it the same way Justice D'Angelo did, but I'm concerned that that number is fluid, that the number of folks who might be sick or have mental illness or otherwise need to be segregated for safety reasons is a fluid number. It just, that's my concern when we start to.
I mean, people are coming in and out. People are coming in and out at all times, Your Honor. You might have inmates who are wrapping their sentences, inmates who are getting paroled, inmates who are going to lower custody. And then in the same token, Your Honor, you might have inmates who are going to higher custody. As you said, people going to hospitals, people going to the state hospital or to outside hospitals because of medical issues. It is completely fluid, on any given day, but
Your
you know,
16L
it
would be a
just,
snapshot. It's a snapshot. And for example, the day after, the day before, the week after, it could differ or not at all. Or it could differ substantially, not at all. Is that your thought?
it could very much differ, but you know, to Justice D'Angelo's point, I'll get a 16L letter by the end of the week with today's number.
And maybe you could just tell us as well what the fluctuation has been within the last month or the last 30-day period or whatever, because I can see how even if there were 1,000 cells and on one particular day there were 999 inmates, if you know that you've got people coming back from the hospital or needing to be transferred from other institutions, you can't transfer an inmate to a single cell necessarily. If the next night he's going to have to be bumped back to his original cell because you got to make room for somebody who actually, needs a single cell because they have enemies or whatever it might be.
Yeah, and Justice Sachs, you might have a situation where you need to keep a single cell open because you might assume if there's an emergency, you need to separate inmates or some such thing. None of that is in the record, but I will, to Justice D'Angelo's point, I'll get today's number, and to Justice Sachs's point, I'll get 1 month ago's numbers, I should say, and submit a 16L letter by the end of the week.
Thank you. Unless there are any further questions from the panel, and I'm not seeing any, that concludes our argument. Thank you both very much for your able presentations, and we'll take the case under advisement. And that concludes our Zoom session. We will resume with hearing other arguments in a few moments from the
Give me a moment. And Diana, which room did you say you were in? Okay, that's okay.
No, it is not okay. My apologies.
Oh, it's fine. We have not started yet.
Well, that's very kind of you, but that is not acceptable. My apologies.
Your Honor, for that outburst, can we please put a tracker on Hank Wilkins?
All right, so we can have Mr. Davis come down, please.
The record reflects that Zach Dunn is going to single wife female me.
I went to a COE where a guy that was talking, a federal thing was talking about how his phone was a tracker. And he said, and he chose a random day. He said, what is scary about it is how boring my life is. I wouldn't go into any place interesting.
All right, we're going to go on the record. Court is calling 2022 CR 1227. State of Texas versus Anthony Lee Davis. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Eddie Brovinick for Mr. Davis.
And are you Mr. Davis? All right, you're going to need to speak up so that the court reporter can hear. All right. And just one moment, everyone. Let me go to the real time. Dana, could you do a test? Just write the word testing. All right, it's up. Thank you. All right, Mr. Davis, I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Anthony Lee Davis who's placed on community supervision in 2022 CR 1227 for the offense of evading arrest, detention with a vehicle on June 28, 2022 for a term of 7 years? Is that you? All right, state.
Violated condition number 14U on or about the 28th day of November 2023 in Bexar County, Texas. The defendant, Anthony Lee Davis, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and/or supervision officer and/or the head of or authorized personnel of the following program. Parenting class in violation of condition number 14U.
All right, to that, how do you plead? True or not true?
And we waive the other violations alleged in the motion, Your Honor.
Any objection?
No, Your Honor.
All right, did you understand by pleading true to violation 14U, the court could find it true, grant the motion, and sentence you up to 7 years in prison and up to $1,000 fine? Knowing that, do you still wish to plead true to 14U? All right, you're whispering. Court will find 14U true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on supervision, and amend conditions to include the state ISF cognitive treatment track, followed by ISP supervision and continue mental health care with CHCS or Be Well, Texas upon his return.
That's our agreement, Your Honor.
All right. Probation, just one moment. Is that the probation's recommendation? All right, Mr. Davis, you wanted to say something? Sure. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
I also have a.
State your name for the record.
Davis.
Yes. What did you want to say?
I also have an address of my sister's house, if I can go there and still get help with my.
Now, here's the thing. We've tried that. And you haven't followed through. So it appears that the only way you're going to follow through is if you're an inpatient. Now you have choices today, and I'm going to give you a choice. Sometimes I can give people choices, sometimes I cannot. So here's your choice. You can go to prison for 5 years, or either you can go to state ISF, and I'm going to order that you be on GPS, and you are not allowed to live with your mother because there's a no contact order in place. You're not allowed to live with your sister unless your sister submits a letter to the court or comes into the court and says that she wants you to live there. And even then, I may not allow you to live with her. You understand? Because a lot of people will be at the jail, they'll be at prison, they get out and they say, oh, this person wants me to live with them. And they're just assuming that because of the familial relationship, that somebody is okay with them living with them. You understand? So what would you like to do? Do you want me to try to give you the help you need? Or do you want to go to prison? You go to prison, you get out of prison, you can do whatever you want to do. All right, so why have you not been following through on what I've been ordering for you to do?
Well, at first I had no contact order at my mom's house, so I wasn't able to stay there. So I was really homeless until I worked my way up to have a car. Then I was living out of my car, and the communication was just bad because they were trying to reach me through my mom, and me and my mom weren't even on.
Why didn't you just go to probation? Probation has a physical office that you can go to. And I know that when people are on probation out of this court, I tell them if there's an issue with probation, they can always come back to the court. So you didn't come here.
When I was going to probation, and then I was doing the Center for Healthcare Services as well. So the Center for Healthcare Services lady was telling me not to report to my old probation officer. And so that was where the mix-up happened. But I was going to my probations, like when I was supposed to report, I was showing up. That was just that one time that I didn't show up at the end, and it was just bad communication. They didn't reach out to me, they reached out to my mom.
All right, this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include ISF cognitive, GPS partial for any mental health treatment, waive fees, and you to follow through with Center for Healthcare Services, and also for Be Well. And there's still to be no contact with your mother. Now, what's going to end up happening? We can go off the record. This is what's going to end up happening. When I say no contact with your mother, once you are stabilized with your medications and you've shown the court that you are actually following through on your mental health issues, then I'll consider allowing you to have contact with your mother, not live with her, but have contact with her. Then ultimately, if things are still going well and she wants you to stay with her, then I will consider that. But now you are not in a position where you should be staying with anyone. Now you're in a position where you should have your mental health issues addressed. Otherwise, this probation is not going to end well for you. You understand? Is there anything else you need from the court to be successful? I'm sorry?
No.
All right. So I'm going to say this again. I've said it before. If there's an issue and you feel as though probation is not addressing that issue, you can always come back to the court. We are here. Do you understand?
She's saying that you know where the courthouse is. and you can't figure out anything else, you show up at this court, they'll contact and they'll bring you in front of the judge. I know this sounds crazy. She actually will, well, I'm just telling you. So, because she's telling you there won't be any excuses. Or are we co-hosts here?
Yes.
Okay.
All right, yes. And of course, I'm not here on Saturdays and Sundays, but throughout the week I am. All right, probation, is there anything else he needs? All right, good luck to you.
They're gonna send you
yes.
you'll wait about 4 weeks and you'll be sent to the treatment facility. You'll be there about 2 months.
Hello.
I have the opportunity to speak about Mr. Hunt. I want to state as well, based on what I think we're coming in agreement. I think it's like
Yeah.
$20,000. I've explained the condition of the
All right, so because the jury is coming up, if you make that agreement to Judge Nahara, I'm sure he'll sign off on it.
Thank you, Judge.
Right,
We appreciate
thank you.
it.
And do you need the case number or anything?
Yes.
All right, so they will, can you make her a copy of this? And so they'll give you a copy of this and a B page for them. And then they'll sign off on it, then you can take this to Judge Nahara. All right, thank you so much.
So he's good to go, Judge?
Yes. All right, before the jury comes in, I'm going to fill up my water.
They were just aligning them outside, Judge.
All right, thank you.
Felony drug card.
No, Judge Nahara won't need to see him, I don't believe. Thank you.
He's been going to that witness now. Okay, so we have the chair over there for.
Oh, yeah, we.
On the witness. Oh, Judge, one. I think it was a witness stand, I think it was a chair on the side. But you can put the chair on the side. Yeah, no, not really.
Really? Isn't that kind of long?
I can, oh, you prefer down there? Judge, you wanted him on the witness stand or down here?
Oh, either way is fine.
Oh, so you don't want him on there.
Okay.
So it's the felony, it's still in the felony drug evaluation is holding them up. Okay. Check back in a day, or two, I guess.
Okay, yeah.
All right, thanks.
Yes. All right, everyone, please be seated. If we can put him, sir, if you're okay with being behind the gate, and then we'll make sure you have your number 4 card.
Okay.
All right, thank you so much. When they made these courtrooms, they did not ask the people who worked here what would be the appropriate amount of room. I'm sure that happens at everybody's place of employment. They never ask the people who actually work at a facility what would be best. All right, everyone, good morning.
Good morning.
All right, you're the first group where we've had a jury trial and I've said good morning and you all are still wide awake and ready to go. Right. My name is Stephanie Boyd. I'm the judge of the 187th District Court. You are on the 4th floor in the 187 District Court. So where are you? All right, y'all, that's all jumbled. Okay, so let's do it this way. Which floor are you on? What's the court?
107.
Who's the judge? Now, I know what you're probably saying. We know where we are. Why would she ask such a thing? And the reason why I do that is because whenever we take a break, everyone has to leave the courtroom. And when I say everyone, I mean the jurors do. And we cannot start again until everyone is here. And believe it or not, sometimes people get lost. And we will sit and wait. One time we had a juror who was down the hallway about to go into another jury selection. So I always say that because if you're ever lost, all you have to remember is 187. There's only 187th court in all of Texas. Or either if you remember Judge Boyd, there's only one Judge Boyd in the entire courthouse. So someone will be able to direct you where you need to be. To my left, we have the court reporter. She is taking down everything that everybody says. That's her job. And I always said that if ever I was in a position to make somebody's job easy, that I would do my best to do that. So I want all of us to make her job as easy as possible, because it is a hard job when you think about it, because some people talk softly, some people talk fast, and it's hard for her to hear if people are talking softly and if people are talking fast. So if everyone will talk at the rate that I'm talking and talk at this tone, this loud, it'll make her job easy. So can everyone do that?
Yes.
Has everyone been able to hear me so far?
Yes.
Now, this is something I'm going to also ask you to do to make her job easy. Every jury panel we have had has failed, but I have faith that you all are going to be able to do it. So everyone in the box, raise your card, please. Everyone on this front row here, raise your card. Number 4, if you'll raise your card. Raise your card. Just the people I've told to raise their cards, all right? Anyone else, if you do not have your cards raised, in order for the court reporter to hear you, you'll need to stand. So will everyone be able to do that? All right. So if somebody whose number is not raised starts talking and they don't stand, I'm gonna need the neighbor to touch them and say, hey, we're trying to get an A here, so please stand. All right, you can lower your card. Now I'm gonna have the parties introduce themselves. This is a jury trial in the state of Texas versus Isaiah Thomas Verjus. So can I have the parties for the state, if you'll introduce yourself, please?
Hi guys, I'm Allie Jackson. Hello everyone, I'm Zach Dunn.
And for the defense?
Good morning, everyone. My name is Jessica Gonzalez.
Good morning, I'm Mario Morano.
And Mr. Verjus, if you'll introduce yourself.
Hello everybody, I'm Isaiah Varyu.
All right. So the other thing is you'll probably notice people who will come through this door. They're coming through that door because they haven't read the sign that says, we're in jury trial. Please do not come through this door. So they have nothing to do with this case. They just didn't read the sign on the outside of the door. People will come through this door and they may have items for me to sign. It has absolutely nothing to do with this case. I'm alternate presiding judge, so I may get some officers who may come to that door for me to sign documents. Again, it has nothing to do with this case. And sometimes we have interns and other people who want to see a jury trial, so they will come in to observe. Does everyone understand? All right. Now, in your hands, you have cards. Those cards have numbers on them. Whenever something applies to you, when either the state or myself or the defense are asking you questions, just raise your card. And then someone will call you by the number in your hand. If you have a question about something, please raise your card. All right? And sir, if you could remove your cap. Thank you. All right. In this case, the charges are indecency with a child contact and sexual assault of a child. And I'm going to come back and talk to you more about those type of charges. When I talk to you and when the state talks to you and the defense talk to you, they are going to be speaking to you in hypotheticals. None of them are allowed to talk to you about what they think the facts of this case is. Does everyone understand? So when you are answering questions, just know it's not about what people think the facts are in this case. You'll only get to know what people think the facts are in this case if you are on the jury panel. Does everyone understand? Yeah. Now I want to talk to you about an indictment because Mr. Verjue is here because he's been indicted. An indictment is not evidence of guilt. How many people here, and I'm going to have you practice raising your card. How many people here have ever had a traffic ticket? All right. So this tells me we have some horrible drivers in this courtroom right now. All right. I've had a traffic ticket before too. So when I got my traffic ticket, and I want to say I was about, I think I was 21 or 22. So that puts me about 24 right now. Okay, that's just, see, your laugh just like, oh my gosh, she's so intelligent to be here, right? So let's say you get a traffic ticket and the officer says you ran a red light. That's why they pulled you over. They say you ran a red light and they're giving you a ticket. Back in the day, they used to write it on a piece of paper and they tear off the piece of paper and give it to you. Now I think it's electronic or something. So when that officer is giving you a ticket and you accept that ticket, that's not you saying I ran a red light. That ticket is just to tell you, hey, I pulled you over. I'm saying you ran a red light. And guess what? To answer for me saying you ran a red light, you need to be at municipal court. If you want a trial, this is the day your trial will be. This is what you're charged with. It doesn't mean that you're guilty of running a red light. It doesn't mean you're saying you're guilty of running a red light. It's just a document, and the indictment is just in a document to let somebody know, hey, this is what we're charging you with. This is where you need to be, and this is where you can have your jury trial. Does everyone understand? So an indictment cannot be held by you in any regard whatsoever. It can't be considered as evidence of guilt. It's really just an instrument to tell somebody what they're charged with. Because guess what? How would you like to show up to a court and you don't know what people are charging you with, right? You don't want to show up at municipal court and they say, the ticket says you ran a red light and they're like, oh no, we've changed it. It's here for a yield sign. So indictments, not evidence of guilt, not evidence of anything. It's just whereby somebody is brought to a felony court to answer for what they're being accused of. Does everyone understand? Yes. Is there anyone who's going to hold it against Mr. Verjue because there's an indictment? All right. The next thing I want to talk to you about is certain rights everyone has who's charged with an offense. Everybody has a right to remain silent. I'm sure some of you have seen The Practice, Beretta, Mannix, Paper Chase. Nobody's seen that. Okay, that's odd. I see some gray hairs and they're natural. Thank you, 22. All right. So anyone, thank you, 48. I appreciate that. Everybody else don't know what they're missing. So everyone has a right to remain silent. What does that mean? That means that if you're charged with an offense, nobody can call you as a witness and say, hey, we're going to call you as a witness. Can't do that because under our rights, and everybody has the constitutional right not to testify. Does everyone understand? And you cannot hold it against someone if they decide not to testify. You cannot consider it. You can't be like on Bewitched with Mrs. Kravitz, like, I wonder what they be. No, you can't do any of that because you potentially will be on a jury panel. Now, if you're just walking down the street in the real world, you can always think about somebody not testifying, but when you're inside a courtroom, you are not to consider it or hold it against anyone. Does everyone understand? Is there anyone who will hold it against Mr. Verjus if he decides not to testify? All right. And of course, there are many reasons why people wouldn't testify, right? I've been a defense attorney, I've been a prosecutor. Sometimes as a defense attorney, I would tell my client, state hasn't proved anything, you don't need to testify, it's not necessary. Sometimes I would have clients who would just be terrified of testifying because when you think about it, you're sitting on a witness stand and everybody's looking at you. And then you have some people who stutter, some people who have different speech impediments. So there are a host of reasons why people may not testify. But the key point is you cannot consider it. You cannot hold it against someone if they chose not to testify. Does everyone understand?
Yeah.
And I know sometimes people will say, well, if I were accused, I would want to get up and say something. Well, that's you. And until you are actually in a position, sometimes people change their mind once they're sitting in a seat and maybe their attorney has advised them to do certain things. So does everybody understand? Now, everyone is presumed to be innocent. So what does that mean? That means right now, if you had to vote whether or not Mr. Verjus were guilty or not guilty of this offense, everybody should say not guilty. And you know why? Because you haven't heard anything and because he's presumed to be innocent. So since he's presumed to be innocent, you know what that means? That means that the state has to prove their case. Does everyone understand?
Yes.
The defense does not have to prove anything. And when I was in law school, the best way the professors would explain it to us, they would say, you can sit over there, you can do crossword puzzles, you can watch videos, you can go to sleep, you can do all of that. You know why? Because you don't have to prove anything. Now, do I expect people doing crossword puzzles or watching videos? Absolutely not. But the reason why I give you the example that our professors gave us is to let you know that the burden never shifts to the defense. Defense does not have to prove anything. The state has to prove it. And they have to prove it beyond a reasonable doubt. And you may ask yourself, what is beyond a reasonable doubt? When I graduated from law school, everyone had to know the definition of proof beyond a reasonable doubt. If you didn't know it, you felt like a failure. I knew it. I knew it forwards and backwards. I knew where to put the comma. I knew where to pause for dramatic effect. I knew where to put the exclamation mark. First jury trial I have, I use it. I was so proud of myself inside. Didn't show it outwardly, but I'm like, yeah. And then guess what? The next trial I had, there's no longer a definition for proof beyond a reasonable doubt. So when I was a defense attorney and prosecutor, I would explain it to people by telling them what it was not. So next door is the historic courthouse. That's the one with the green rooftop. They try civil cases over there. They have two burdens of proof. One of them is preponderance of the evidence. And it's more likely than not something happened. So if you're ever on a criminal jury trial and you're deliberating and you're saying to yourself, well, I think more likely than not this happened, you know you are not at the correct burden of proof because that is not proof beyond a reasonable doubt. That's on the civil side. So remember that. The other burden of proof over there they have is what's called clear and convincing evidence. Clear and convincing evidence is what is needed when somebody wants to terminate your parental rights. They're saying, you're not a good parent, you're a danger to this child. Legally, we're going to take away your right to be this child's parent. That's the highest burden they have on the civil side. Guess what? Proof beyond a reasonable doubt is higher than clear and convincing evidence. Does everyone understand? So neither the state nor the defense nor I can give you the definition of proof beyond a reasonable doubt because it no longer exists. Now, in a jury trial, there are two phases. First phase, people like to call it the innocence phase. That's really not what the phase is. The first phase is whether or not you find someone guilty or not guilty. It's not whether someone is innocent or not innocent. It's whether did the state prove their case or did they not prove their case. Now, if you find someone not guilty, there's no phase two. But if you were to find someone guilty, there is a phase two. People who are charged with criminal offenses must make an election or selection that if they were found guilty, who would they go to for punishment? Does everybody understand?
Yes.
And that must be done before jury selection. It isn't somebody saying, well, I'm guilty, so let me go to this person or let me go to that person for punishment. It's the law. They have to make a selection or election if they were found guilty. In this case, Mr. Berjou has decided that if he were found guilty, the jury would decide his punishment. Does everyone understand? Now, let's talk about range of punishment. In each of these counts, there are 4 counts. The range of punishment in each count is 2 to 20 years in prison, right? Now, that's a wide range because these are second-degree felonies. So when you think about it, you could potentially sentence someone, if you were to find them guilty, 2, 3, 4, 5, 6, 7, 8, 9, 10, all the way up to 20 years. Does everyone understand? And that's a wide range, right? And sometimes for these type of offenses, people are eligible for probation. So some cases, if you were to find someone guilty, but not sentence them more than 10 years, they could be eligible for probation if you so decide. None of you know anything about this trial because I was telling you, everybody will speak on hypotheticals. So there are some cases where you may say, oh, I can see giving somebody probation for this type of case. Because when you think about it, sometimes you think about the age of the complainant and the age of the defendant, right? Because sometimes you have people who may be 16 years old and you may have a defendant who is 20. And you may say, oh, I could see perhaps giving somebody 20 years for that. Let me see what the facts are of the case. Does everyone understand?
Yes.
And then there are sometimes you may say, no, I'm going to give this person 20. But in this case, nobody can ask you what you would give somebody because guess what? You don't have any facts. So what I need to know, is there anyone who would not be able to listen to facts for punishment? And I'm speaking hypothetical, not about this case. On a sexual assault case, can you listen to facts and apply those facts to punishment if you were to find somebody guilty? Is there anyone here who can't do that? Is there anyone here who can't consider the full range of punishment, bearing in mind that what that means is that you will be able to listen to facts and apply those facts to whatever punishment you would consider in a case? Does everybody understand?
Yes.
Is there anyone who will not be able to do that? All right. Next thing I want to talk to you about is what's called the one witness rule. One witness rule is this. The state will call a witness. Again, I'm speaking hypothetically. The witness could be Mother Teresa. But this witness is someone who's credible. That means that you believe them. It's not too dark. You know how sometimes you say, well, I'm listening to that witness, but it was dark outside. Maybe it was too dark for them to see. They wear glasses. They were not wearing glasses that night. Listen to my hypothetical very closely. There's one witness. Witness does not have a vision problem. It's not too dark. It was there is light enough for this witness to see. The witness is trustworthy. You believe that witness is trustworthy. That one witness, if you believe them, proves the state's case beyond a reasonable doubt. Does everybody follow me? Okay. And the question is going to be whether or not you would be able to convict somebody from that one witness. Does everybody understand my hypothetical? Don't add anything to my hypothetical. Don't take anything away. Now keep that hypothetical in your mind. And I'm going to give you another hypothetical. Let's say someone is in a parking lot. It's just that person walking in the parking lot. It's not dark, but there is nobody else around. They think they're the only person in that parking lot. Somebody comes out of nowhere. They see this person, and it's only them now and this other person in the parking lot. That person robs them, takes their items, and runs and leaves. The person in the parking lot, again, there's only that person and the person who robbed them. How many people think that that person's case should still come to court? Raise your card if you think they should still be able to file a report. Is there anyone here who thinks that that person should not be able to file a police report and say, hey, I was robbed? All right. So as you can see, sometimes there are offenses that are committed when there's only the person who's the complainant or the victim and the person who did it. That, in essence, is the one witness rule. So I go back to my hypothetical where a person comes to testify. You believe them, they're credible, and they say, this is what happened. I was in a parking lot, reaching into my purse to pull out my car keys. This person comes up to me, robs me, takes my car keys, takes my money, takes off running. I know the person who did it. I saw them very clearly. This is how tall the person was. This is their hair color. I see that person in the courtroom now. This is the person who did it. Is there anyone here who would not be able to find that person guilty? All right. Next, I want to talk to people about languages. I love languages. When I was in law school and when I was in graduate school and undergraduate, there are a lot of people who spoke a lot of different languages. I always thought it was beautiful. I'm originally from Louisiana, so I decided to take a language that I should have been taking, knowing that I was going to live out my life in Paris, which was French. So lo and behold, I ended up in San Antonio. And I should have listened to my friend and took Spanish when she was taking Spanish, but I'm like, no, I'm taking French. So is there anyone here, if you could raise your card, English is not your first language? All right. 31, 33, 45. All right, everyone, here's the test. 31. Yay. What's your first language?
My first what? I'm sorry.
Your first language.
My first language is Spanish.
Okay. Have you been able to understand everything?
Yes.
All right. How do you say hurry up in Spanish? Thank you. I know how to say hurry up in almost every language. I was just testing you. All right. Thank you. Number 33. What's your first language?
Spanish as well.
All right. Did she tell me how to say hurry up correctly?
Yes, you did.
But there's another way to say it, isn't it?
Apúrate, ándale.
Thank you. That's what everybody knows, andale. All right. Have you been able to follow through on everything that's been said?
Yes, ma'am.
All right. Thank you. 45. Yes. What's your first language? All right, have you been able to follow everything?
What?
Have you been able to understand everything? All right, what does that mean, the waving of the hand?
Más o menos, o en inglés es,
So?
Yeah.
All right, thank you. All right, is there anyone here who has any type of religious reason or some type of reason where you can't sit in judgment of others? Okay. Now, the next question I'm going to ask is about time constraints and travel arrangements. I'm expecting potentially for this case to conclude on Friday. At the latest, it may be Monday. This is what both the state and the defense have told me. So is there anyone here who has any time constraints or travel arrangements? You have tickets to, you know, someplace that's not refundable and you can't put them in my name. Is there anyone? Raise your card if there is a time constraint issue. And I'm going to tell you right now, I'm going to start calling out numbers. And once you hear me not scream and yell at anyone, don't then backtrack and finally raise your number. So over here, we have number 5, 10. All right. Raise your numbers high so I can see them, please. 30, 40, 42, 43, 54. See, number 18, see what you did there? All right. And you on the front row, you had your card raised too, or no?
He's so sorry.
Okay, 64 and 74. All right, number 5, what's your issue?
I had plans to leave in town tomorrow morning. It'll be longer until
All right, where are you headed?
down south to Laredo.
All right, what are you doing in Laredo?
I'm guiding a hunting trip down there.
What are you all hunting?
Still deer seeds.
So how do you feel about Bambi? Bambi's mom.
Pretty good.
All right, number 10. Number 10? Yes, that's okay.
And I have a third and final job interview in Austin tomorrow morning at 10 a.m.
All right, so you've been interviewed twice before with them? So what type of job?
I'm a nurse.
Okay, awesome. You know, my mom always said, if you got the interview, then you have the job. So you have the job. Okay. Number 18.
Well, I'm not traveling, but where I work, it's just me and another nurse, and she's gonna be leaving out of town on Friday.
And where is she going?
She's going to Florida,
All right.
so I don't know if that.
Okay.
Because it's just me and her.
All right. Thank you for letting us know. Number 30.
This isn't really a travel thing and it may not be eligible for what you said, but I'm on a night shift and it's just a very small team. So this is just polar opposite my usual schedule is the only thing. And it may cause just work complications if I'm not there for a long period, but other than that, that's it. I'm not sure if that's even eligible for what you're asking.
All right. Where do you work? What do you do?
I work IT.
Okay. All right. Thank you. Our computers here are always down. I'm just, all right. Number 40.
In the afternoons and evenings, I take care of my child, so I have to pick him up every day after school.
All right. What time do you pick them up?
5 o'clock.
And what time would you have to leave in order to pick them up by 5? 4:30. All right. Thank you. Number 42.
Good morning, ma'am. I have a data and analytics summit on Monday morning in Austin that I need to host for the Veteran Health Association.
Okay. Are you all traveling together? Is it, you know, Austin traffic is bad. You all could ride together. Okay. All right. And what time?
It's a week-long summit, ma'am. So I have to be up there at 6 in the morning on Monday.
Okay. And that's on Monday.
That's correct.
All right. Thank you. Number 43.
My wife has reservations for this weekend for my daughter's birthday and the plans.
Reservations where?
I tell her I'm not sure. I don't know their plans, all of them. She just, all I know is that she has reservations.
Okay, where? Is it going to be in,
I don't know the plans.
okay, you're just showing up. At your wedding, did you just have to show up?
My wife and daughter.
Okay,
for her
and-
birthday.
all right, they want you there.
Uh,
Okay,
absolutely.
all right. Okay, awesome. Thanks for letting us know. And you say that's tomorrow,
This weekend.
this weekend? So do you even know if you'll be available on Monday? Are you all coming back on Monday, or you have no idea?
It's not a
They have truly kept you in the dark. Tell them you need to know. All right, thank you. Oh, and by the way, how old will your daughter be?
She'll be 10.
Oh, well, tell her I said happy birthday or birth month, because I believe in celebrating the entire month.
Be happy to hear that.
All right. Number 54.
I have a work on Friday and Saturday at 4.
And what do you do?
I'm a prep cook.
Oh, where?
Velvet Taco, it's pretty good.
Oh, I've never been there. Where is it located?
South Bend, near the Palladium.
Okay. Number 64.
I have travel plans to Las Vegas, non-refundable.
You just threw that in. When are you going?
Las Vegas,
When?
Friday morning.
Are you going by yourself?
Group of people.
Okay, I don't want to get you in trouble. I'm just, asking. All right, number 74. Good morning. Oh, I'm sorry to hear that. All right, thank you so much. All right, anyone else? See, this is what I mean. Number 52.
Morning, I have to do a group test every 2 hours starting today at 11:30.
All right, group tests every 2 hours.
My pregnancy, I got a higher, my blood test was high, 175, it has to be a 145.
Ah, okay, all right.
Yes.
All right, thank you. All right, number 15.
I have a client meeting on Friday, Judge, through the weekend.
All right, what type of work?
I'm an attorney,
All right, and what time is that meeting?
Friday morning, early, outside of Refugio, Texas,
All right, what time?
9 o'clock.
All right, thank you. Number 16.
Next week I have to work from 8 to 4 in the morning, and normally I give them up, but this month, one of my insurance carriers they pushed the commissions back till next month, and it's just a bad time for me to give up work shifts.
Okay. All right. So, ladies and gentlemen, I'm going to tell you 2 stories. Both stories are true. The first story is concerning my uncle. My uncle grew up in a small town, Grand Cane, Louisiana. My grandmother's firstborn child. Since then, both of them have passed. But my uncle was super intelligent. And so the teachers just kept moving him ahead to the next grade, because they're like, there's nothing else we can teach you. We're going to move you forward to the next grade. So he ends up, going to graduate. And of course, his siblings, when they come behind him, because all the teachers in Grand Cane knew all of the students, they were telling them, we are expecting a lot of you out of you all because of your brother, who's super intelligent. So when he graduates, the Vietnam War breaks out. Now, he legally can't sign for himself because he's underage, because everybody keeps moving him up in class. So he goes to my grandmother and he tells her, there's really not going to be any work for me here. I only see a way out of this situation going into the military. So she had to sign for him to go to the military. And I know we're used to all this social media stuff, but for the young people, going to take you back a little bit. During my grandmother's time, television wasn't on 24/7. The TV cut off at a certain hour. The national anthem comes on. NBC, on a good day, if the weather's nice, maybe you can get NBC. But normally you couldn't get NBC, you'd have lines. And their phone number was 4 numbers. And to make a phone call, you'd have to pick up the phone, call the operator and tell her what 4 numbers you wanted. There wasn't a computer where you just write things. There was what people call now snail mail, where you have to write a letter. So she signed for my uncle to go to Vietnam. And that was back in the day. Nobody knew where Vietnam was because let's face it, America, we're not the best place with students who think geography is very important, right? So nobody knew about Vietnam really. All she knew was she's signing up to send her firstborn to go off to war. Maybe he comes back, maybe he doesn't come back. Nobody knows. When they were shipping him off, they didn't give her an address and say, oh, this is where he's going to be in Vietnam. So she had to agree for him to go off, write a letter, and then wait for months for it to return. Didn't know if he was going to be okay or not. He ended up surviving Vietnam. But the reason why I tell you that is because that's a sacrifice. I think too often in this time period, we throw around the word sacrifice so easily. To me, that's a sacrifice. When people do jury duty, that's an inconvenience. Because when you think about it, the inconvenience is, guess what? Downtown has too many one-ways. You see a building, you're like, hey, if I could just turn left right here, the building's right there. Then you have to pay for parking. And it's like, hey, I'm doing you all a service. Why am I having to still pay for parking? I'm not in charge of that. But so it's all an inconvenience. But when you think about your country, what does the country ask for you? They're not drafting anybody. Guess what? The only thing they're asking for you is to serve on juries. And they're not even to ask you to serve monthly. I know some people who have been called up one time in the past 2-3 years, and they're not asking you to even serve every 2 months, every 3 months. So this and pay your taxes is all the country asks for you. And those are all inconveniences. So in order to have jury trials, we need jurors. And both the state and defense, you know what they're looking for? Somebody who's going to be fair. And what does fair mean? Fair means that when witnesses are called, you're able to listen to the evidence and make a decision on whether somebody's guilty or not guilty based upon what you hear in court. Everybody has something in their past that they wish maybe didn't happen to them. Everybody has some kind of trauma. Even Pollyanna had trauma in her past, right? Thank you. Not everybody's seen Pollyanna, but everybody has something going on in their past. Sometimes when you try cases and it's a assault case where somebody got beat up, everybody's like, oh, well, let me raise my card. I know somebody who's been beat up, or I've been beat up. Or sex case. Oh, I know somebody who was charged with a sex offense, or either I was sexually abused. And I understand all the trauma involved in that. But the main question is not whether or not you've had something that's happened to you in your past. The main question that both the state and defense are going to be asking, really, when they say, can you be fair? It's whether or not you can sit in this trial and make a decision on whether Mr. Verjus is guilty or not guilty based upon the evidence that you hear in the courtroom. Does everybody understand? Is there anybody who will not be able to do that? Now, the other true story I'm going to tell you is about one of my friends from law school. She decided to do civil work. Civil attorneys, civil attorneys, you're usually not in jury trial. On the criminal side, people are in jury trial or in court every single day. So she got called up for jury duty. And she said, Stephanie, I got called up for jury duty. Let's have lunch. I'm like, great, this will be fun. So we have lunch. And I asked her, how is jury selection going? And she's like, it's going fabulous. Now that I'm a judge, I'm like, how can it be fabulous? Because you're not in court with me. But so I say, why do you say it's fabulous? And she says, because it's like in law school. I got my head down. I'm on the back row. I'm not talking. And I start laughing. She's like, what's so funny? I'm like, I'm so excited because we're going to be having lunch all week. So the quickest way to be on a jury, honestly, is to be silent. And I tell people that true story because the state and the defense have this small window to talk to you, to find out what your thoughts are and everything. Does everybody understand? All right. So is there anyone who needs a break? All right. If you ever need a break, number 28, that's okay. And 29. All right. So I'm going to give you all a break. And I'm going to need everybody back here by 11:25. Now, here's the thing. If you need to go to the restroom, wherever you see stairs, there's a restroom on either side. So if you see the restroom is crowded, just take the steps down. There's another restroom on either side. You find a stairwell, you will find a restroom. And which court are you in? All right, so leave the plastic cards behind, and you are more than welcome to leave your items behind. All right, and we'll see you back here at 11:25.
Unruly mob.
Let's bring them in if they're ready.
Where the hell is that?
We're putting
Hang
them
on,
in-
where's that?
We're putting them in order, Judge, because they're all, okay, over the place. Guys, I will email you both.
You guys know where to sit now, right? Yes.
Someone not gonna sit on it. It's nice to know I was the only one that had to go like it. Out.
I didn't think I could tell. I was just-
That's all I know.
Gentlemen, each side is going to have 30 minutes to speak with you. All right, State, are you prepared?
Yes, Your Honor.
All right, you may proceed.
Thank you, Judge. If please support the defense. Good morning, it's still morning, we haven't quite hit noon yet. Like I said earlier, my name is Allie Jackson. I'm the lead prosecutor on this case, this is my partner, Zach Dunn. And then defense has also introduced themselves. Is there anybody here who knows any of us or anybody who's working here in this courtroom?
No.
Just raise your card. Always want to double check, you never know. So before we kind of get into this, I have one more housekeeping thing. You may at times, especially if you make it onto the jury, you may see me or Zach or defense counsel on our phones. You're probably going to think we're being rude because you can't be on your phones, but I swear to you that we are not. Zach and I are wrangling witnesses and dealing with other matters, and Jessica also has witnesses and they have other matters that they may attend to. So if you see us on our phones, please don't think we're being rude. So we are here for Wadire or Wadir, depending on where people went to law school. But it's basically what we call jury selection. That's a misnomer. It's actually more of a deselection process, which is why Judge said that those of you who are quiet are the most likely to end up on here. Because what we're doing is we're trying to see if there's any biases, prejudices, or anything that keeps you from being a fair and impartial jury or juror on this case. So the more you speak up, the more reason we have to get rid of you. We want people who are fair and impartial on this case. I'm about to get into the indictment, which is what the charge is. So this is a sex case. You're gonna hear, and it always makes people uncomfortable. I've been in this unit for 5 years, so I'm very nonchalantly going to be saying things like penis, vagina, penetration. Don't think I'm being flippant. This is what we deal with all the time, but I know that you guys are gonna be uncomfortable, but we're gonna get through it together. So there are, first charge we're gonna be talking about is indecency with a child by contact. Now, think of this as kind of the checklist that Zach and I have to prove. We have to prove each and every element beyond a reasonable doubt. Defense doesn't have to do anything. This is our burden, we welcome it. So we have to prove that on or about a particular date, this defendant did intentionally and knowingly engage in sexual contact with Joe, this is a pseudonym in this case, a child younger than 17, by touching her breast, part of her genitals, and by causing her to touch his genitals, with the intent to arouse or gratify the sexual desire of any person. Next one is sexual assault of a child. On or about September 1st, 2020, the defendant did intentionally and knowingly cause the penetration of the sexual organ of Joe, a child younger than 17, who was not their spouse, by this defendant's sexual organ. Sounds like a lot. If you make it onto the jury, you're gonna have kind of a charge, you're gonna have something to read. All of this will make sense to you, but this just kind of get you familiar with what we're here to talk about. Now, one of the things you're gonna see on here is I said nothing about consent. In Texas, if a child is under the age of 17, they cannot consent, period. I don't have to prove that there was a lack of consent. We'll get into this more in a moment. But it also means that when it's under 17, that this means it could be anywhere from a child who is, 3 years old, all the way up to 16. Now, if a child is under the age of 14, that's a separate higher charge. So keep in mind, kind of going into this, we're most likely talking about a child who could be 15, 14, 16 when this happened. Think of a teenager. Now, in the language that we have to prove, it's on or about this particular date. The law does not require us to prove an exact date. It simply must have occurred before a case was presented to the grand jury. Now, is there anybody here who can think of why we wouldn't have to prove an exact date when we're talking about a sexual assault of a child? Anybody have an idea? What if it happens more than once? You may not remember it. Does anyone here, who here raise your card if you have a child? Keep your hands up if they are a teenager or a little older. Do any of y'all keep your hands up if you think teenagers are really great with dates? Yeah, that's what I thought. Now, hearing that we don't have to prove an exact date, is there anyone who says, I get it, I understand that's the law, Allie, and I understand why it's the law, but I want an exact date. I'm gonna hold the state to my own burden, and I want you to prove an exact date. Is there anyone who feels that? Raise your hand. Cool. So, in the indecency count, you notice that we talked about sexual contact. Sexual contact is any touching by a person, including through the clothing of the anus, breast, or any part of the child. And it also includes any touching of the body part of the child, including through the clothing with the anus, breast, or any part of genitals of a person. So this just means touching the vagina, touching the breast. This can be over the clothes, this can be under the clothes. It can be with their mouth, it can be with their hand. And you'll hear if you're on this case, you're gonna hear what we're specifically talking about. Now, more about consent. They cannot consent under 17. Doesn't matter if they flirt. Doesn't matter if they send inappropriate text messages. Doesn't matter if they secretly arrange a rendezvous. Doesn't matter if they come on to the person. Adults know better, and adults are in charge. A child cannot consent. Now, we were all teenagers once, so I know that people can be a little uncomfortable with this. And so I need you to sit here and think about this whole consent thing, keeping in mind that we're most likely dealing with teenagers, 14, 15, 16. Is there anyone here who says, Allie, I understand that they cannot consent to have sex with someone. However, I will not feel comfortable if you do not show me that there was force or coercion or some sort of threat. If they didn't resist, I can't. Is there anyone here who says, Allie, I need you to prove that they did not consent and I cannot follow the law? And it's okay if you do, I just need you to raise your cards right now. So, Judge talked a little about beyond a reasonable doubt and how we have no definition. Like Judge, we can also tell you what beyond a reasonable doubt is not. It's not beyond all doubt. It's not 100% certainty. What is the only way you can know 100% that something happened? Juror number 6, what do you think? See it. You said see it. Raise your card. 38 said see it. Correct. If you saw it and you witnessed it, you know 100% it happened. And you're going to be here as our star witness. You're not going to be sitting on the jury deciding. And when we talk about possible, all possible doubt, just because something's possible doesn't mean it's reasonable. Say you guys were coming in here this morning, and I know it's not, but say when you came in this morning, skies were dark, there was a wind blowing in, and there'd been talk of rain. You managed to escape here after only 30 minutes. You walk outside, everything's wet. There's puddles, cars are wet, people are carrying umbrellas. What happened? It rained. Now, is it possible that someone decided, I don't like this courthouse, I don't like the people who work here, took a hose and just started spraying everything? Yeah, that's possible, but that's not reasonable. That's where I'm kind of going with that. My main thing is use your common sense. Everyone has it. Please just use it. Think of a case like putting together the pieces of a puzzle. Sometimes you may have all the pieces. Sometimes you may be missing a few pieces. Everyone's going to have their own idea of what all you want, what all is reasonable doubt to you. Everybody's an individual. So say there's a few pieces missing. Looking at this slide, who can tell me what this is a puzzle of? Okay. Are there pieces missing?
Yes.
Is there anyone here who says, no, that's not enough for me. I need to see all the pieces. I need it. Anyone here who doesn't think this is a puzzle of a gun? Cool. The main thing when you're evaluating the case and listening to the evidence is to ask yourself, do I have a doubt? Is it a reasonable doubt? And did it go to one of the elements that Zach and Allie had to prove? That is the key point. Now, we're all human. We all have a level that we want to get to in order to make a decision that would affect somebody's life. Because even if you gave a defendant probation, it is still affecting their life, and that's fair. So is there anyone here who says, I get it. I get what the law is. I get that beyond a reasonable doubt is the standard, but I need no doubt. Is there anyone here who would make us prove the offense beyond all possible doubt. Please raise your card. Alrighty. So, next thing is evidence. Who here has any idea or suggestions of what kind of evidence you expect to see in a case involving assault or sexual assault? Jury number 7, what's the evidence? Witness. Testimony is evidence, y'all. All evidence comes from the witness stand. From somebody testifying, somebody bringing in physical evidence. You get to sit up there and judge their credibility. Now, in cases like this, some people might expect medical evidence. Who here would kind of expect medical evidence in a sexual assault trial? Raise your hand. Most people. We all watch CSI. We all watch Law and Order. Now, is there any reason you can think of why there wouldn't be physical evidence? Number 54? A bath. Time elapsed. They could have bathed. There's not going to be any evidence. Anybody else? What if it was they outcried much later? Would there be any physical evidence if they didn't, if nothing was found out? No. Things happen. There's not always. Number 48.
There's no passing of fluids.
There's no passing of fluids. Number 48. Correct. So there's not always going to be medical evidence. There's many reasons why. Now, hearing that, and this is also another fair thing, this is your personal decision. Is there anyone here who says, I understand why there may be reasons, there wouldn't be medical evidence, but if I do not have medical evidence, I cannot listen to this case. I require the state to bring medical evidence. Please raise your card. Right. Now, who here, again, raise your hand if you have kids. Most of us. Now, can you tell when your kid is lying? 13, 13, you're very quick. How can you tell your child's lying?
Yes, by the way, the eye movement and the way they handle them.
Okay, eye movement, handling themselves. Number 11.
My wife tells me.
Your wife. Okay. Yeah. What are some other ways you can tell when your child's lying? Anyone else? Number 48.
Depends on what my daughter calls me, mom or mommy.
Oh, there you go. Word choice. Number 7.
The head is down and can't look you in the eye.
Head is down, can't look you in the eye. Body language. 64.
Their mood.
Their mood. Yeah. 34.
Change of tone.
Change of tone. 67.
Inconsistency in stories.
Yes. We got demeanor, motive. I think you guys got everything. What they say, if there's anything that backs up their story, kind of what the circumstances are. Now, who here, like, who can be a victim of a case like this? Who here thinks anybody can be a victim of any type of? Yeah. Now, I would love if my victim and my witnesses was a bus full of nuns. That would be fantastic, but no one is perfect. Probably not even the nuns. But we just ask that you sit and listen to everybody and you decide who you believe. Now, Judge touched on this briefly with
Just 1 second. Yeah. Yeah, just 1 moment. State and defense, if you can come forward. All right, ladies and gentlemen, it appears that 26 is having an issue, and normally jury selection, everybody needs to stay together, but both the defense and the state have agreed that they'll continue with their voir dire. And then if they need to ask some more questions of juror number 26, they will be given the opportunity to do so. All right, state, you may continue.
Your judge touched on this with the one witness rule. So we know we're here talking about indecency with a child and sexual assault with a child. Where do these types of crimes occur?
Anywhere.
Anywhere? Do you think they occur where other people can see? No. No. They occur behind closed doors. The two people who are typically there are the abuser and the child. Makes sense. That's why Judge talked and kind of touched on the one witness rule. Now, technically, if the victim came in, testified, they could testify to every single thing that Zach and I had to prove. And we could technically put on a one witness trial if you believed that victim beyond all reasonable doubt. That doesn't necessarily mean that there's not other witnesses to be brought in. You know, there might be a police officer to come in to corroborate, hey, they made this account, the account's consistent, this is what we did. You know, there may be other people who did exams, you know, they're just kind of gathering evidence, but at the end of the day, there's only one person or two people really who know what happened. That's why we have the one witness rule, because that makes sense to everybody. Okay, is there anyone who says, that's great, but I'm gonna need a lot more than one witness to prove this case beyond a reasonable doubt, Ally? Please raise your card. Cool. Now, you know, we're here most likely talking about teenagers. Who here thinks that when a child has been sexually abused, all kids react the same way? No one does. How would you expect different kids to react to being abused and talking about it? Silent. Silent? Is that number two? Do you mean like not to say anything or not want to talk about it?
Yeah, not explain it, anything that might have happened.
Okay, they're not gonna want to talk about it. Who here agrees with number two? They might not want to talk about it. We've got one, keep your cards up, but I say your number. It's most of you, but 1, 2, 3, 4, 5, 6, 7, 8, 10, 11, 12, 13, 14, 15. Actually, we're gonna stop right now. Raise your hand now if you didn't raise your hand. Raise your card if you didn't raise your hand. We got 51, okay, and 28. Much easier. Yeah. Do you think that all kids will testify the same?
No.
Now, juror number 2. Can you please tell me about the last time you had sex? How do you feel when I asked you that? About last month? Okay. How'd you feel when I asked you that question?
Well, there's a lot of people here.
Yeah. 75 of your best friends. When I asked her that question number 1, how'd you feel? Do you think maybe you were next? Yeah. How do you think a child's gonna feel talking about a time when they were sexually abused to a room full of their new best friends?
Very uncomfortable.
Very uncomfortable. Number 19? Who here agrees with number 19 that a child's gonna feel very uncomfortable? Most of y'all. Raise your hand if you didn't agree that it was gonna be uncomfortable. Okay. Yeah, it's an uncomfortable situation. So sometimes someone can look, how do kids look when they're uncomfortable? Like, what are the things that you can see and be like, oh, this child's uncomfortable? Number 5,
They look down, they're squeamish.
look down and squeamish. Anybody else?
Withdrawn.
Withdrawn, number 19. Yeah.
They might stutter.
Stutter, number
Or they
48.
might continue blabbing.
Yeah, might just babble. Yeah.
They'll also have nightmares.
Nightmares.
They also squirm.
Squirm, what card? 38. They might squirm.
They might get depressed.
They could get depressed. Are you 54?
All right, so everyone, make sure you remember the rules.
That's the end. Who do you answer? They might, but 54 said they might get angry. Number 2? I forgot it. Number 5.
They don't want to be around the person that assaulted.
They don't want to be around the person that assaulted them. 64?
What they post on their Instagram or whatever
Yeah.
whatever social media that they have.
They might post about it. Yeah. All right. all different ways. Number 40,
They could change their routines.
change their routines. So those are all different things that you can look for in a child who's been abused. Now, I'm gonna ask a 2-answer question right now. Sit with it before you answer. Neither one of these is a wrong answer. Just trying to get some opinions here. Which do you think is more common? Number 1, a child makes up a completely false allegation of abuse. Or number 2, a child denies being abused when they actually were. Raise your hand if you are number 1, you think it is more common for a child to completely make up a false allegation. Raise your card.
What if you don't know?
Number 38.
What if you don't know?
Okay, we'll get to the don't knows. Okay, what if you think it is more common for a child to deny being abused when they actually were? We got number 1, 2, 3, 5, 4, 6, 7. And you can put your cards after the same answer. 8, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 39, 40, 41, 42, 43, 45, 46, 47, 48, 49, 50, 51, 53, 54, 55, 56, 58, 59, 60, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, and 75. Raise your cards if you abstained from voting, which is totally fair. Number 38. And number 44. And number 14. And 57. Now, we're gonna get to any sort of biases about this later, but right now, raise your hand if you or someone close to you was a victim of sexual abuse. All right, keep your hands up right now. Lower your hand though, if that person outcried and told someone immediately. Lower your hand. Okay. Lower your hand if it took that person much longer to outcry. Now, keep your hands up if that person never told anyone. We have number 22, 42, 43, 49, and 50. Why don't children always tell immediately?
Because they think they're not gonna be believed.
Number 18, because they think they're not going to be believed. Number 2,
Because they're ashamed.
they're ashamed.
They think it's their fault. They're too traumatized.
Too traumatized, that's number 38.
Correct.
Number 5 agrees. 24,
Embarrassed.
embarrassed.
Fearful.
Fearful, who was that? Number 29, okay. 27,
They'll get in trouble.
that they'll get in trouble. Number 36,
They just might not understand what happened.
they could not understand what happened. And then everybody in the back, whenever I call on your number, make sure you stand when you answer.
5 minutes.
Okay, thank you, Judge. I'm actually gonna skip forward a little, guys. Gotta get some stuff done. Now, this is a wild question. Raise your hand if you're a fan of sexual abuse. No one. No one is. No one wants to be in these types of cases, and I understand. Now, raise your hand, or your card rather, if you or a close friend or family member has been arrested or accused of sexual abuse. Raise your card. Number 3, 18, 21, 27, 29, 44, and 57. Now, those of you who just answered, because of that experience, are you unable to be fair and impartial to both sides in this case? What I mean is, are you unable to take that experience or that knowledge, put it aside and listen to the facts that Zach and I present? Those of you who earlier raise your cards if you cannot be fair and impartial because of that experience. Number 10, 18, 44, 21, 57. Now, we just did this one a little ago, but is there anyone here who you or a close friend or loved one has been a victim of sexual abuse? Please raise your card. All right, 1, 3, 5, 6, 8, 10, 11, 12, 13, 18, 19, 20, 22, 27, 28, 30, 32, 34, 35, number 4, 39, 42, 41, 43, 44, 47, 48, 49, 51, 53, 56, 57, 58, 59, 60, 54, 62, 63, 64, 66, 67, 69, 71. Now, same thing that I just asked. Because of that experience, we need you to put it, take that hat off, put it aside, and listen to the facts, because these facts are not your facts. They're not your friends and loved ones' facts. Is there anyone here who says, I get that, Allie, but even if I am ordered to, I cannot put that experience and knowledge aside and be fair and impartial in this case? Please raise your card. Number 10, 8, 11, 12, 18, 20, 42, 43, 44, 47, 48, 49, 51, 56, 57, 58, 60, and 61. Alrighty. I'm about to sit down. Is there anyone else? If there's something we haven't talked about, but you really think we need to know before we decide whether or not to have you on our jury, but you'd rather not share it with your 75 closest friends and you want to talk to us and the judge later, please raise your card. All right. Oh, number 20 and number 16. Anyone else? 68, 60, and 51. 10, 12, 14, 5, everybody's going up now. 22, 32, 44, 48, and 56. Alrighty, I'm about to hit my time limit, so I'm going to hand it over to Ms. Gonzalez. Right.
Yes.
All right, good morning. Let's try that one more time because my stopwatch isn't working. Okay, never mind. Good morning.
Good morning.
Hey, how's everybody doing? Okay, so Ms. Jackson and Judge Boyd covered a lot of things. So I'm still gonna have the slides in here, but I don't necessarily need to go and talk about these topics. However, even though they covered a lot of stuff very thoroughly, there's still some questions I'm gonna wanna ask you guys. And just a heads up, I wanted to be a professor when I was in college. I like the teaching aspect, so I am gonna be calling on some numbers to kind of get you guys talking. And let's not forget Judge Boyd's rule. If you're sitting back here, go ahead and stand up. Okay, so we already covered that. We're talking about who's going to be a good juror. Allie spoke about sometimes people have biases and prejudices, things in their own history that kind of makes them not a great juror. For instance, one of the examples that a lot of people like to give is Willie Nelson. Would Willie Nelson be a great juror on a possession of marijuana case? No, him and Snoop Dogg can go stand over in their corner and watch everything on their own, but they're not exactly the people we want or the state wants. I may want them, But the state may not want them to be able to judge whether or not a person broke a law for possessing marijuana. So we're here to have this conversation, and like I said, Judge Boyd talked about a lot, Ally talked about a lot, and I'm gonna talk about a lot. But all we're asking right now is that you listen. What I'm asking you is that you listen and answer my questions honestly and fairly, okay? So the judge spoke a little bit, the constitutional rights, boilerplate, easy to remember. The right to remain silent, everybody's heard that. The right to an attorney, the right to a jury trial and a right to a fair trial, and the right to confront the witnesses. So I'm gonna ask you my first survey question. You don't have to hold up your hands, but who's on trial today? Well, actually, I do want somebody to answer. Who's on trial today? Anybody have the answer?
Say it.
I'm sorry, juror number 5? What'd you say?
Gentleman over there.
Gentleman over here, Isaiah Varju. Anybody else agree with this, juror number 5? Everybody? Yeah? Yeah? Yes. Okay. So remember when Judge Boyd talked about the presumption of innocence? Presumption of innocence says, my client, as he sits here right now, he's innocent. He does not have to prove anything, but he's not the one that's necessarily on trial. What we're asking for the jury is to be able to decide whether or not the state of Texas has proven their case. As Ally talked about and as the judge talked about, it's beyond a reasonable doubt. The jury that we're going to be selecting to hear this evidence is solely here to listen to the state's case, listen to the evidence that has been presented by them, and the jury decides, do I believe that? Do I believe that? And furthermore, has the state shown evidence of each and every one of those elements? That's what we're here for. So what does the state have to prove to you? Do I have some teachers in here? Anybody? Okay, so when I say 5 W's and 1 H, what does that mean to you? Okay, go ahead, number 60.
Where, when, how.
Well, I feel like we're missing one. When? Who? So we get
Where, when, and why.
who? Everybody got that? So the state of Texas is gonna have to show who committed the crime, what, how, when. Okay, those are part of the elements, that charging document that Ms. Jackson had presented to you guys. Where did this happen? They have to show it happened in Bexar County, Texas. Why? Here's the thing. I like to call this the hidden why. The state of Texas does not have to prove why a crime happened. However, as the jurors, I'm going to be expecting you guys to be asking yourselves several questions as we go through it. Why? The first question I'm going to be talking to you about is why would a witness lie? Ally was talking about that people will deny something or they'll make something up, but that's where the hidden why falls in there. So how does the jury judge the state's case? Anybody see this movie? Anybody? What's your number? Juror number 48? What's this movie? If you can stand up.
Vinny.
Sorry, if you can stand up.
My cousin Vinny.
My cousin Vinny. Has there anybody else that's seen My Cousin Vinny? Yeah? Okay. I love this movie. No surprise. That's a shocker. This is a great movie. And so what is Vinny, the attorney, doing with each one of the witnesses in that case or in that trial? Or that movie, I should say. What was he doing that was so effective? Juror number 48?
He was getting to what really happened. Don't make it up. Don't assume, just the facts.
Just the facts. Just the facts, ma'am, is something that my dad always liked to say. But in My Cousin Vinny, the state presents a case and they tell a little story. And if you just listen to that, it sounds like they proved their case. But when Vinny gets in there and he starts asking questions of each and every one of the witnesses, you start to see the case unravel. Is that a good explanation for My Cousin Vinny? Does everybody understand what I'm talking about? Yes.
So in this type of case, because Ally spoke about the one witness rule, that's what we in this field call it, the one witness rule. But when you have one witness, the one thing about the one witness rule is you have to believe the witness. The person may come in and they may testify and they may give evidence of each and every one of those elements the state has to present in order to get a conviction. But when you're a juror, the law is going to tell you, as the jurors, you are the exclusive judges of the credibility of the witnesses and the facts proved. Okay, everybody with me so far? So this is why it's very important that Isaiah gets the right to confront the witnesses. Who here is on social media? Okay. Who here can reach in their pocket or their purse right now or their jacket pocket and pull out their cell phone? Yeah. We live by cell phones, right? Social media, judge calls for a break. What are you out there doing? Anybody, juror number 27, what do you do?
On the phone.
On the phone. Juror number 11, is it 11? Juror number 11, would you agree with that?
Yes.
Okay, and I mean, would you agree that it's just adults that do this? Is it children? You said you have children, right? Do your children have cell phones?
Yes.
How old are they?
27, 20, and 16.
Okay, okay. So I'll come back to you in a second for that one. So who here has a child? Let me ask you this. Who here has teenagers? Okay, put your hands down if they don't have a cell phone. Did I say that the right way? Yeah. Put your hand down if they don't have a cell phone. Juror number 31? Does your child have a cell phone? Okay, you can put your hand down. Juror number 33?
Oh, I misunderstood.
I think I got it wrong too. We'll go ahead and. So my point is, everybody lives on social media these days, right? Where's the tech IT guy? What was your number, sir? 30. 30? Okay, what do you do for work? Like for your job in general? When you said IT.
I just maintain software and systems. But that get too technical, that's what I do.
Okay, anybody else have a job that they work in where it's very IT specific? Juror number 42, you said you're going to a data summit?
Yes, I'm a data and analytics strategist.
Okay, so do you analyze things on social media?
Yes, ma'am.
Okay, juror number 70?
I'm a software developer.
Software developer. Okay, so you really know about all the ins and outs of this stuff, right?
Yep.
Kind of? Okay. All right, so how can you tell a person is lying? We already kind of covered this. We talked about the difference between children, and I think Allie's point is sometimes when a child is up there to testify, it may give off the same signs as they're lying. Because when your child is lying, you're looking at something at their details, their body language, changes in stories. But if they're nervous, they may look to be the same way. So, but this is going to be very important, especially in this type of case. If there's a one witness, you're going to have to sit there as jurors and look at this witness and be able to make that judgment. Is this person telling me the truth? Because like Ali said, you weren't there. If you were there, you'd be up there testifying. So does anybody have a problem with being able to make that type of judgment on another person? Anybody? Okay. So how can you tell if a witness is lying? Juror number 1, how can you tell a witness is lying? Or person is lying, I should say. Okay, juror number 2, do you have anything?
Very nervous, uptight.
Okay, juror number 3?
Anxiety.
The story changes. Story changes. Juror number 4, how can you tell a witness is lying?
I don't know them. I don't know if I can tell if they're lying.
That is a really good point.
Know their traits and how they're.
Okay, so like I think it was juror number 3 that was saying, what about if their story's changing? Would that be a sign to you?
Because they're nervous because they're here in court.
Okay. Okay, so what if they told the story to other people outside, not just in the testimony? So would that play into it?
Yeah.
Okay. So there's a lot of things to be able to tell, even though because that's a very fair point, juror number 4. if you don't know the person, how will you be able to tell these things? Let me see, I think I come up to it in a little bit. So you remember I said the hidden why? You know, why would a witness lie? Sometimes a motive for why a person would lie ends up coming up in a trial. Let's skip ahead. Police officers. I may go back to that in a second. Okay, actually, I'm gonna go back. So police officers, more than likely, police officers are not there when something happens. Okay, so who here has law enforcement in their background or is law enforcement themselves? Juror number 27, juror number 49, 71, and 62. You guys can put your cards down. I'm sorry, juror number 5 also. So police officers are there. They're in our community in order to protect and serve, but they're also there to do an investigation. But just like all people, they can make mistakes. What happens if what somebody is telling them is a lie? Does that make it, just because a police officer repeats it, does that make it true because a police officer is repeating the lie? Juror number, what's your number, sir? 57. So that doesn't make it true, right? So police officers can also make mistakes themselves, correct? What are problems with an officer that does a selective investigation? Juror number 57, can you think of a problem? If an officer just focuses and just believes that one story, what sort of things can happen with that investigation?
It'd be biased, it'd be one-sided.
Okay, juror number 58, can you think of anything?
They do have like a lot of authority over the case.
I'm sorry.
Sorry, if you could stand up.
It might be biased since they have much more of the authority over the case. It seems a lot more real on someone's side compared to someone who's not being backed up by police.
Okay, juror number 59, can you think of something if an officer just focus in on one person?
Just make assumptions.
Assumptions.
Right.
So they could myth stuff, right? And then juror number 60, would you agree with that? Okay, juror number 48, did you have something to say?
Yes, they might listen with their own opinion, enveloping, making assumptions, deciding if they care about the person involved or the person who supposedly did something.
Mm-hmm. Okay, so who here is okay with an officer making assumptions and having a biased investigation? Nobody? Okay, awesome. Who here wants an officer to do a thorough and complete investigation? Everybody. Thank you. Okay. So what happens is yes, there is a one witness rule. And yes, it is true. Most sexual assaults, most sexual abuse will just happen in a private room. It'll just happen when it's an accused person and an alleged victim. That is 100% true. I don't disagree with that. But if you're not there, you're not in that room, and you don't know the person, like juror number 4 was talking about, how is the state going to be able to prove to you beyond a reasonable doubt? That's ultimately one of the questions that I'm looking at that I want to talk to you guys about. So we take it outside of that room, okay? We start listening to the witness's story. What sort of details is this witness giving to the jury to be able to corroborate their story? And I believe Allie asked you, what sort of evidence would you expect in a sexual abuse case? Who here would like to see photographs? Raise your card. If they exist, would photographs help corroborate a story? Video. If videos exist, would that help corroborate a story? Okay. All right, so there are things that can be done in order to corroborate a story. Now, remember when I was talking about the cell phone, who lives by the cell phone? Okay. Would a cell phone, evidence of a cell phone and information in the cell phone, would that possibly corroborate a story?
Yes.
Okay. There's computers now, we have cell phones, we have tablets. So yes, sexual abuse may happen behind closed doors, but there's other things that we can look at to be able to pull together and see, did something happen? Does everybody agree with me on that? Okay. All right. So who remembers all the feelings of being a teenager? Raise your card. Yeah. If you, whether or not you're dealing with your own teenagers, you've dealt with your own teenagers, or you yourself remember what it was like when you're a teenager. I mean, is that anything anybody ever wants to go back and relive? Let's be fair. No. Because I don't know if you guys remember the movie The Breakfast Club. These are my favorite 4 quotes that come out as the themes of The Breakfast Club. I see me and I don't like what I see. I really don't. I hate it. I hate having to go along with everything my friends say. You do everything everyone tells you to do, and that is the problem. I could disappear forever and it wouldn't make any difference. Teenagers are kind of in this weird flux. They want to be seen. They want to get attention. They'll do anything to get attention. But on the other hand, they don't want anybody to look at them. They don't want anybody to pay attention to them. So it's kind of like this horrible, weird dynamic. And so, unfortunately, things do end up coming out. Allegations can end up coming out. There are times that people can end up making a statement, whether or not it's true or false, to be able to get attention. What I'm asking for the jury, for the members that do get selected on the panel, is that you just listen to all of the evidence. I don't want to come to the end of the trial and a jury panel looked at my client and said, yeah, he looks like a person who would abuse a child. So even though the state of Texas didn't prove it, because it was a very tough emotional case, I'm going to find this person guilty. Can everybody agree with me that they will hold the state of Texas to the high burden of proof of beyond a reasonable doubt? Does everybody? Okay. Does anybody know what I'm talking about when I say the snowball effect? Oh, yeah. Okay, what's the snowball effect? I know it just disappeared on you, but juror number 48, what's the snowball effect?
When one person says something, another person believes it, another person believes that person, another person believes maybe the first person or the second person, and it just keeps rolling and getting bigger and bigger.
And bigger and bigger and bigger. And I'm gonna go back, see if I can get it to come back again. See if you guys catch what happens. Sorry, there's a little bit of delay. But if you caught it, at the end, everything can just fall apart. That's what we're here to be able to analyze, is whether or not this is a true allegation or whether or not it's just something that kind of keeps rolling and rolling and rolling, and see what happens, okay? How do I prove a negative? Any of my data analysts know? Anybody know 42? How do I prove a negative? You can't. You can't. And that's why the Constitution of the United States says my client does not have to prove anything to a jury, because you cannot prove a negative. I can try to show you things. So the state is going to make an argument. They're going to say that my client committed a crime. I'm going to try to poke holes in their story, but I cannot come to you and prove a negative, because if something did not happen, I cannot prove that to you. But I love this movie, and it says, that's a negative, ghostwriter. The pattern is full. Okay, who would believe a child just because it's a child? I'm going to start over here. Anybody in the jury box that would believe a child just because they're a child? Okay, front row over here, juror number 18. Second row, third row, fourth row, juror number 40 and 42. Anybody in the last 2 rows? Okay, front row over here. Second row, juror number 64. Third row, fourth row, and fifth row. Okay. Similar question. Who would believe a victim just because they're saying they're a victim? Anybody in the jury box? Okay. First row, second row, third row, fourth row is juror number 40 again. Fifth row, sixth. Anybody on the left, right side? Can I cross-examine a recording or a witness statement or medical report? No. No. I mean, it's just impossible. And then the judge talked about it. Is there anybody who's gonna say, nope, with this type of case, I need to hear Isaiah's story? Anybody? I'm sorry, jury number 38 and juror number 46. Okay, juror number 16, juror number 18, juror number 30. Okay, anybody on the right-hand side? Juror number 58. Okay. Now, we did talk about guilt innocence, judge covered it, but I do think that there was one point that I want to go and make sure that everybody understands. When we're talking about that range of punishment, if you get to this stage, this is the time to consider what happened during the alleged offense, but also what is going on with Isaiah. What is his background? What is his current situation? And what is his future? That's all the things that you're going to be considering when you're looking at punishing him. Now, given these charges, probation may be a option if the jury sentences Isaiah to 10 years or less. Does everybody understand what I mean by probation? Okay. So is there anybody who is going to say right now, knowing that this case involves sexual abuse of a child, I will not consider placing a person back in the community on probation? That is the question I'm asking.
Just 1 second, let me pause.
Okay.
All right, ladies and gentlemen, you don't know any of the facts of this case, the alleged facts. Does everybody understand?
Yes.
All right. So when you talk about punishment, the question is whether or not you can consider the full range of punishment. For example, in some cases as this, a person may be eligible for probation. So the question is not whether you're going to give probation to somebody or give them 2 years or 3 years or 20 years. What it means is that you know that potentially somebody could have probation. Can you think of a case, a fact scenario where you would give somebody probation? Can you think of a fact scenario where you would give somebody 2, 3, 4, 5, 6, all the way up to 20 years? Does everybody understand?
Yes.
All right, you may continue.
Thank you. So my question to you is, if the judge is correct, you're not, by answering this question, you're not saying I am going to give Isaiah probation. What I'm asking you is, will you consider giving him probation? So anybody that's sitting in this jury box, can you say now, I will not consider giving Isaiah probation? Anybody in the jury box? Do you have a question or?
Question.
Okay.
Is this, when you present that, is that, has the jury or the court said, yeah, we have found him guilty?
Yes, this is
Okay.
only after he has been convicted.
And ladies and gentlemen, it's not whether you can give him probation, because remember, this is all hypothetical, all right?
Correct.
Right. If you can give any person charged with the offense of sexually abusing a child, could you think of any example and give that person probation? Willing to consider it. Again, you're not giving it. You're willing to consider probation. Okay? You will not?
No.
Okay, juror number 5. Anybody else that agrees in the jury box with juror number 5? Juror number 14, juror number 1, juror number 8, juror number 12. Okay, in this front row, juror number 16, juror number 18, juror number 19, 21. Next row, 27, 28. Third row, fourth row, juror number 42. Fifth row is jurors number 46, 47, 48, 49, 50. Okay, last row, 51, 56. Front row right here is 58, 59, 60. Next row, 64, 63, 62.
All right, 5 minutes.
Anybody beyond? Okay. So I want to spend a little time talking about beyond a reasonable doubt. Okay, I'm gonna give you guys a little scenario. It may sound weird, but just go with me, okay? Who here has children? Multiple children? Raise your hand. Juror number 35, I have not heard from you. So juror number 35, how many children do you have?
3,
3 children. What are their ages?
16, 12, and 2.
So perfect. I love it. Okay. So your 2-year-old, well, add on a little bit. Okay. So let's say your 5-year-old. One of your 2 children were 5 years old. Okay. So they're helping you make cookies in the kitchen. Okay. You guys are making chocolate chip cookies, waiting to have, it's after school, having chocolate chip cookies for dessert. And the whole time your little 5-year-old is saying, Dad, I want a cookie. And what are you going to say? No, you got to wait for after dinner. This is for dessert. We're not having cookies right now. So you finish making the cookies, you take them out of the oven, they're nice and warm, you put them on the cooling racks and they're sitting there cooling, and ding dong, your neighbor comes and rings the doorbell. Okay, so you step out of the kitchen and you go to the front door, you talk with your neighbor for a few minutes, and you come back and you analyze the kitchen. There's 2 cookies missing. There's a little bit of crumbs, there's a little bit of chocolate on your kid's mouth. And what do you say to your kid?
Do that.
Did you eat the cookie? And what does your child say? No, I didn't eat the cookie. You told me not to eat the cookie, so I did not eat the cookie. Who here believes that the child did not eat the cookie? I mean, come on. We all know the child ate the cookie. So then you ask them, well, if you didn't eat the cookie, who ate the cookie? Okay. So, I mean, they're going to come up with a million reasons. What happens when he says, you can go ahead and take a break. What happens when he says Cookie Monster ate the cookie?
That's right.
Juror number 29. Is that doubt? I mean, well, hold on. I mean, is it doubt? Aliens could have shown up from outer space. They could have taken the cookie. Anybody could have taken the cookie. Okay? We all know Cookie Monster loves cookies. So of course he came off of Sesame Street when he came and stole the cookie.
My dog ate the cookie.
Right. So the question becomes, what is reasonable? Because like the state and the judge said, it's not all possible doubt. It is what is a reasonable doubt. Okay. So what if your son says the dog ate the cookie? Okay, that's possible doubt. What if they point to one of the siblings and say they were upstairs, they came downstairs, they grabbed a cookie, they didn't hear the law that we're not allowed to have the cookies, so they took the cookie back up to the room and they ate the cookies. Yes, ma'am. Sorry. So that's reasonable, okay? But what happens when you're watching TV later that night and there's a news story about how a man dressed up as Cookie Monster is breaking into houses and stealing cookies? So my question becomes, can an unreasonable doubt become reasonable?
Yes.
Okay. Yes, juror number 19, you agree with me?
Yes, ma'am.
Okay, everybody in the box, do you guys agree with me?
Yes.
An unreasonable doubt can become reasonable. Left side, you guys understand?
Yes.
Right side, everybody understands. Because that's what we're asking for, is did the state prove their case beyond a reasonable doubt? We want to make sure you're going to listen to all of the evidence that is presented. And evidence is not my questions, but my questions become their responses. Listen to what I've picked apart and say, after it's been picked apart and gone through and everybody dug through it, did the state go beyond a reasonable doubt? Here, you're looking at it, it's clear. They went yards ahead. But when it comes down to a snapshot, that's where we don't know. The state bears the burden to prove it beyond a reasonable doubt. And if you're still sitting back there in the jury room and you're saying, maybe it happened this way, it could have happened, it possibly happened, you just still don't know, that's where you're ultimately saying not guilty. Okay? Does everybody promise to follow the law? Okay, thank you.
All right, ladies and gentlemen, I'm gonna have you all step outside in the hallway. Make sure that you are back. If you decide to do a restroom break or something, make sure you are back no later than 12:50. That's 12:50. Please leave the cards behind. Take your personal items with you. And the people who are in the box, you're going to need to take your personal items with you. And we're going to call you back in at 12:50. Everyone, please rise for the jurors.
Leave the numbers behind, I'll call you.
Mhm.